ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಮ್ ಐ ಹಿಯರಿಂಗ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಹತ್ತೊಂಬತ್ತು. ಇನ್ನು ಆಡಿಯೋ ಆಫ್ ಮಾಡಿಲ್ಲ ಕಾಣುತ್ತೆ. ಹೋಗ್ತಾ ಇಲ್ವಲ್ಲ ಇದು? ಅವರು ಮ್ಯೂಟ್ ಮಾಡಿದಾರ? ಶುರು ಆಯ್ತಾ? ಇಲ್ಲ ಅವ್ರು ಬಂದಿಲ್ವಾ? ಹೆಚ್ಚು ಬಂದಿಲ್ವಾ?
ಹೇಳಿ.
ಅದು 102 ಇದೆ. 102 ಇದೆ.
ಅದೇ ಸರ್, ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಅಂದ್ರೆ 1:15ಗೆ ಬಂದು ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಕೇಳಿ 2:15ಗೆ ನಮ್ಗೆ ಹಿಯರಿಂಗ್ ಬೇಕು, ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮೆನ್ಷನ್ ಮಾಡಕ್ ಹೇಳಿ. ಆಲ್ ಮೆನ್ಷನಿಂಗ್ ಅಟ್ 1:30. ಇವತ್ತು ಹೇಳಿದ್ದಾರೆ 1:15ಗೆ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಮೆಮೋಸ್ ಎಲ್ಲ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಏನ್ ಫ್ರೆಶ್ ಇದ್ರೆ ಫ್ರೆಶ್ ಮೆಮೋಸ್ಗೆಲ್ಲ ಇಲ್ಲ. ಫ್ರೆಶ್ ಮೆಮೋಸ್ ಟು ದಿ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಆಫ್ ದಿ ಬ್ರಾಂಚ್. ಅಲ್ಲಿ ಹೇಳಿ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳಿದ್ದಾರೆ ಇದು ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿ. ಅದು ಹಂಗೂ ಕಂಪ್ಲೈ ಮಾಡಿ ಅವ್ರು ಏನೋ ಮಾಡ್ಲಿಲ್ಲ, ನಿಮ್ಗೆ ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ, ನಾವು ಡೈರೆಕ್ಷನ್ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ.
ಮೇಡಮ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮೂವ್ ಮಾಡೋದು 1:15ಗೆ ನಮ್ಮ. ಹಲೋ,
ನಿಮ್ಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕು ಅಂತಂದ್ರೆ ನೋಡಿ ಮೂವ್ ಮಾಡಿ ಕೇಳಿ ನೋಡಿ ಸರ್. ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
ಈಗಲೇ ಮಾಡ್ತೀನಿ. ಹಾ, ಅದಾಪ್ ಮಾಡ್ತೀನಿ. ಇದು ಮಾಡ್ತೀನಿ
ಮೇಡಮ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮೆಮೋಸ್
ಎಲ್ಲ ಸ್ಕೂಟ್ನಿ ಸರ್.
ಓಕೆ.
ಏನ್ ಹೇಳಿ ಸರ್? ಫ್ರೆಶ್ ಆದ್ರೆ ಅಲ್ಲಿ ಫ್ರೆಶ್ ಆದ್ರೆ ಕನ್ಸರ್ನ್ ಬ್ರಾಂಚ್ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ಗೆ ಅಲ್ಲಿ ಹೋಗಿ ಸರ್ ಒಂದ್ ಕೆಲಸ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟು ನೀವೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. ಲಿಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರೆ ಹೇಳಿ, ನಾನೇ ಬೇಕು ಅಂತ ಹೇಳಿ. ಅವ್ರು ಲಿಸ್ಟ್ ಮಾಡಲ್ಲ ಅಂತ ಬಂದು 1:15ಗೆ ಬನ್ನಿ ಲಂಚ್ ಅವರಲ್ಲಿ ಸರ್. ಆಲ್ ಫ್ರೆಶ್ ಮೆಮೋಸ್ ದೇರ್ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ಗೆ ಸರ್. ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿನೂ ಅಷ್ಟೇಪ್ಪ. ಹೇಳಿ ಸರ್, ನೀವು ಸೆಕ್ಷನ್ ಆಫೀಸರ್ಗೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳಿದ್ರು ಕಳಿಸಿಲ್ಲ, ನಾಳೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಬೇಕು ಅಂತ ಹೇಳಿ. ಅವರು ಲಿಸ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ಅಂದ್ರೆ 1:30 ಲಂಚ್ ಬರುತ್ತೆ.
Thank
List number 1 for orders matter.
In the meantime, my lord, in the meantime, may I'm on my VC, I'm not keeping well. I'm a senior citizen. May I make one submission, my lord?
Yes.
I'm sorry to trouble your lordship. Serial number 8 in list number 2, may matter may be taken up in the next week, my lord. I'm not keeping well.
Yes, next week. Yes.
Interim order may kindly be extended, my lord.
Yes.
Serial number 8, list number 2, interim order may kindly be extended.
It is done.
Obliged. Obliged.
This is the court's copy.
My lord, list number 2, serial number 23, seeking time. Serial sort of.
It will not reach. Why are you making all this effort? List 1 I will not be completing. Where is the question of list 2? Yes.
Yesterday, this.
Yes.
See, the court permits, because I understand that the matter, just I'll assist the court only in with reference to, notice there are two extreme views which has been taken by the courts.
My lords,
Wherever
kindly
the
pass
suit
over-
for specific performance,
Kindly pass over, my lords. Have it.
I'll complete my arguments, he can, if he can. Notice, wherever the suit for specific performance had been filed and decreed, then the matter was at the stage of appeal or went to the Supreme Court. Then the courts have taken a view that in view of the rights having crystallized by means of a decree, though it is pending a subject matter of an appeal, they will be entitled for compensation. This is one extreme view. The other extreme view is where this agreement is in existence, but it is not taken forward in the nature of a suit for specific performance. It's not filed, not decreed. There, the courts have consistently taken a view that an agreement holder does not have a right to claim compensation because Section 30 specifically bars. Because an interest in the property by virtue of Section 54 is not created only by means of an agreement of sale. These are the two extreme views. In between, what should happen? Now, a person has filed a suit for specific performance. During the pendency of the proceedings, the lands comes to be acquired. So, two things happens in this. Now, specific performance cannot be pursued because the land is not available. The first thing which is required to be done is the plaint in the form of a suit for specific performance cannot be pursued at all. There, the Supreme Court took the view that wherever such thing happens, that without the fault of the plaintiff, the suit for specific performance cannot be pursued. He is given the liberty to amend the plaint in terms of Section 21. That is to claim for damages. Then the next question is Section 73 and 74 of the Contract Act will have to regulate as to how damages is to be awarded. This is the position of law. There are several judgments which I am just placing for lordship's consideration. Now, that is essentially where the law lays. Now, the plaint as it stands before the trial court is only a suit for specific performance. The Supreme Court, wherever it directed that.
That's what I asked him to convince the court.
Yes.
So how do you stand in a better position than your? So
Yes.
that's what the matter is adjourned to today.
Kindly have
That's
it.
essentially where it lies, my lords. Because it is more like the nature of directing a redeposit is in the nature of a final relief. That is what a division bench of this honorable court has taken a view. To direct them to do it is, but one, because of course, subject to what my learned friend would say, the step 1, step 2, step 3 is required. But the moment the lands are acquired, step 1 is that they have to mandatorily amend the plaint saying that now that it is not capable of being performed for non-fault of the plaintiff, first they will have to amend the plaint to bring it in conformity with the Section 21. Unless that is done, the question of saying that no, you should deposit the compensation doesn't arise. Now, an extreme situation, my lord, says that if he wants to make a reference, he wants to claim for a reference under Section 30. Now, this honorable court has already taken a view that Section 30 is a complete code by itself. Now, if Section 30 is a complete code, he was entitled to make a claim because a person who wants to claim compensation is required to go under Section 30. That's seek for a reference under Section 30. But in order to do that, There are at least 4 judgments of this honorable court and 1 division bench judgment which says that he has no right of seeking a reference. So now the only question is, unless he comes under section 21, the question of making an application of the kind would not arise. The suit as it stands, Milords, is any interlocutory application, it is an interlocutory application.
Will not have a right to go, right to seek reference and other
Reference.
things. But the thing is, when there is an order of, we have to look it from that point of view. When there is an order of, no, an injunction
Not to alienate. Yes.
it is alienated.
I would put it this way, my lords. The plaintiff has to stand or sink on the basis of his own merits and not on the weakness of the defendants. Let us assume, my lord, that lords, what the Supreme Court says is, Sukhbir Singh's case, which my learned friend has referred to, it says, is given us the list of documents. That's the first of the judgment. 96 Supreme Court, that was the first of the judgment, which said that when an order of injunction is of the kind is granted, then it is not only an injunction against the party, but is an injunction against the court to recognize such a transaction. Notice, it doesn't invalidate the transaction. There is no invalidation of the transaction, but for the purposes of this litigation, the transaction will have to be ignored. So because Jehal Tanti's case and even Vidurimpeg's case, when the matter came before the Supreme Court, the question was whether as a matter of right, he was required to be impleaded. There, the subsequent purchasers in violation of an interim order wanted to implead themselves. Supreme Court said that since this sale transaction cannot be recognized in violation of an injunction order, we cannot permit you to implead. Order 22 Rule 10, Order 1 Rule 10 essentially came up for consideration before the Supreme Court. So that is on that context. Now he has himself impleaded us. We are already a party to the proceedings. Now the question is only this. Even assuming that my sale deed is to be ignored, factum is as to whether he is entitled to seek for this relief. Now the plaint as it stands, my lords, is only a suit for specific performance. If your lords were to see the first of the judgments, which is that is Jagdish Singh. This is the, I would refer to GH Grant's case, page 147 in the compilation.
Filed by him.
Please, my lords, now I have just filed it, which commences at page 147. Sorry, go on.
Yes.
Lords, GH Grant's case, which is referred to, my lords, by a coordinate bench, essentially referred to what is meant by a person interested for the purpose of seeking reference under section 30 and 31. You lords, in that, para 19.
So it is essentially arising under the Land Acquisition Act.
Lords, it is under the Land Acquisition Act.
Who had an agreement in his favor.
Yes, lords, this is, I would say that this is not considering the rights of an agreement holder at all. GH Grant's case never considers, but lays down the contours of section 18 and section 30 as distinct from each other.
Yes.
So right to claim under section 18 is completely distinct from seeking for a reference under section 30. There the word person interested has been gone into. To say that any person who wants to have an interest in the property is bound to make a reference, make a request for reference under section 30. So that is GH Grant's case. Now the law has developed beyond that, my lords. This is GH Grant's case. Now your lords may kindly come to page number 1. Jagdish Singh.
Yes.
Lords, para 15 extracts section 21.
Yes.
Lords, section 21(2), I'll just take your lordships to section para 15. Section 21 of the Specific Relief Act, corresponding section of 19 of 1877, enables the plaintiff in a suit for specific performance also to claim compensation for its breach either in addition to or in substitution of such performance. 245 of subsection 245 of section 21 is material. If any such suit, the court decides that specific performance ought not to be granted, but there is a contract between the parties which has been broken by the defendant, the plaintiff is entitled to compensation for that breach. It shall award him such compensation accordingly. In determining the compensation amount awarded under this section, court shall be guided by the principles under section 73. No compensation shall be awarded under this section unless the plaintiff has claimed such compensation in his plaint. Just mark, lords may kindly see, this is the mandate. Provided that where the plaintiff has not claimed any such compensation in the plaint, court shall at any stage of the proceedings allow him to amend the plaint on such terms as may be just for including a claim for such compensation. The circumstance that the contract has become incapable of specific performance does not preclude the court from exercising jurisdiction conferred by this section. So now this is principally on the first principles, Milords, that unless there is a pleading in the plaint that he is entitled for compensation in lieu of specific performance, because now as things stands, it cannot be specifically enforced.
So I don't want to interject because I don't want to reread this judgment. Let that be continued.
I will continue reading it. I am just explaining on the first principles, Milords.
First principles are very neatly elucidated, so I'll have to rely on the same thing. My learned friend can read it in full.
I'll,
have to read it.
This is the first principles. Next, section para 16. So far as the proviso to subsection 5 is concerned, two positions must be kept clearly distinguished. If the amendment relates to relief of compensation in lieu of or in addition to specific performance, where the plaintiff has not abandoned his relief of specific performance, the court will allow the amendment at any stage of the proceedings. That is a claim for compensation falling under section 21 of the Specific Relief Act 1963, and the amendment is one under the proviso of subsection 5. But different and less liberal standards apply if what is sought by amendment is the conversion of a suit for specific performance into one of damages for breach of contract, in which case section 73 of the act is invoked. This amendment is under the discipline of orders rule 17 of order 6. The fact that subsection 4 in turn invokes section 73 of the Contract Act for the principles of quantification assessment of compensation does not obliterate this distinction. I'll just pause here. Now, suit for specific performance in its present form can never be pursued. I'll just read the subsequent paragraphs. The distinction which is drawn by the Supreme Court in Jagdish Singh's case is, if you are seeking for damages under section 21 in addition to the specific performance, then there is no necessity for you to go to order 6 rule 17. You can make an amendment application which under the scheme of the statute, that is 21(5), the amendment is required to be allowed. But the distinction comes when there is the second part. Less liberal standards, that's consciously so used, will apply if what is sought by the amendment is conversion of the suit for, this is essentially where the what is that which is required to be done. Then comes order 6 rule 17. Whether this should be permitted or not is within the realm of order 6 rule 17. This is the distinction which was drawn. Number one. Now your lords may kindly come to paragraph number 19. This was, my lords, the earlier view. In Muhammad Abdul Jabbar Lalmia, lords, there's a historical background is what this Supreme Court says in para 18 and then goes on to refer to two judgments, my lords. Muhammad Abdul Jabbar Lalmia's specific performance on agreement of sale dated 16 January 1934 sought by the institution of the suit of January 1937. During the pendency of the suit, 1937 provincial government started acquisition proceedings respecting the subject matter of the suit, and the same was acquired. The High Court upheld the dismissal of the suit for specific performance and referred an amendment for award of damages. On the obvious impermissibility of specific performance, the Nagpur High Court said, we accordingly conclude since specific performance now is impossible and we cannot decree it for equity, like nature does nothing in vain. We cannot hold the plaintiff appellants entitled to compensation money into which the property was converted because they had no right nor interest in the property. Refusing the amendment for relief of payment of money, the High Court held we would not allow the amendment also because on the facts we found by the trial court, with which we see no reason whatever to differ, we would have refused specific performance, and the claim for damages on this account would also have been negated because the damages would have been awarded only if specific performance could rightly be claimed. The appeal therefore fails and dismissed. Support for this conclusion was sought from the oft quoted but perhaps a little misunderstood judgment in Ardashir's case. The passage in Sasson's case relied upon by the Nagpur High Court is this. In a series of decisions, it was consistently held that just as its power to give damages additional was to be exercised in a suit in which court had granted specific performance, so the power to give damages as an alternative to specific performance did not extend to a case in which the plaintiff had debarred himself from claiming that form of relief, nor to a case in which that relief had become impossible. These two contingencies. The case of Sasson fell within the first category of these cases described above under the alternative relief of damages. This case falls within the second part of the relief where the specific performance has become impossible. This is essentially, my lords, where it says. Can I now skip para 22 and go to para 24, my lords? when the plaintiff by his option has made a specific performance impossible, the section 21 does not entitle him to seek damages. That position is common to both section 21 of the Lord Keynes Act of 1858 and section 21 of the Specifically Act. But in Indian law, where the contract for no fault of the plaintiff becomes impossible of performance, section 21 enables award of compensation in lieu of and in substitution of specific performance. We therefore hold that second contention of Manoj is not sustainable, so on and so forth. But then what the court does is very important, Milords. Under section 142, Article 142, the last para 26, learned counsel were not specific on the point whether respondent had actually asked for compensation in lieu of specific performance. We assume that it is not specifically sought. In order that formality in this behalf is completed, we permit the amendment here and now so that the complete justice is done. Of course, this is a case where the suit had already been decreed. If your lordships were to see in the beginning paragraphs, I'll just point out to paragraph number 6, 5 and 6. So this was a case where the High Court had already decreed the suit for specific performance in a second appeal. Even there, the Supreme Court said that it is necessary that the amendment is to be done in terms of section 21. Of course, Article 141 of the Constitution enables the Supreme Court to pass appropriate orders, which has been done. Now, the second judgment, Milords, is at page number 1313. Milords, it is by a coordinate bench,
Yes.
which is more or less similar to the facts on hand. This is a case where during the pendency of the proceedings, can I just persuade your lords, may kindly have a look at paragraph number 10 at page 19. The Supreme Court's judgment in Jagdish Singh is referred to, and paragraph number 11.
Yes. Yes.
On the basis of the dictum in the aforesaid decision, learned counsel for the respondent persuaded me to take the view that the Supreme Court has taken the view that when the subject matter of the suit for specific performance is acquired under the Land Acquisition Act, during the pendency of the proceedings, the agreement holder is entitled to compensation that is awarded under the Land Acquisition Act. I am afraid that is not the dictum laid in the aforesaid decision. The Supreme Court proceeds on the basis that when the land is acquired during the pendency of the suit for specific performance, the agreement becomes incapable of performance. But their lordships have considered the position of law under the English law and the Indian law as to what is the relief that can be granted to the plaintiff in such circumstances. Their lordships held that in spite of the land being acquired, the plaintiff is entitled to compensation as provided under section 21 of the Specifically Act for the contract become unenforceable not due to fault of the plaintiff. As stated earlier, the lordships held that unlike the English law, under Indian law, even in such circumstances, section 21 of the Specifically Act enables awarding of compensation in lieu of and in substitution of specific performance. The mere fact that lordship took account of the compensation due under the land acquisition compensation as a measure of damages for fixing compensation does not mean that plaintiff in such a suit is entitled to all the benefits which accrued under the land acquisition proceedings. The agreement holder cannot be substituted in place of the owner. The agreement holder, when substituted in place of the agreement holder, when his contract becomes unenforceable, is only entitled for compensation as provided under section 21 of the Specifically Act, which the court is entitled to determine taking into account the facts and circumstances of the case. No doubt, in considering the measure of damages, the compensation awarded under the Land Acquisition Act may be a relevant factor. The aforesaid decision has not laid down the law that plaintiff in such suit is to be substituted in place of the owner in regard to the compensation payable under the Land Acquisition Act. In that view of the matter, the aforesaid decision cannot help the respondent plaintiff is considering that he is entitled for all the benefits arising in the land acquisition proceedings. Then para 13. It is made clear that if the plaintiff is entitled to specific performance of the contract and if the land is acquired during the pendency of the proceedings, he may be entitled to claim compensation under section 21 of the Specifically Act. The proviso to subsection 5 of section 21 provides that where the plaintiff has not claimed any such compensation in the plaint, the court shall at any stage of the proceedings allow him to amend the plaint on such terms as may be just to include such claim for compensation. The plaintiff may be entitled to get such plaint amended in accordance with section 21 of the Specifically Act if he so chooses to do, but certainly a plaint cannot be amended by claiming the entire benefits arising out of the land acquisition proceedings Accordingly, I make it clear that the decision in this revision will not stand in the way of claiming amendment. My lords, here again, my lords, the distinction is again the same thing. That which I read to your lords, my lords, in Jagdish Singh's case,
Yes.
that if he is seeking for an amendment, in addition to substituted specific performance, then section 21. Otherwise, he will have to seek for under Order 6, Rule 70. The second judgment, my lords, is page number 22, my lords, of the Division Bench of this Honorable Court.
Again, Jagdish Singh was considered.
Yes.
Next judgment is Justice
My
Ravi.
lords, the Division Bench of this Honorable Court, if your lords were to take, my lords, the page number 38.
Yes, I've seen that.
Yes, a view in Jagdish Singh's case, but it enlarges a little bit, amplifies a little bit on the nature and manner in which it should be done. Lords, page 39, this third line. In that case, after having placed reliance on the above Supreme Court decision, this court laid it down that the plaintiffs may be entitled to get plaint amended and seek for compensation to be determined under section 21 of the specific Leaf Act, and therefore it is permissible for the appellant to seek amendment. No doubt plaintiff may have to pay the court fees, but he is entitled to seek decree of damages or compensation for breach of contract which has become impossible of performance for no act or fault of the present appellant. Essentially, my lords, I am just driving home the point that unless the plaintiff is amended under section 21 and he makes out a case that this is how I am entitled for computation of the damages, question of he asking me to get a redepositing of the compensation which has been withdrawn by me does not arise. Then, my lords, of course, page 41, I think my learned friend has already read this judgment. I'll not trouble you lords with that. And then page number 130, your lords may kindly see, my lords. That is Muhammad Zahir's case. It's a very extensively considered judgment commencing from page 84. If I can just take your lordships directly to page 130, which is the conclusion.
Page number?
But of course, my lords, I should guard myself by saying that this was a view taken in the second extreme, which I referred to, that where they wanted to seek for a reference under section 30. Now,
Number 134 is relevant.
page 130.
4 is relevant.
My lords, page 130, my lords. Sorry, because this judgment commences at page 84, very extensively considered judgment. So, it considers, my lords, the rights of an agreement holder, not merely in relation to the compensation, but what it means to hold an agreement, qua the property. That's essentially the principle which has been laid, which when it considered specifically with reference to the compensation, because the law after Jagdish Singh's case has now, my lords, evolved itself in the context of Suraj Lamb's case. Suraj Lamb's case has taken the view that you cannot take a cut short, or you cannot have a shortcut to the conveyance by means of a registered instrument. You have to claim a right only under a registered instrument, which is by means of a sale deed. Anything else, including an agreement of sale, which is covered with power of attorney, etc.
This judgment is also arising out of the land acquisition procedure.
It's under the Land Acquisition Act only. Then, my lords, that is, I think, lords, and the other judgment, my lords, which I want to refer to is page 188. At page number Lords, this is on another perspective, Lords. Can I just persuade you, Lords? This is essentially the sum and substance of my submission. I'll also take your Lordships to that order. I think the order has been read. Lords, the order only says that since there is a sale in violation of the order, they are required to deposit. It doesn't say why the plaintiff is entitled to seek for that relief. That is the order imputed. Lords, just before that, can I just add one?
This judgment, what it says, 180.
Lords, page number para 20, if your Lordships were to kindly have a look at it, Lords. It's only on the principle that defendant's weakness is not something which would determine granting of main or the interim relief. That's essentially the principle, my lords.
Para 20.
Para 20 and 21.
Yes.
The plaintiff to stand on his own legs and not on the weakness of the defendant's case. That's essentially, they refer to, my lords, the other judgment of a coordinate bench, which says that it should be based purely on the, that's essentially. Now, one thing which I wanted to, lords, 151, once they invoke, lords, this is an equitable jurisdiction. Lords, ends of justice, if it is required, equity requires it, then such an order would be passed. Notice what they would do at the first instance is they would come to this honorable court by filing a writ petition. No interim order is granted. Then thereafterwards they file this application under section 151. Then 151 application is allowed. The trial court says merely because there is a matter pending before the High Court will not preclude me from passing appropriate orders, and he passes the orders. That is the second reasoning which has been given. Then he comes back before this honorable court and says that since there is already an order which is passed by the trial court, I don't want to pursue this. It's the one of the main ingredients for the purpose of invoking section 151, which is more equitable in nature. It is to meet the ends of justice. It's ex debito justicia judgment. When such is an application made, the court should go by conduct. There is no question of duplicating the proceedings and keeping it parallelly pending, taking a chance in both the litigations. If he opts to come before this honorable court, unless he abandons or he claims liberty in this case to go to the other case, he cannot parallelly pursue the remedies. It rather becomes a kind of bench hunting, or forum shopping. Once he has chosen the forum, of this honorable court, he parallelly goes to the civil court and says that, no, I want the same relief before this court. Of course, the trial court grants us a different matter, which I'll deal with. But the conduct on the part of the plaintiff is, he is going on a forum shopping. Until and unless he is pursuing the remedy before this honorable court, it did not permit him to go before the civil court and seek this relief. This is the second contention. And if your lordships were to see, there is a second set of citations given. Not the common thread which is running in all these cases. Lords, I have just marked the paragraph numbers also, my lord, so that I'll not be.
What is the ratio laid down?
Lords, the ratio is the interim relief cannot traverse beyond the main relief, because an interim relief should always be granted in lieu of the main relief as it stands. Now, if as it stands, if the main relief is for specific performance, and if it doesn't take steps under section 21, an interim relief under 151 could not have traversed beyond the main relief which stood as on the date when the application was considered in the plaint. That's essentially the principle.
Was the property acquired?
Pardon, Lords?
When was the property acquired?
Lords, property is acquired after the suit for specific performance is filed. Lords, can I just pursue your Lords? May kindly have a look at the plaint, my lords. There is one thing which is very interesting in the plaint. Paragraph number 5 of the plaint. Lords, commencing from page number 47. Sorry, this is the writ petition. Yes. The plaint is interim prayer. I'll just point out. So, please, sir. Page number 33, my lords, is the plaint. Amended plaint is page 33. And paragraph number 5.
Yes.
Lords, while executing the agreement, defendants have informed the plaintiff by stating that the balance of so-and-so khata has not been entered. After obtaining khata, they would get the land also surveyed, hissa podi durast after so-and-so. After having said this, paragraph number 8. On 23/5/22, so-and-so sent a evasive reply stating that none of them have executed the agreement of sale in favor of the plaintiff to sell, nor received any money from him, and they are not under any obligation to execute the sale. It holds. Essentially, the plaint averments itself brings home the fact that it is a disputed transaction. Notice, wherever it is a transaction which is disputed, is in the manner in which it has been pleaded. It is not that straight away they will be entitled to get the relief. Now, the order impugned, my lords, is an ipse dixit order. Where have you produced the agreement? Have you produced here? But So, it's okay. Lords, just kindly have a look at the order impugned, Lords, in the writ petition papers. The page number 30, point number 1.
Yes.
Lords, paragraph number 6 essentially is only on the contentions. Paragraph number 7 is the only reasoning given. On perusal of the entire records, it prima facie goes to show that when a temporary injunction is operating against defendants 1 to 15 from alienating the property until further orders, they alienate the property in favor of 16 defendant and registered salient and violated the orders of the court. Thereafter, defendant number 16 has disbursed the compensation in favor of defendant number 16, which is not denied by him in his written objections. He has only contended that since writ petition is pending, the plaintiff cannot seek the same relief in this court, and the plaintiff has not yet laid his evidence, and defendants have denied the agreement. The matter is pending before this court for specific performance of contract, and during the pendency of the suit have alienated property in favor of so and so, has acquired the suit property and awarded compensation. Plaintiff has got jurisdiction to seek appropriate relief merely because writ petition is pending. But what is the reason for directing the redepositing, Lords, is something which should be forthcoming. That's the reason why I said 21, 73 and 74, Lords, is what the courts have consistently said requires a consideration at the time when such an order is to be passed, because the plaint itself is not there in terms of section 21. So therefore, Lords, it's an ipse dixit order. But if they still want to do it, this exercise, it can be done. But this order cannot be sustained, Lords, is my respectful submission. So grateful for the hearing, Lords.
My lords, kindly pass over, my lords. Have it at 2:30.
Whenever my time permits, I'll hear it.
Yeah.
Lords,
Whenever my time permits, I'll hear it. If not, I'll not take it up today.
The interim order granted yesterday in a
Yes, I'll, if I don't hear it, call it in the afternoon, it will be extended.
Lords, so grateful, Lords.
Sir,
Yes.
number 2, Vijay Kumar.
Appearing for petitioner. The petitioner is the plaintiff in the trial court filed a suit for specific performance of contract. Lord, when the matter set down for cross-examination of PW1, he filed 3 applications, my lord. One is to recall and reopen and permit me, the plaintiff, to produce the Leveni sketch. My lord, Leveni sketch is a larger extent of land. My lord, the plaintiff purchase agreement.
What is IA?
My lord,
What is IA?
IA is section 58 and 60 of Bharatiya Nyaya Samiti Act, my lord, Evidence Act, to lead secondary evidence, since the original is.
Come to the order.
Lord, come. The order, my lord, is relevant page, portion, my lord, reasoning part, page 24, last paragraph. Page 24, last paragraph, my lord. It is further, it is settled position of law for the secondary evidence to be admitted. The foundational evidence has to be given, being the reasons as to why original evidence has not been furnished. In the present application, plaintiff claims that it was informed by the revenue authorities that Leveni sketch concerning to the suit property is no longer available with them to give a certified copy of the same. However, plaintiff has not furnished any material, namely endorsement or the such kind of issued by revenue authorities stating that said Leveni sketch is not available with the revenue authorities.
Yes.
Lord, for that, I have produced the photocopy. Page number 65 is the document. Lord, I purchased only portion of land to identification.
The court said.
Court said that I have not laid down a foundation. My lord, I have laid down a foundation. Why primary evidence?
That's true that
Yes.
it is, the original is not available.
My lord, certified copy they have issued authorities. It is a sketch in the larger extent of a survey sketch.
So your case is that the original is not available with them.
Yes, my lord.
There is no endorsement is placed before the court.
They will not give, because Leveni sketch is a 6 months period.
Anything in the, under the right.
They will not issue, my lord, because I have only earlier they issued certified copy. It was misplaced. I have only a photocopy. Photocopy I have placed before the court, and page 65 permit me to lead secondary evidence. Court held that you have to get the endorsement or any other document. My lord, my foundation is original is they have issued a certified copy in 2016, 2006. It was misplaced in my hand. Only I have a photocopy. The original they will not again issue. The sketch period is only limited 6 months period. That is the information given by authorities. For that, court said, my lord, is that you have to produce the endorsement to that effect. The sketch is only for limited period. It is not, otherwise we will not believe the version. That is the court finding. Not primary evidence, secondary evidence, I am permitting me to lead evidence. The scope of secondary evidence, my lord, I have to place before the court. Why primary evidence I could not able to produce before the trial court to lead there as a secondary evidence. But in my affidavit, I may kindly come to page 61, my lord. Para number
No, for example,
8.
if that is, let's take a situation where it is available, you can get it, but you say the copy given to me is no more available or I lost it. So I may permit it to reduce the secondary evidence.
Lord, it is only for to show that.
So it is also a very easy thing what the court has said.
Lord, court merely said that, my lord, you get as a NOC. My lord, NOC to getting also it requires some time. In the meantime, close rejected my entire application. My lord, on the ground that I have not obtained the NOC endorsement from the competent authority. My lord, this is the sketch issued at the time subsequent to my agreement of sale. I applied for identification. I am the agreement holder. I am entered into purchase this particular portion of land. To show this particular portion of land, my bona fideness, I am ready and willing to my perform.
Get it, get it.
I have to go and apply and to get
You should
the.
have done it when you want to do this. Before doing all this, we should have got it.
But I have only photography. Earlier they issued certified copy. It was misplaced with me. And therefore, I placed the photocopy as placed. It is a certified public document now available.
The question of the court was whether the main, you have been given one copy, whether the original is available with the authorities. You said it is not available, only this is the one.
Because of.
Further, they wanted, I don't think that will be so difficult for them to say that we don't have a copy.
Because
And the right
which
to
officer was there? They have.
Right to Information Act also you can ask.
That's why I filed. That is my endeavor, my lord. In the meantime, court has, because I filed a Right to Information Act already. It is in the process. In the meantime, court has rejected. Therefore, I am able to.
I number 123 is filed under order 18/17 and section 15 and 60 of the BSA 2023. And the same came to be rejected on the ground that the petitioner has not placed any material to show that the original is not available with the authorities. It is submitted that they have filed an application under the Right to Information Act and they would be getting the said endorsement from the authorities and place the same before the court. Considering the said submission, there shall be stay of all further proceedings pursuant to the dated notice and summons.
Number 3. Number 3. Shavan Madhav.
Appearing for the petitioner in this case, my lord. My lords, I filed a petition under section 16(3) of the Indian Telegraph Act. Subsequently, the trial court has passed an order. I'm not seeking any interim relief in this case, my lord. Notice may be issued.
Notice to the respondents.
Number 4.
Wait for me.
Raj Ballal.
Lord petitioner is a factory, my lord, which is closed.
Over this,
Pardon,
fresh matter.
Lord, there was a mistake in the annexures, my lord. I had filed an IA. The ladyship permitted me to replace it. Annexure B is the one which I have replaced it.
Yes.
Facts in brief, my lord, is
What is injunction is?
injunction has been granted by the trial court and confirmed in MA, against which I am before the honorable court. The reason is this: the factory is closed. There were 16 employees. We have paid them 35 lakhs of rupees for the 16 employees as retrenchment compensation. After receiving that, my lord, they have raised a dispute before the labor authority. In the meantime, my lord, the factory in the premises, which is closed now, is also the tenancy has lapsed and they have received a notice for vacating. Why at the time of shifting the machines, my lord, they go and obtain an injunction, and the trial court grants the injunction on the plaintiff who is not even the workmen are not even the members of that trade union, and trade union has no locus standi, despite which, my lord, the plaintiff injunction suit is for not to remove the machines.
Injunction.
Injunction, my lord. And that is confirmed by the appellate court also. I cannot move the machines. My tenancy is terminated. I have retrenched the workmen. I want to shift those machines to my original.
What has happened before the labor court?
No, they have just raised the dispute, my lord. Dispute is pending.
And they filed a suit for injunction.
Yeah, they filed it. And the plaintiff, the workmen are not even the members of the trade union.
We'll pass the order in their presence.
Pardon me.
Take out hand summons. I'll pass a final order.
Please, my lord, please.
Notice to the respondents, hand summons.
Obliged.
It is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo by 24th of August. If it is filed, lists the matter on 25th.
Please.
Cell number 5, Jairaj 80.
Appeal for petition, my lord, we are withdrawing. We are withdrawing.
Check that. Memo is filed stating that the red petition has become infectious and the petitioner wants to withdraw the same. Memo is taken on record and dismissed as withdrawn.
Cell number 6,
I appear for the petitioners.
Adish Kumar.
My lord, the petitioners have challenged the order of the Deputy Commissioner under the Telegraph Act. My lord, kindly see that annexure L. My lord, already one set of petition has been filed before this honorable court and is pending. It may be called along with that, my lord. The number details.
In the list it is there.
It has been listed and interim order has already been granted. The same order have been challenged by other 30%, around 20% have challenged.
Serial number?
6 million. It has not been listed today.
Oh,
So
see
it is
that.
filed and this is the writ petition. There are totally 173 parties. Out of that, my lord, some more persons, 21 persons have filed there.
No,
Please,
this order says that some route is approved by the deputy commissioner.
please,
They are taking a contra route and laying
Please.
the lines in your land.
please.
But here you are questioning the order of the deputy commissioner.
Yes, even the same order we have challenged it.
Why you have challenged?
No, we are also, our land being used.
No, in this case,
Ah.
deputy commissioner's order is in favor of the petitioners.
No, 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 it is not in favor of.
No, you look at it, that's what
Please,
it says. No, the petition's
Earlier,
basis is that.
earlier it was in our favor. Without,
How this order will.
same, say, earlier it was made in our favor, stating that alternate,
Basing on this order, there can't be an order in this case.
they have not followed their own order. The deputy commissioner now, which is impugned, they did not follow their own direction. That is my case. Even in that petition, in this.
Sir, you're not supposed to question the deputy commissioner's order. In the light of deputy commissioner's orders, their inaction should have been questioned.
No, what happened thereafter, initially the deputy commissioner, based on our representation, has gone through our representation and said that there is a best alternative route. You please proceed with that route. Then what happened? The concerned authority did not follow that direction. Then we challenged that order before this honorable court. This honorable court has directed the deputy commissioner to look into this. Again, we went before the deputy commissioner. This time, deputy commissioner said, I cannot find direct for alternative routes. That is the order which has been challenged.
Under the provisions of the Telegraphic Act,
Please.
what are the powers conferred with the deputy commissioner?
My lord, as far as that is concerned, in the impugned order, the deputy commissioner has relied upon the decision of this honorable court in SM Rao cases. In that case, my lord, it has been clearly stated that direction was given to the state government stating that there must be an alternative forum for the persons who have suffered with this route. Kindly the decisions.
Take that.
Oh, please. Aye. My lord, kindly see, this is the decision which has been relied upon by the deputy commissioner to say that I am not the competent person to find, to direct them to have a different route.
Under the Telegraphic Act, is any such exercise permissible or contemplated?
My lord,
Can you ask somebody to say, no, they will finalize a particular route because they have their own it has to be straight,
Correct.
or otherwise there are some other complications. Those are all their cases. So what is the role of a deputy commissioner under the Telegraphic Act?
My lord, under the Telegraph Act, there is a provision which says that as far as routes are concerned, the competent authority has got, means my lord, if it is a Grama Panchayat, or it is a Tahsildar, or it is a deputy commissioner, they can have say on that issue. That is there, my lord.
Give that act.
Section 13. Power for local authority to require removal or alteration of telegraph line or post. When, under the foregoing provisions of this Act, a telegraph line or post has been placed by the telegraph authority under, over, along, across, in or upon any property vested in or under the control of management of a local authority, and the local authority having regard to circumstances which have arisen.
Is pertaining to the property of the local authority.
This is a agricultural land.
No. This 13
Please, ma'am.
is pertaining to the property belonging to the local authority.
Power for, no. Power for local authority.
No. That is what, then it says, when under the foregoing provisions of this Act, a telegraphic line or post has been placed by telegraphic authorities under, over, along, across, in or upon any property vested in or under the control of the management of a local authority.
Under the control and management, control means, my lord, Grama Panchayat, it comes under the Grama Panchayat limits. If it is agriculture land, it comes under the jurisdiction of the Tahsildar or the deputy commissioner. It is not that, my lord, ownership, it is the control. The agriculture land comes under the control of the deputy commissioner. My lord, therefore, the local authority can have say on that. That is the distinguish which needs to be made.
So how the deputy commissioner will know that, no, you say that the lane should not go in A to C, it should go to B to D.
My lord,
You say so.
in our case,
Deputy commissioner, how he can
my
competently
lord,
consider
the
it?
deputy commissioner is also one of the competent person to decide these routes. In our case, the electricity authority has found 3 routes. They proposed 3 routes. Whichever is applicable, feasible, that they are ready.
Proposed route 1 is inconvenient to you. Proposed route 2 is inconvenient to somebody.
Yes, no. The 3 routes what they have identified in the first stage is admittedly is okay for them.
No. 1, 2 and 3, all pass through the private lands or government land.
It is part of the government land and part of the private land and part of forest land.
No. Then part of private land, whomsoever is having the right over that property, it may not be acceptable to them.
No. See, that is where the Telegraph Act comes. If it comes under the private property, then the deputy commissioner will have a right. Then whatever the.
That I understand. What I'm saying is, now this line 1, your property is going to be affected. You want them to take line 2. 2 is also private properties are there. They are also not interested. 3 also the same thing. So how the deputy commissioner will draw a distinction that he should take 1, 2 or 3?
My lord, it is based on the objections. Based on the objections.
No. Line 3 is completely the government land. Then they should, because it is viable, they can take line 3. But where private properties are also included in that. So why should there be a difference between 1 and 2?
My lord, the reason is this. Suppose in route 1, my lord, the number of open land is more. Then, my lord, the preference will be given to that. If in line 2, the garden lands are there. My lord, garden lands, my lord, all small extent that the owners are having. If that is damaged, even the government has to pay more compensation and it is a loss to the society also.
When this whole process started?
My lord, it started in the year 2023 and my lord, there was a proceeding before the deputy commissioner.
From 23 to now, lines are not laid.
No, out of my lord 100%, the 60% have been done. Now it is a point where it has to take divergence. Either this route or this route is the point where it has.
That's what now The whole purpose of saying that this is gone by the Telegraph Act, because you don't have any say in that. Now, if this manner from 23 to 25, if the important laying of the telegraphic, I mean, the electricity lines are state, it is, that's not the purport of this.
No, my lord, at the
provision.
same time, the government has to take care of this garden land, my lord. We are not, even for them also, the distance will be less, the expenses will be less, and we have not stalled any of these one. Now they can take the deviation and they can proceed.
Mr. Devaraju is directed to take notice,
It may be called along with another writ
list
petition.
along with so and so.
Date has already been.
More or less, it has become infructuous, this other writ petition.
No, my lord, it is, there is an interim order not to precipitate, that is there, they have not done it. Even now, it's a rainy season, they cannot do anything because the situation is like that.
Because things like this, we can't grant an interim order and keep it pending.
My lord,
Because it is
I'm not
the
asking for
larger-
any interim order
I'm
in
saying
this.
it's in
It
the
may be
larger
called
pop-
along with that, my
That's
lord.
what- Call along with WP number 9805/2026, Mr. Devaraju is directed to take notice and he shall get specific. Huh?
I will take notes for respond number 1, HP Devaraju 2 to 6.
Respondent number 1, HCGP takes notice to Mr. Devaraju.
2
He
to
shall-
6, madam. 2 to 6.
2 to 6. He shall get instructions. List this matter on 17th of August.
Already date is there in other connected.
Coming?
Lord, I'm not.
No, but we'll hear it. There is a stay in
All-
that matter.
no, date is there, that's why.
17th August. Let it come along with that on 17th August.
Much.
Yes.
Seven, Abhinay Vaiti.
Petitioner, madam. Lord, between, Lord, under an agreement of sale.
You appear for whom?
I undertake to appear for the respondent.
It is not even notice is ordered. Yes.
Under an agreement of sale between the respondent, defendant and his vendor, possession is handed over. Sale deed is executed.
Yes.
This, my lord, in a separate suit filed by the plaintiff seeking recovery of money. These two documents are presented before the court. Court says, my lord, I am bound to pay duty penalty on the agreement of sale. This, my lord, this court has already considered this. And in view of...
First of all, let me look at the impugned order.
Sure, madam.
Let
But
me
the impugned order is
understand
at
the
page
case.
70, madam. 70.
Then the judgment.
70, madam.
Yes.
Now, my lords, may see the court, my lord, while considering the similar issue in a separate case, held, my lord, that explanation to Article 5E states, my lord, if agreement of sale is followed by a sale deed, stamp duty that is to be paid is to be adjusted. This is the view, my lord, which this court takes.
No, what about this case? What is the suit for?
The suit is for recovery of money. It is not with respect to this agreement.
No,
of
that
sale.
is coupled. Now, after the agreement of sale, a sale deed is also
Sale deed is
executed.
done between me and my vendor.
Yes.
But this just relance.
Yes, I've seen the judgment. What do you say?
My lord, they are the defendant in the trial court. They are, it is a money recovery suit.
No. Agreement of sale culminated in a sale deed. What it presupposes? Why
No,
should
no,
that?
agreement of sale, when agreement of sale, possession was granted. And agreement of the sale is between one Mr. Keshavamurthy and Leah. And whereas the sale deed is only Keshavamurthy. Agreement of sale is for land and plant and machineries. Whereas the sale deed is only plant and only for the land. So these two deeds are totally different. The innovation has taken place. And what they have done is only they have impounded the document. They are not levied penalty or any such thing. As far as the document is concerned, prima facie it is understamped.
No, that is what is the judgment.
That's what I'm trying to. Now they have only impounded the document. And subsequently, they want to.
They are only questioning the impounding of the
No,
document.
that's
which
what
is
I'm
not
trying to say.
necessary according to them.
As far as the impounding of the document is concerned, on the prima facie document is understamped. Whether duty is payable, whether duty is set up is subsequent question. What is the duty, penalty is payable is different question at all. For that, a separate hearing is to be done, separate order is to be passed.
Pass on the judgment.
In that judgment, what has happened, in that judgment, what is said is, if sale deed is subsequently executed, the stamp duty penalty need not be executed, need not be levied. But the question is, whether the sale.
Let's see what is, first of all, what is the law laid down here?
Yes.
Where is
Para 7, my lord.
para?
7. Para 6 is the reasoning, my lord. Para 7 is the.
Agreement of sale, once a sale deed has been duly executed and stamped, should no longer be independently subject to stamp duty. It has been merged into the sale deed. What was the question before the court in that?
Question before the court, my lord, says, my lords would come. First paragraph, my lord. My lords, take para 6, my lord, the reasoning is complete there in para 6. The sale deed, which was marked as exhibit D1, is an essential document produced by the petitioners. Article 5(1) of the Karnataka Stamp Act 57 specifies that if the possession of the property is delivered or agreed to be delivered before executing a conveyance, such a document is liable for stamp duty as conveyance. However, once a sale deed is executed, it absorbs the terms and conditions of the earlier agreement of sale, making the sale deed the governing document of the transaction. In the present case, the agreement of sale dated 11.
That is precisely the law laid down.
My lord, my submission is the same sale agreement has not culminated into a sale deed. The first sale agreement is with regard to, is between two persons. One Mr. Keshavan and Ilya. The sale deed is with respect to Keshavamurthy alone. And secondly.
Is it Keshavamurthy a party to this or not?
It is against Keshavamurthy only, not against the other person. What I am.
Keshavamurthy is in his favor the sale deed is.
Yes.
That is relevant.
That is relevant, my lord. What I am trying to say, the same sale agreement has not culminated. A new sale deed has been executed. The sale agreement is in respect of land, plant and machinery and so on and so forth. And the valuation is totally different thing. Sale deed valuation is totally different thing. Sale deed is only in respect of land. But these are the matter to be considered by the trial court.
What do you say on that?
My lords, may see page 37 and page 52, my lord.
37
is the agreement of sale schedule, my lord.
37. Yes.
This is the schedule, my lord, to which the sale agreement is page 37. Now, my lords, may kindly come to page 52.
All that piece and parts of the movable property bearing immovable industrial plot bearing number, so and so.
Now, kindly come to page 52, my lord, the sale deed, schedule to the sale deed.
No, but it also says about.
This, my lord, these are the machineries which exist. The trial court values it on the plottal area. My lords, may now come to the impugned order. Impugned order says it's to be valued on the plottal area. Now, kindly come to page 70, my lord.
Then what is, by this agreement of sale, what you wanted to.
I purchased the plot and also the machinery on it.
Yes.
Sale deed is only with respect to the plot area because that is what determines the market value of the sale deed. Trial court says, since your agreement of sale is with respect to a plottal area, the square feet of the land was X. Since you took possession, you are required to pay. It's not on the machinery. May not kindly come to the impugned order.
The machinery also attract tax.
It was part of it.
That was not the consideration by the court.
No. What I am submitting.
No, I can only understand why the court has passed this order by looking at the order. Court is only concerned with this document. It never mentions about the machinery. It is not the concern of the court at all. Court says still you have to pay the stamp duty. So, as per the reasoning given by the court, in the light of this order, which he is relying on, he need not.
No, my lord, this was not before the court. Whether the sale agreement and sale deed are one and the same or not, that is the matter to be decided by the court.
Then the court has to decide it first. Then it should impound. It can't do it.
That can, if your lordship's remand is for the first, let them decide it. It has converted into the same sale deed. I have no objection. But per se, it cannot be set aside. If the court were to direct the trial court to first consider.
First of all, this impugned
No,
order
my,
doesn't.
no, my lord.
Understand, the impugned order doesn't even deal with it.
No, my lord.
Why should we look
No,
into
in the-
something which is
no,
not there in the impugned order?
If the impugned order does not deal with that, to that extent that impugned order is bald, the impugned order may be set aside, but it cannot be said that this judgment is applicable to this case law. For the instant case, the trial court has to consider whether the sale agreement has culminated into the sale deed or not, or a novation of contract.
But do you think that in a sale deed, machines will be also will be form part of a sale deed?
Yes, my lord. You see, in the sale agreement is if the plant and machinery may be embedded to the land, therefore it may be part and parcel land.
For purchasing a movable movable
That is what I am
property
trying to say. These are not the matter to be tried by the trial court. What I am trying, the valuation is totally different thing.
Stamp duty requires for what?
No. The sale agreement and sale deed are one and the same. The sale deed.
Please listen, I'm asking you a question. For purchasing a movable property, you require a sale deed, registered sale deed.
Yes.
Movable property.
Movable property need not be. But they have included it. They have valued it. And it is tax, once it is included it, stamp duty is payable on movable properties also under the Karnataka Stamp Act at 5%. And what I am trying to say, what he is trying to say.
So you should have also come to the court if that is the argument you are putting forth.
No, we have submitted our written argument. We have submitted our written argument saying that it is totally different thing and other thing.
Anyhow, the reasoning that is given by the court, I do not find any. I'll stay the proceedings. You come and
My lord, one more thing. They themselves ask for an application for withdrawal of the sale agreement. It only means they are not relying on the sale agreement for the purpose of the agreement.
Submits that. The court has directed
And the suit is in the year 2019.
Impounded.
And
they have relied on a judgment of
one submission, madam.
the
one submission, when they themselves are saying that they are not relying on the sale agreement, they are withdrawing it, the trial is over, argument is over, my argument is over, they have to reply it. What is there to be said?
When was this order passed?
It was immediately moved. The order was passed on.
Thereafter, they have taken a lot of time. I have completed my argument also.
14/7/26, the order was passed. 20th July 26, I filed this writ petition. I had moved it twice. The matter is now listed before me.
When was this order passed?
14th July 26. I filed the writ petition on 20th
For
July.
the petition.
May I submit this application? This is an application for withdrawal of the application.
You can file all the documents, we'll see. The petitioner is before this court questioning an order passed by the court, whereby the court has directed that the copy of the agreement of sale dated 22/2/2013 produced by the defendant number 1 shall be impounded, is impounded. It relies on an order passed by the coordinate bench of this court in WP number 105278 of 2018 in case of Srimati Nagamma and others versus Rudraya and others dated 25th July 2024, wherein it is held that when the agreement of sale is culminated into a sale deed, the agreement of sale need not be impounded. Considering the submission, there shall be stay of all further proceedings. Learned counsel so and so submits that. You appear for whom?
My lord, 1, 2. For respondent number 1, my lord.
You appear for?
Respondent 1 and 2.
One and two.
Only
One.
only one.
1.
One.
2 and 3 notice may be
Submits that.
dispensed with.
He has instructions to file wakalat on behalf of first respondent.
2 and 3 notice may be dispensed with, my lord.
A memo is filed seeking dispensation of notice to respondent number 2.
Respondent 4.
3, my lord, yes. 4 is the government, my lord.
3.
2 and 3 dispensation, my lord, because they are
2, 3
codified.
dispensation.
4 is the state, my
4
lord.
AGA takes notice. Yes.
Grateful.
Copy may be served. Copy of the petition.
Learned
I'll
counsel
serve
the
it- I'll
petition
serve it
such
today.
of the copy of the writ petition on the counsel for the respondent. List this matter on 7th of September.
Grateful.
Yes, short date may be. Short date because.
I'm completely, my board is full, I can't
understand,
take it up.
Because the suit
Yes.
is in the year 2019.
2003 suits are also pending here now.
I understand. I'm not on that.
The petition, my lord. I'm open for the
Yes.
petition, my lord.
Yes.
It's a plaintiff petition, my lord. It's a amendment application dismissed, my lord. Against that order, we filed this writ petition, my lord.
Suit is of the year 2020. What is the suit?
Suit for declaration and injunction, my lord. Only in the para number 4 and para number 5 and 6, my lord, this is mentioned
Where
that, my
is
lord,
where is your affidavit?
affidavit page number 50, Annex D 59, my lord. Only its boundary is concerned, my lord, it's clearly mentioned. But it's a body of the petition instead of northern portion, it's a southern portion we mentioned. That is the only clarification, ma'am.
Where is the order?
Order, my lord, page number 37, my lord.
When counsel for the petitioner submits that when an application is filed seeking amendment of the plate with regard to the boundaries, where instead of mentioning southern, you mention northern or northern southern. What is that?
North, it's instead of northern, we mention southern, my lord.
Instead of mentioning northern boundary, southern boundary is mentioned in the court without considering any of the aspects, simply dismiss the application. It is submitted that unless the same is, unless said typographical mistake is corrected, that would cause a lot of hardship to the plaintiff, considering the same stay, notice, hand summons. Yes.
Cell number 9. Vaidya Ravi.
Lord, I appear for the petitioner, my lord.
Yes.
Suit for injunction, my lord. My application seeking for a temporary injunction came to be rejected by the learned trial court, my lord, which came to be affirmed by the learned first appellate court.
Come to the appellate court. We'll order notice, let others will come, we can decide. Notice to the respondents, hand summons.
In the interregnum, my lord, may I request, my lord, to pass
Let it come,
status
any
quo,
two courts have held against you, will hear them.
please.
My lord, suit for partition and separate possession. Suit is filed by the sister as against the brother. During the pendency of the suit, my lord, the matter is referred to Lok Adalat. In Lok Adalat, my lord, the settlement takes place and an award is passed. Thereafter, the cousin brothers, my lord, file an application for impleadment and, my lord, 23 Rule 3A application for setting aside the compromise. Impleading application, my lord, is allowed by the trial court and the matter is posted for enquiry on 23 Rule 3A application. My lord, once an award is passed by the Lok Adalat, my lord, the only appropriate relief, my lord, that he can claim is filing a writ petition before this honorable court. Lords, the matter, my lord, was referred to Lok Adalat, my lords.
No, where is the impugned order?
Please, my lords. The impugned order, my lords, it is page number 64. It starts from 62. Lordships, my lord.
Yes.
Page 61, my lord, it starts.
When was the award passed?
My lord, the award, my lord, was passed on, my lord, the 8th of 8/7/2023.
When is this?
Application, my lord, is filed on 31/7/2023.
Let's see that. Where is the present or interim application?
My lord, the application file, my lord, is at page number 110.
No, how is it numbered? Where is that? In the suit, they filed an IA.
No, my lord. The matter was referred to Lok Adalat.
Not your case.
Please,
I'm
ma'am.
asking what about the respondents have done?
In the suit, they have filed in the suit, the application is recorded, and in the suit only, my lord.
Where from you get that?
Please, my lord. Lords, your lordships, my lord, will get it page number 38, my lords. 38, my lords. 38. The case is taken up 31/7/2023, my lords. The typed copy is in 39. Case is taken up on advance by third party. Applicant has filed IA number 10 under order 1 Rule 10.
When counsel for the petition submits that a suit of partition was filed, and thereafter that an award was passed on 5/7/2023. Thereafter, the persons who were the cousins of the petitioner has filed an application before the court, and the court
has allowed their
But
application.
that, this is, that is recorded by the trial court. The compromise is recorded by the trial
In
court.
presence of conciliator after the matter was referred to Lok Adalat.
Ultimately, after that, it hasn't again gone back to the court.
No, my lords, it has compromises in Lok Adalat.
See at page 38.
I'm not at 34 if your lordship sees, my lord.
38.
My lord, 38 is also the conciliator signature is also present, my lord. It is in Lok Adalat. 37 was on Lok Adalat day. On Lok Adalat, this settlement happens. It was on a Saturday the settlement takes place, my lord. The matter was specifically referred to Lok Adalat.
No, again, all of you have come before the court. Before the Lok Adalat, it has not become final. It has come to the court again. Court is looking at the terms and conditions of the compromise. Court has recorded it. No, it will not become a compromise before the Lok Adalat now.
The award, my lord, is Lok Adalat award only because of conciliator's presence there. Court did not record it, my lord. The same order sheet is maintained. That is the difficulty. Order sheet should have been different. My lord, kindly see, my lord, page number 34.
Advocate conciliator present.
Please. This should have been in a separate order sheet, my lord. This order sheet should not have been maintained. Conciliator cannot sign in the court's order sheet.
When counsel submits that an award is passed for the Lok Adalat, now the cousins have filed an IA to set aside the compromise decree. It is submitted that when an award is passed for the Lok Adalat, the only remedy available to the third party is to file a petition before this court. It is submitted that even otherwise, a third party cannot question the Lok Adalat, the compromise decree before the court by filing an IA. Considering the submission, there shall be stay of all further proceedings in so and so, pursuant to the order dated so and so.
That's only respondent number 5 and 6 notice may be ordered, my lord. Others it may be dispensed.
Who are the others?
Not the family members, my lord.
1 to 4.
Please, my lord.
1 to 4, a memo is filed seeking dispensation of notice dispensed with 5 notice hand summons. In all these today's hand summons, the day shall be 3rd of September. Yes.
Cell number 12. Cell number 11. Anand M.
Please, Lord, let's suit for a declaration and injunction. Lord, on the ground that not the sale deed executed is under the GPA, it's a forged one and non-registered one. My Lord, court says that my Lord issue summons so that there is no prima facie has been made out. My Lord, court says that, my Lord, kindly.
Where is that order?
Please, my Lord, order. Huh?
Where is the order?
Please, my Lord, order, my Lord, starts with my Lord page, my Lord 20. Please, my Lord. Page 20, my Lord, last para. On perusal of the records and also from the plaintiff, ever clear that the present suit is plaintiff sought relief or declaration in respect of many documents.
The petition is before this court, agreed with the order dated so and so, passed by so and so, dated 27/6/2026. Then counsel for the petitioner submits that when an application is filed seeking ad interim injunction, the court ought to have considered the same and passed orders on the merits of the matter. Having discussed the case, the court issues emergent notice. Considering he has relied on a judgment of that order is there. No? Coordinate bench of this court and so and so. Accordingly, the petition is disposed of, directing the trial court to go consider I number so and so within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the notices are not served on the respondent.
Cell number 12. Manjunath HR.
Yes.
Lord, Annexure A is the impugned order. Wherein Annexure A is the impugned order, my Lord.
What is the suit for?
A suit for partition filed by the respondent number 1 and 2 herein, seeking the relief of partition separate position that came to be decreed, my Lord. And they have filed execution FDP. After FDP, execution petition came to be filed. During the pendency of the execution petition, the JDR number 1, the one Mrs. Sharfunisa, she died. She died on 29/1/2026. And upon the death of the JDR number 1, my Lord.
Reduce the fan on the top of my head. Reduce. Yes. Reduce. Yes. You are the?
I am the beneficiary under the will executed left behind by the deceased JDR number 1. I made an application before the executing court to bring me as a legal representative of the JDR number 1 because I am the son-in-law of the deceased person and sought for an application as implement as a party to the proceeding. That application came to be rejected with.
Come to the order. Where is that order?
Annexure A is page number 14, my Lord.
Orders on IA number 2 of 26 filed by the applicant under order 22 rule 4 of the CPC. The 11th paragraph is at reasons quoted at para number 8, please, madam. It is not in dispute that Srimati Sharfanisa, who is defendant number 1 in the suit, is no more. Decree holder JDR 1A, 2 and 3 being children of Sharfanisa already on record. Now applicant came up with the application that is named to be implemented as legal representative of deceased Srimati Sharfanisa. On the ground that Sharfanisa during her lifetime on 2398 executed registered will and bequeathed scheduled properties to him. It is worth to know that here that in suit, Srimati Sharfanisa filed return statement containing that dependent 2 and 3 over her daughters and their husbands have played fraud on her and obtained a signature on blank paper informing same required for creating lease deed and get created.
Para 10 relevant.
Honorable High Court, while disposing regular first appeal, has observed that defendant number 1 Sharfanisa has no absolute right to execute gift deed. It is observed that defendant number 1 has no absolute right to execute any testamentary document. Blood, it is observation made insofar as gift deed is concerned.
Testamentary. Next.
Milad, once it is observed that Srimati Sharfanisa has no absolute right to execute any document in respect to properties, already legal representative Sharfanisa on record, no grounds made out by applicant to come on record as legal.
So, what the court observed is, now the court will not conduct an inquiry which is contrary to the findings of the High Court. Now, in respect of this property, there is an observation in the appeal, which is disposed of by the High Court, that either she has no independent right to execute a gift deed. She has no right over the property. Question of executing a gift deed or a testamentary will not arise.
Milad, I have produced a sale deed under which is Srimati Sharfanisa has purchased the property. She is the absolute owner.
That we can, that aspect, a particular aspect, come to where is the judgment and decree? I mean, that is in the RA. What is the appeal order?
Appeal not produced. So far as my humble submission is that, my lord, even though Sharfanisa being the one of the shareholder as per the partition decree that has been passed, my lord, so far as that particular share is concerned, as per the will that is executed by the Srimati Sharfanisa, I am entitled to have
notice to the respondent's petition is permitted to take put hands on.
Sought for a stay, my lord. Tomorrow is the hearing date, my lord, because they have already taken steps to auction this.
At least you should have placed the document before me. Judgment. Without that, I will not grant.
So far as her share is concerned, madam, I'm concerned.
If you want, I can hear it tomorrow, but I will not grant stay without being convinced with the order. That is a case for interim order. If you want, I'll hear it tomorrow.
Please, madam. Tomorrow.
Please, yes, tomorrow.
Achha.
May I please, your lordships?
Yes.
I'm the plaintiff tenant before the learned trial court, my lords. Suit is one for injunction, my lords, to not to interfere with my possession, nor, my lords, disposes me from the property without the procedure under the law, my lords. I also filed IA number 2, my lords, seeking interim injunction, my lords, under order 39, rule 1 and 2. The trial court, my lords, was pleased to grant a status quo order, my lords. However, my lords, the learned appellate court, my lords, without looking into the documents, without looking into the pleadings, my lords, says that, my lords, my application under order 39, rule 1 and 2 is not maintainable because it has the effect of granting the final relief, my lords. Lordships will find this at annexure A, my lords, page 59.
Appellate court has reversed it.
Yes, my lords. Appellate court has reversed the order on the ground that my application is not maintainable.
Let's see.
Para 46, my lords.
Because interim and final reliefs are one and the same.
My lords, the final relief, my lords, what I am seeking is, my lords, not to dispose me from the property without following the procedure under the law. I am a tenant, my lords.
What is the interim prayer?
Interim prayer, my lords. Application, my lords. Annexure P, page 141, my lords.
You can tell the court, what is it?
For the reason stated in the accompanying affidavit, the plaintiffs prays that until the disposal of the suit, an order of temporary injunction may be passed restraining the respondent defendants, their men, agents, servants, or anyone claiming through or under them from dispossessing the plaintiff from the plain scheduled premises. If that is the view taken, my lords, that would be contrary to order 39 rule 1, my lords, because under order 39 rule 1, my lords, till the disposal of the suit, my lords, the position of the plaintiff ought to be protected, my lords.
When counsel for the petitioner submits that, the trial court has granted an order of interim injunction or passed an order of status quo. And the appellate court had reversed the same without any basis. He submitted that he is a tenant in the property and he wanted an injunction restraining them from dispossessing without following the due process of law. And if during the pendency of the proceedings, if the plaintiff is dispossessed, the suit itself will be, the purpose for which the suit is filed will be defeated. Considering the same, there shall be stay of all the order of the appellate court in so and so state, and the party shall maintain status quo. Notice and summons.
My lords, if I may make one submission, my lords, if your lordship say status quo, my lords, what will happen is, my lords, currently the building is kept locked, my lords. So at least permit me to conduct the business, my lords, subject to putting.
No, it is now. I'm traveling beyond the scope of this 227 petition, because you are not there before the appellate court.
I am before the appellate court.
Against the status quo order.
Yes, my lords. I am the one who filed the suit, my lords.
You have filed the suit.
Yes.
Status quo is granted. Status quo is questioned before the appellate court.
We questioned the status quo order before the appellate court, my lords.
Why?
Because as per the.
By that time, you are already dispossessed.
No, not dispossessed, my lords. What has happened is they have put lock to the premises, my lords.
You are not using it.
I am using the premises. Because I am using the premises, they have locked it.
Court notice, let them come. I will decide that. Now we will not, without all these factual aspects, we can't pass an order. Same, the order of status quo.
Lordship may put me to term, my lords. I will.
Let me understand the facts from them. In this matter, if the memo is filed by 1st of September, list the matter on 2nd September.
Please, my lords. I'm grateful.
Then number 14.
Hearing for petitioner, my lords. Kindly have this matter next week, my lords. There is
List
a
it in the month of
inconvenience.
September. List 15.
Then number 15.
Yes.
Petitioner in this case. Yes, I'm questioning annexure D, my lords, wherein the deputy commissioner must determine the compensation payable to the farmers. Plus, wherein, my lords, in their land, they are about to draw the transmission lines, my lords. Plus, this power, the determination of compensation is exclusively vested with the deputy district judge, my lords. The deputy commissioner, as per section 16, can only give the protection to the transmission authority while drawing the transmission line, my lords.
Go before the court, question it.
Plus, only after the payment of compensation only, my lords, I can go before the deputy commissioner under section 3 of the act, my lords.
Who will determine the compensation then?
The transmission authority, my lords, first they will pay the compensation for the loss of trees or damage caused to the land.
Questioned before this court now.
Annexure D, my lords.
That's what I'm not able to understand. Now, whatever it is, they will pay the compensation as per determined by the deputy commissioner.
No, my lords,
No, just listen to the court. You will take you are not happy with the compensation. You will go before the civil court. Ultimately, either ways you have to go before the civil court. So why do you want us
Malas,
before
then
this
they
court?
will Malas, take the defense before the learned district judge that Malas, they already paid the compensation in terms of the deputy commissioner order, and deputy commissioner attains finality, and they are not question the deputy commissioner order by the landowners.
So only that formality you have come here.
Yes, the current Malas, they fix the compensation in terms of the guideline value of the sub-register. Malas, you lordship kindly see.
Yes, Mr. Devraj is directed to take notice. This is matter day after tomorrow. Sir, the papers on.
Please.
In the first list. Yes, next.
It is private. Devraj is a private.
Devraj is not there, Malas. This is Ashwamedha, the private
MIS
transmission.
private solar, that is
Private solar company. It is not a KPTCL, Malas.
For their benefit, it is done.
Yes.
For that, Devraj is not representing, my lord.
You get instructions. Deputy Commissioner's order.
Respond
Day
number
after
20.
tomorrow.
16.3 is there, my lord. They have to approach.
16.3
is there, my lord. Telegraph record. They have to approach district judge, my lord. Because the specific contention.
His contention is deputy commissioner has no power. What is your submission on that? Please make.
Please, my lord.
Yes.
I will take notice for respond
Yes.
number 2 and 3, my lord.
2 and 3.
Respond number 2 and 3. AJ takes notice and AJ shall get specific instructions day after tomorrow. Yes.
Monday, my lord.
Monday.
Please.
Then number 16. Muralidhar.
All the matters which are adjourned in the first list, right? First list, whether I say or not.
We are the petitioner. We are the petitioner in this case, my lord. Kindly have it on day after tomorrow, my lord.
Right.
Senior is not well.
Day after. The first list. Yes, sir.
Lord, application, my lord, came to be rejected by the trial court, my lord, on order 1 rule 10 of CPC, my lord.
What is the
Taking, my
suit
lord,
for?
Not defendant number 5, my lord, filed the
Suit for,
suit for partition and separate possession, my lord.
who filed the application and
So
order
defendant
one?
number 5 filed application, my lord, for transposition from the defendant number 5 to plaintiff number 2, my lord.
He suit for partition.
Please, my lord.
That is allowed.
That is came to be rejected, my lord.
Oh, you are the defendant who filed this
Please,
application.
my lord.
Come to the order.
My lord,
Why do you want to be transposed?
my lord, we are, my lord, to take the contention, my lord, on behalf of the plaintiff also, because we are the own sisters. My lord, we are supporting the suit, my lord. For that reason, my lord, we have to transpose from
You can
the,
support him as a defendant also.
no, my lord, I am the being the defendant number 5, my lord. I have to support the plaintiff, my lord, because, my
But
lord,
you can support him being a defendant also.
my lord, I have to
No, if
strengthen.
he is not taking care of the interest of the, if he
Your
is not
lordship may kindly
pursuing
see, my
the, if
plaintiff.
he is not prosecuting the suit, if you have any other apprehension, that would be a reason. If you want to help him as a defendant,
No, my lord, page number,
because it doesn't make any difference, it's a plaintiff or a defendant.
para number 9 may kindly see, my lord, page number
Please
50.
come to the order.
Page number 50, my lord. The impound order at annexure G, my lord, page number 44. Relevant para number 9, my lord, page number 50. 50.
Yes. Notice to the respondents and summons.
My lord, interim prayer, my lord.
Why should the suit be
For
stayed
further
for this
argument, my
reason?
lord.
You say you want to support the plaintiff and
Please, my
the,
lord, but
and the suit be stayed.
till then, my lord, they
No,
will
no, no. That's
they'll
not a
post for
ground at all.
judgment, my lord.
Then I have to infer something and I'll dismiss it. Yes, notice.
Number 18, Arya Devanand.
No representation in the month of September. Yes, 19.
19,
Hearing for petitioner, my lord. On record counsel is not well, my lord. On weak adjournment will be granted.
List the matter after 2 weeks. Yes.
number 20, Chidambara GS.
And defendant number 2 is in writ petition, my lord, order challenging the acceptance of commissioner's report in a suit for declaration that the plaintiff is having right to draw water.
Where is the order?
My lord, order is at page number 61. Relevant portion is 62. But commissioner was appointed for local
No, it
investigation.
says it's a suit for injunction.
Declaration that prayer of plaintiff may kindly be
No,
seen.
no. When you look at this order at page 61, court says it's a suit for injunction.
It is not in, not only injunction.
Declaration
Is also there. Page number 68 may kindly be seen. That observation is not correct. Plaintiff got appointed court commissioner. But court commissioner submitted the report.
What was not considered by him?
And I have given memo of instruction stating that exactly in which point I have obstructed flow of water, and also that in which point he has laid a pipeline. That was not shown in the report. Memo of instruction has not been properly considered, and that he says as per the statement of plaintiff.
Let us read that.
Please.
Insofar as objection raised by defendants are concerned, that is, that the commissioner has not acted as per the instructions given by the defendant
Please.
and has not perused the court documents with respect to suit scheduled properties, the commission has answered to the instructions given by the parties by stating that, as per the court documents and the instructions given by both the plaintiffs and defendants near the spot, the sketch has been prepared, but it is the stage where to decide whether the commission has followed the instructions issued by this court. On perusal of the material placed on record, it clearly discloses the commission has followed the instruction issued by both the parties and considered all the documents before finalizing it.
This is the observation of the court. Your Lordship may kindly see. The court observes that, but it is the stage where to decide whether commissioner has followed the instruction issued by this court.
Where are your instructions?
Please. My memo of instructions, at page number. All these documents are in Kannada. And page number 81.
Then how will I read now?
Now, this is one aspect. Secondly, my lord, alternative prayer is at least permit me to cross-examine the commissioner.
That you should have asked the court. Why are you asking here?
Those not specifically asked. We have submitted that, my lord, I may permit it. Oral submission was there, but it is not there on
So
record.
for that, we have to hear the other side and pass orders.
Please.
Notice and summons. Yes,
And
ma'am.
a date may kindly be given.
Hand summons, matter, if the hand summons were filed by 10th of August, 15th of, 9th of September, list the matter on 10th.
Please.
Yes.
Number 21, MB Chandrachуда for petitioner.
The defendant petition. A suit has been filed by the plaintiff before the trial court for adjustment of the premises where the petitioner are in possession. Even we have not been served with the notice in the trial court.
Suit for?
Suit for adjustment.
Oh.
Even before service of the notice,
Hmm.
an advocate who has been suspended from the Bar Council,
Hmm.
which has been confirmed by the Supreme Court,
Hmm.
has been engaged by the defendant at his instance. And a written statement came to be filed forging our signature.
Hmm.
Later on, we came to know that there were our signatures have been forged, the proceedings are pending before the court. We entered appearance
Hmm.
before the court mentioning that we are not engaged in advocate, our signature has been forged, we are not authorized him to do that. And the said advocate has been suspended from the Bar Council of Karnataka, which was confirmed by the.
When he was suspended?
Your last may kindly see the judgment of the Supreme Court.
You can give the dates.
Please. He was suspended on 5/11/2022.
5/11/2022 by the State Bar Council.
Please, it was approved, confirmed by the Central Bar Council. Same was confirmed by the Honorable Supreme Court, page 143, Annexure B. Dated 25th August 23.
When did he file wakalat?
He has filed the wakalat on 20th March 2024. And we brought to the notice of the Karnataka State Bar Council about the subsequent conduct with said advocate.
Understood. Come to the impugned order.
Please, kindly take the application filed by us at page 43.
No, come to the order.
Please. The learned judge, as if it has referred to an application filed by us for withdrawing the written statement. In the operative portion of the judgment, the learned judge refers to that we sought for an amendment of the written statement. Kindly see the order at page 82, last portion. First paragraph refers to an application. Kindly say page 74. Advocate for the defendant filed an application.
Please come to the IA number 9.
Please kindly state the application at page 43, Annexure G. Annexure G, page 43. May I read the application? This was the application filed by us.
Then counsel, the petitioner submits that one advocate has filed wakalat on behalf of the petitioner on 20th March 2024 without their notice and filed the written statement. In fact, he was suspended by the Bar Council, State Bar Council on 5/11/2022, which is affirmed by the Nation Bar Council, and thereafter, that is an order that was affirmed by the Honorable Apex Court on 25th August 2023. And in the light of those, they have come up before the court filing an application under 151 CPC. The court, without appreciating any of these facts, has rejected the application. Considering the submission, they shall be stay of all further proceedings. Notice hand summons.
Swami, C for petitioner.
I'm only seeking for a direction for the trial court to consider my application for vacating the 39(1) and 2 application.
When was stay granted?
My lord, 6/3/2020, 3/12, my lord, 3/12/2025.
When did you file your?
I filed my wakalat on 6/3, my lord.
Subsequent to 6/3 short date, I requested so that the matter can be heard and vacated, the interim order can be considered. The matter was posted to 5/6, my lord. That's
Then-
post vacation. I filed my written statement and objections on that day, and I addressed the arguments also. Then for the plaintiff's arguments, the matter was posted on 5/6, 16/7. 16/7, he does not give his arguments, and the matter is posted on 17/8. Lord, I have addressed the arguments almost 2 months back.
Where are we now? Why should there be a mandamus now?
My
Matter
lord,
is coming up on 17/8.
17th is coming up, my lord, but 1 month last time after I finished argument,
We will, I'll list this matter on 18th. If he doesn't pass order, you can tell the court. List on 18th.
you know, it may come on the fresh matter so that it will.
Yes, on 18th as the first matter.
Bill number 23, Ravi Shankar R for petitioner.
Appear for the petitioner. Now, suit is filed seeking for recovery of money and damages by the plaintiff against defendant number 1 company. The plaintiff was a successful bidder. Defendant number 1 company is a non-banking financial institution. The allegation of the plaintiff is that once he bid for the property and he was given.
What is IA? We don't have to go
The
into all
IA,
of
my
that.
lord, in the plaint, my lord, defendant number 2 and 3 were made parties in their personal capacity. Now, defendant number 3 is an authorized signatory who has just signed on the possession certificate and other documents. He is no way, he has no personal privity of contract with the plaintiff, my lord. And defendant number 2 is a non-existent person. Now, both of these assertions were made, and I had filed an application for deletion of defendant number 2 and 3 because in a civil matter, my lord, an employee of the company cannot be personally made a party in the absence of any strong allegations of fraud. Now, my lord, kindly come to page 22, which is the impugned order. Lord, the reasons are at page 24. However, according to defendant number 1 and 3, defendant number 2 is not the authorized signatory of defendant number 1, and there is no such person in the company of defendant number 1. However, according to the plaintiff, it is the defendants who have scrutinized the suit property and informed them that the title of the property is clear. Whether the defendant number 2 is authorized official by defendant number 1, whether no such person by the name Yellappa in the institution of defendant number 1 is a matter of trial. There is no such person by the name Yellappa in the institution of defendant number 1, then the suit of the plaintiff will go against the said person. However, the fact that defendant number 3 is an employee of defendant number 1 is not in dispute. The fact that defendant number 3 executed sale certificate in favor of the plaintiff acknowledging the receipt of the sale price of 49,10,000 is not in dispute. Whether defendant number 3 is responsible for day-to-day affairs of the defendant number 1 institution or not is once again a matter for adjudication. At this stage, the defendant number 1 and 3 have not placed any material to establish that defendant number 2 has no relation.
Notice to the respondents and summons.
Lord, the trial has commenced in the matter. Tomorrow,
No, please tell the court, what is the prejudice to you?
my lords, defendant number 2 is non-existent person. I have made an assertion that there is no such person.
Correct.
Now,
No, I don't stay the proceedings and the suit will proceed. What will happen?
lords, then defendant number 2 and 3 will have to stand trial. They will have to lead evidence. They will be put to that hardship of
It's a
standing
strong
trial.
point that they paid 49 lakhs and all, and that person has endorsed it. Are you accepting the receipt of that money?
My lords, with respect, Lord, there is a difference between a proper witness and a proper party. My lord, I ask myself, if a decree is ultimately passed,
We will be deciding it, but within 1 week, 10 days, nothing will happen. Notice to the
my lords,
respondents.
can
and
I
summons.
can I request for a direction to serve the learned counsel appearing before
Summons,
the
I
trial
said
court
so.
also? My lords,
Yes.
a date may be kindly fixed. My lord.
Yes, 15th of September. Yes, next.
Bill number 24, Krishna S. West.
For the petitioners.
Yes.
There's a suit in which a decree for partition and specific partition has been sought, my lords. Subsequently, in the year 2025, my lords, the original plaintiff in the suit expires.
What is the present
Interregnum, my
IA?
lords. My lords?
What is the present IA?
Yes, sir. I will explain a backdrop and then immediately
First
get into
you,
my lords. Within
this
10
is for-
seconds, my lords, not more than that. In the interregnum, during the pendency of the suit, my lords, there is a suit which is filed before the small causes court.
Present IA.
That is the IA, my lords, specifically.
What is IA?
The suit before the specific small causes court, my lords, it has been decreed. Small causes court, my lords, is restricted insofar as section 16 of the act is concerned to deal with the suits wherein title disputes are supposed to be decided, my lords. No full-fledged trial has happened. Matter is pending before this honorable court in CRP. Now, my lords, there is an amendment which is sought before the lower court, my lords, to challenge the decree which came to be passed in the small causes court. After this plaintiff, my lords, accrued her right with respect to the said property. That is posterior to the death of her husband, who has filed a partition suit. Suit is for partition between brothers. Husband dies, my lords. In the interregnum, the brother has contended before the
She
court.
seeks the leave of the court to question that.
Decree which has been passed in the small causes, my lords, because the title to the property, my lords, could not be decided.
Provision that application is filed.
My lords,
Under which provision that application is filed?
Order 6, Rule 17, my lords. Order 6, Rule 17, I seek for an amendment.
The suit is decreed.
Suit is decreed in small causes court. Suit is decreed in so far as small causes court, my lords. That decree, my lords, however, the additional district judge, my lords, the small causes court is an inferior court to the district judge. And the suit rightly, my lords, should have been referred from the small causes court to this court for hearing on the title dispute. Your lordships may see section 16 of the small causes courts act, my lords.
I'll understand from the order. Come
Yes.
to the order.
And not only that, my lords, another additional ground had been sought to be brought on record, my lords. Your lordships may get my application at page number 199, annexure H,
First,
my
I'll
lords.
read the impugned order, then we'll go to the.
Yes.
Yes.
Impugned order, my lords, annexure L, my lords.
Page number.
Page number 218. 218. The reasons, my lords, begins from page number 227. The reason which comes to be attributed by the court is, my lords, the earlier proceedings which have happened before the court.
Let me read the order.
Yes, please.
Yes.
Yes. No, my lords. The
First of
backdrop
all,
the
what I am
proceedings
not
is
able to
this.
understand
Yes.
is why should the judgment and decree passed in SC shall be declared as null and void
In
when
this case.
already you are the party and you have already filed a CRP against that?
Yes.
All
No,
the grounds that are available to you, you can raise in the CRP.
yes, I can raise in the CRP, my lords. As your lordships very well know.
A
So
party
far
to
as
the
CRP is
proceeding, a
concerned.
party to the proceedings can never say, declare that the judgment and decree is not binding on me.
My lords, the difficulty there is that, my lords, so far as CRP is concerned, my lords, it is only a revisional jurisdiction which has got a limited scope of
But
review,
can the
my lords.
party to the proceeding say that it is not binding on me?
But the mean profit aspects is there, my lords. Assuming for a moment that, my lords, even if the partition suit is going to go in my favor, ultimately, so far as the judgment of
The main proposition is a party to the proceedings can never ask for this relief.
I am not
On
against
that
that,
it
my
is
lords.
gone. Then the next one.
Yes.
2000 sale deed is in your name, in your notice in the year 2013 itself. Till 2023, till 2026, you don't do anything. Now you say, I want to question that sale deed and all the parties who have purchased the property should be made parties. Where is the due diligence?
Yes, my lords, here, insofar as this application is concerned, it has arisen only after the LR has come on record. Till date, my lords, the wife was not the LR of the original plaintiff who was on record. It is a suit for partition. Necessarily, my lords, all the parties who are interested in the property should have been made a party. They have not made them a party. Now, my lords, as an LR, I have accrued my right to pursue the suit only after the death of my husband. After I come on record, my
Husband
lords,
was pursuing the matter. Now you will not come up with saying that I will, because my husband has not done that and this. You're just stepping in the shoes of your husband. You have
I
you're
certainly
not
agree with it, my lords.
independently-
But in so far as partition is concerned, my lords, I have a vested right with respect to the property. And appropriately, my lords, my son as well as the other offsprings who are there in my proper family, as well as the other LRs, my lords, they should have been made party to the proceedings. Or they have not made, I am not questioned that aspect, my lords. What I am now questioning is that, let it be decided. If they say that there is no limitation appropriate for you in questioning the case, let that be left to the court for answering it, my lords. Because I am raising a point.
Where
The
is
point
it?
has to be considered by the court is all my
When were
contention.
you
is.
impleaded?
Lords, I impleaded in the year 2025, immediately after which my husband, my lords,
When he
dies
died,
on.
he conveniently he dragged on the matter from 13 till now. Court has recorded how your husband has dragged on the matter, how he has not examined the defendants.
No, my lords, there is one difference of opinion in this at this stage, my lords. There, what has happened is my husband stepped into the box through my son, my lords, as PW1. There later there was a difference of opinion between my son and my husband, who was already ailing and bedridden. Therefore, my son, without informing my husband, my lords, he did not go to the court at all. Subsequently, my lords, so far as the defendants are witness to be examined and other
One
aspects, my
fact
lords,
is clear: whenever the legal representatives come on record, the suit
they will be
not,
stepping into their shoes.
No, the suit will not start afresh.
I don't say no, my lords. I am only on this aspect, my lords. 12 to 2025, my husband died, my lords. Later, the suit was brought to my notice. I appeared in the suit. The entire contention, my lords, what has been taken in the suit, my lords, is for partition. Partition, your lordships very well know, my lords, it is a vested right which will flow to the legal representatives of the entire family. Now, in my question, my lords, when I am stepping into, there are so many documents which have not been challenged before the court. Let it be challenged. If there is limitation, if there is an issue of limitation, let it be decided in my favor. If there is no issue of limitation,
There is
let it
nothing,
go against.
there is nothing to be decided. It is within your husband's notice way back in the year 2013.
That is there. They are alleging that, my lords.
Not alleging. They filed a written statement. They've placed everything on record. Where is a question of that is not a matter of trial at all.
My lords, here the question is that, my lords, if any part of my property would be alienated in favor of another person, my lords, even assuming for a moment, I don't challenge that now, my lords. If I have a vested right in the property, that would stay as it is. I don't have a limitation there, my lords. In this case also, my lords, I have sought for a partition of the property. In the subsequent occasion, my lords, if I am declared that I am entitled to so and so extent of the property, and the other fellow says that the property which has to be reckoned is that of extent of property which is left out after the other property being sold, then I will be put to prejudice, my lords. What I am seeking is, my lords, if so far as the sale deed which has been executed by the defendant in favor of other parties are supposed to be held as valid, let it be held valid. Let it not be binding on me. Let me not be allowed to suffer is
The
all my
opportunity
question.
was long back available to you, which you have not availed.
My lords,
Now we will
even
not
if
put
that
it
is a
on back.
matter of limitation, my lords, let them raise an issue on that, my lords. Assuming, my lords, I would be now
Let's not
filing
say limitation. I'm saying due diligence.
My lords, here due diligence also, my lords, so far as the aspect is concerned, I am bringing a particular aspect to the notice of the court after I have come as an LR. I understand what your lordships are saying, that as an LR, you do not have an independent stand. You are stepping into the shoes of the earlier plaintiff. You are bound over by whatever the plaintiff has said before the court. I don't say no. But so far as the partition suit is concerned, my lords, let me take the limitation from the filing of the suit by my husband itself is concerned. I will not say new limitation, my lords. Even assuming for a moment that this honorable court, the honorable trial court would say that so far as the applications, whatever you have filed with respect to that is the bringing of the LRs on record as well as the challenging of the suits are concerned, we will not be considering it because there is no limitation. I have no botheration in that. But let it be matter of record. That is all.
Agreed with orders passed on I number 5 and I number 6. Under order 6 rule 17 CPC and order 1 rule 10(2) of CPC dated 21/1/2026. The 21st order is no question in when did you find this? 3/8/2026.
Millets? The difficulty was that, Millets.
21st January order is questioned in the month of August.
No, Millets, the difficulty was that she is also a senior citizen. She could not arrange for the
Yes.
necessary.
The 21st January 2026 passed by the so and so. The petitioner before this court or the plaintiffs, the LRs of the plaintiffs, the suit is filed for partition. By way of amendment, the petitioner, the plaintiffs want to insert a prayer that the judgment and decree that is passed by the court in SC number 75 of 2012 dated 23/2023 is not binding on them. And the second prayer, the other amendment, what they are seeking is the document. What is the document dated?
Declare the sale deeds dated 14/7/2000.
To declare that the documents dated 14/7?
2000, bearing number, document number 1794 of 2000.
14/7/2000 is not binding on them, which is executed by the defendant, and to implead the purchasers as defendants to the suit. That came to be dismissed by order impugned. While dismissing the application, the court has extensively dealt with the matter and has observed that the suit for the small cause of suit was disposed of on 23/20/23. That they have questioned it, that the father of the plaintiff is a defendant in the said suit.
As well as myself, Millets. I am also a defendant.
And the LRs are also parties to the said suit. They have questioned that by
Only the
filing.
LR, Millets, only myself. Other
Wife
LRs
is also a party to the said proceedings, and they have already questioned it by filing a CRP. Now, by virtue of this amendment, they want to question they want that the judgment and decree in the said suit be as not binding on them. The court has said that such a the petitioner cannot, the plaintiffs can, the LRs of the plaintiff, who are the parties to the party to the proceedings and who are now pursuing the CRP, cannot seek the said relief. Then coming to this 14/7/2000 sale deed is concerned, court has observed that in fact the defendants in the small cause of suit has filed their written statement and in their written statement they have mentioned about all these transactions which are very much in the notice of this the present petitioner, that is the wife, and also in the notice of the plaintiff, that is her the original plaintiff, that is the husband. Right from 2014, no steps are taken, and now in 2025 and 6, the present applications are filed. And the court also has observed that.
That's one selection. the execution of the sale deeds were not within my notice, my lords. It was within the notice of the
Defendant has brought to your notice by filing a written statement in the small causes.
small causes. They were the plaintiffs, my lords.
They are the plaintiffs, you are
They
the
did not bring
defendant.
anything of this, regarding this sale
Yes.
deed in the notice.
I think you can read from the order. I have read it from the order.
No, my lords, it is not so. Because I have also produced the documents. They have not elicited anything regarding the existence of sale deeds in that case, my lords.
Where is the
Only in
written
this case.
statement?
Your lordships must get the order in small causes court, my lords, at page number 59, annexure C. I personally have no knowledge about it.
Further, the plaintiff also claiming that the sale deed dated 14/7/2000 executed by the defendant along with one Prabhu in favor of proposed defendants appears to be well within the knowledge of the plaintiff, as according to defendants, the plaintiff himself has filed a joint development agreement dated 25/3/1996.
That is my husband.
Between K. Balaji, no, further, dated, and the registered sale deed dated 14/7/2000 executed by the defendant along with K.R. Prabhu in favor of the proposed defendant as per exhibit D6 in SC number 75 of 2012. That is a part of the, it is marked as an exhibit.
Yes, my lords. I'm sorry.
That this document is very much marked in SC number 75 of 2012 as exhibit D6. That is on behalf of the defendants. Both the plaintiff before this, the wife of the original plaintiff, who is later pleaded as the LR, have the knowledge of the said document. Now, after these many years, they are coming up with this application, and the court found that there is no due diligence on the part of the LRs. Further, the court has observed that the plaintiff has led his evidence on 19/9/2019 and he has been examined at length. Further, it is clear from the order sheet that PW1 was not at all attended for cross-examination many times, and then his cross-examination was taken as nil. And thereafter, evidence of the defendant has been led. And then again, the learned counsel for the plaintiff filed I number 1 of 2023 for amendment of the plaint, and the said application came to be dismissed on 31/10/2023. Wherein he claimed that he has perfected his title over the sued property by adverse possession. But the said application has been dismissed by the court by holding that the plaintiff had failed to establish, in spite of due diligence, he was unable to bring the said fact before the commencement of the trial and the suit of the year 2013, and the matter is set down for cross-examination of DW1. Thereafter, the counsel for plaintiff filed I number 4 of 2023 and I number 5 of 2023 for reopen the case and recall DW1 for further cross-examination, as the plaintiff had not cross-examined DW1. However, both applications are been allowed, and thereafter plaintiff reported to be dead and the LRs were brought on record. Even though DW1 was recalled for cross-examination, the plaintiff has not at all cross-examined DW1 in spite of sufficient opportunities, and ultimately filed the present application for amendment of the plaint and impleading of the additional defendants. The court, considering all these aspects, has dismissed has rejected both the applications. Agreed thereby, the petitioner is before this court. Then counsel for the petitioner submits that the petitioner had sought the amendment that is sought by the plaintiff is very much essential for deciding the dispute between the parties. According to him, the court has the judgment and decree that is passed in SC number 75 of 2012 is beyond the power conferred on the said court, and as such they have sought a declaration that the said judgment is not valid. What did you say? Not binding on you?
Not binding.
Not binding on
Is said to be null and void.
Is a null and void. It's a null and void. And further, they are the LRs of the deceased. If the other prayer with regard to declaration of the sale deed as null and void dated 14/7/2000 is allowed by the court, it's a matter of evidence and the burden lies on him to prove. It is further submitted that it is a suit for partition, and in a suit for partition, that kind of a strict interpretation of Order 6 Rule 17 cannot be gone into by the court. If this amendment is allowed, no prejudice would be caused to the defendant all these aspects were not considered by the court. Anything else? Were not considered by the court. Next para. Having heard the counsels on either side, there is a material on record. By way of amendment of the plaint, the petitioner wanted to insert two prayers. One is that the judgment passed by the court in SC number 75 of 2012, dated 23/2023, is null and void, and declare the sale deed dated 14/7/2000 is illegal and not binding on the plaintiff. And three, they want to implead the subsequent purchasers, who are the purchasers of the by way of the sale deed dated 14/7/2000 as defendants to the suit. Coming to the first submission, whether that judgment in SC number 75 of 2012 is null and void. The party, the wife is a party to the SC number 75 of 2012. A party to the proceedings has already questioned that the judgment and decree by filing a CRP, which is pending consultation before this court. A party to the proceedings and who has availed the remedy before the appellate court cannot seek a relief that the said judgment and decree is not binding on them, is null and void. The court was right, has rightly considered and rightly rejected the same. Next, the second part is that they wanted an amendment that the sale deed dated 14/7/2000 is not binding on them. The court had observed that this particular document is produced by the defendant in the suit, that is SC number 75 of 2012, and that is marked as Exhibit D6. That is from the side of the defendants who are the plaintiffs in the present suit. And this plaintiff, or the petitioner who is before the court as an LR, the wife of the deceased, is also party to that, which makes it very clear that this is in their knowledge right from the right when the suit is pending. And in those circumstances, why this application is filed seeking amendment in the year 2025 and 26 is not known. There is no due diligence on the part of the plaintiff, and remaining all the contention that was put forth by the petitioner cannot be appreciated. In the manner in which as observed by the court, the manner in which the plaintiff has dragged on the proceedings and the manner in which the applications are filed makes it clear that only for the purpose of dragging on the proceedings, the applications are filed one after the other. This court do not find any reasons to interfere with the order impugned, accordingly dismissed. This court has not expressed anything on the merits of the matter, and the court shall proceed with the matter in accordance with law.
Much of it.
Petition number 25, Subramaniam K.
Petitioner, my lord. Suit for partition and separate petition. This petition file application for 1 Rule 10 to impleading the proposed respondents. Issue notice to respondents.
Who is he?
I am impleading respondent.
You are impleaded.
Yes.
Come to the order.
As per annexure E, my lord, is 80, number 85.
Page number?
85. IA number 25 and 26. In page number 94, my lord, type.
94 is the order.
94. Plaintiff, we have applied IA number 25 under order 6 Rule 17 of CP seeking incorporated the pleadings in the inserted the Jigni village place and Muttap village pertaining from the shoot schedule property, and they further sought to incorporate the pleadings as alienated in the made by the dependent number 58 relief of the sought sale deed executed in favor of the dependent number 58 is not binding on them. Proposed dependent number 65 has filed he has come up with IA numbers 26 under order 1 Rule 10 to seeking for impleading him suit schedule property.
What is this PD? PD means?
Proposed dependent. Yes. The Srimati Ratnama has filed a present suit for against the or brother seeking partition, but the proposed dependent number son of the plaintiff and sought impleading him the sense the present proposed dependent can have no right need during his lifetime of the father plaintiff necessary party. Thus, in the circumstance, IA number 5 seeking amendment, plaintiff is allowed prejudice the cause of no side. Accordingly, pass the following.
Why you want to be implemented in the suit?
My maternal grandfather has executed will in favor of me.
Hmm.
That's why I plead the application.
Take out notice. Notice to the respondents and summons.
Number 26.
Here for the petitioner.
Yes.
Your lordships will recollect yesterday your lordships had asked me what is the stage. This is a suit for specific performance defendants.
It's a judgment.
Yes, my lords. This is for, it's posted for judgment, my lords. I'm relying upon one judgment.
Take that. Yes.
Para 15, my lords. Page number 280, internal page number 284. May I just read, my lords?
Yes.
The learned counsel for the respondent contended that once the arguments are commenced, there could be no reopening of evidence or recalling of any witness. This contention is raised by extending the convention that once arguments are concluded and the case is reserved for judgment, the court will not entertain any interlocutory applications for the kind of relief. The need for the court to act in a manner to achieve the ends of justice, subject to the need to comply with law, does not end when the arguments are heard and the judgment is reserved. If there is abuse of process of the court, or if interests of justice require the court to do something or take note of something, the discretion to do those things does not disappear merely because the arguments are heard either fully or in part. The convention that no application should be entertained once the trial or the hearing is concluded and the case is reserved for judgment is a sound rule, but not a straitjacket formula. There can always be exceptions in exceptional or extraordinary circumstances to meet the ends of justice and to prevent the abuse of process of court, subject to the limitations recognized with reference to the exercise of power under 151 of the code. Be that as it may, in this case, the applications were made before the conclusion of the arguments.
Actually, the court has, has considered more on this matter is posted for arguments. Only at one place, it is reserved for judgment is like it's a passing remark.
What had happened is, in this facts and circumstances, the matter was posted for arguments. But there's a finding as to whether if the matter is posted for judgment, will it curtail or it will stop the hands of the court to
That's
take
what
on
I'm
any
saying,
application.
except at one place, also including reserved for judgment. If you read the further paragraph,
Yes, ma'am.
it only deals with because it is posted for argument.
Lord,
Look at that.
yes, ma'am.
Para 16.
My lord, I do agree, my lords. There is the findings is with respect to arguments, but they have, however, also given a as to if the matter was posted for judgment, what the court should do is also
That
something
judgment, the division bench judgment is straight on the point where the matter is posted for, it's for pronouncement of judgment.
that in that judgment, my lords.
There is a clear order in that, and we have been following it.
My lords, may I just pass on two judgments which have relied upon this, the same court has relied upon the 2004 division bench judgment. And to meet the ends of justice, they have proceeded to allow the application and recall the order. Can I just pass that on, my lords? My lords have 2010 SEC.
Ramakrishna Reddy.
Yes, my lords. My lords may kindly take paragraph number 5, my lords. Learned counsel appearing for the respondent did bring to my notice the decision of so and so. I have perused the decision. In the facts and circumstances of the case, the ratio laid down therein has no application. In order to do justice to both the parties.
A learned single judge cannot say that.
My lords, I understand, my lords, but
It's
two coordinate benches of this court, my lords.
Two coordinate benches also cannot say something which is contrary to the division bench.
My lords, that's the reason I'm relying
And
upon
they just
the.
simply say, it will not apply to the facts of the case.
My lords, may I just take your lordship's attention to
Please
the.
understand that the judicial discipline requires that an order of a division bench has to be followed.
That is the reason I did not want to produce this.
Problem is simply we can't say it doesn't apply to the facts. How it doesn't apply has also to be stated in the order. Not both the orders which you are relying on, they don't say, just say substantial interest that will not apply. So I will grant you that.
My lords, that's the reason I did not want to produce this. That's the reason I still want to rely upon the 2011. My lords, today this is a case of suit for specific performance where certain conditions about consideration of 4 crores has to be given to me. That is not done so. Now an addendum which is filed in the year 2019, the sale agreement is of the year 2013.
When was this order passed?
My lords, it was passed on 19th of June 2026, July 2026. And I've filed my writ petition within a week, my lords. In fact, I've brought it to the notice of the trial court that there's a writ petition pending. However, the trial court has proceeded to pass and post it for judgment, my lords.
Give that order sheet.
My lords may kindly take page number 2 of
You have
this
taken
memo.
time from July to comply with the official objections itself
My lords,
till 6/8/2021.
I don't want to point fingers at the registry, my lords. I had filed an IA for dispensation. Off the record, my lords, I had filed an IA for dispensation on 17th of July. That was lost. And only on that ground, the registry did not post this matter. And in fact, I personally had moved this matter before your lordships thrice. I just passed on one memo, my lords. May I just. Page number 2 of that, my lords, a daily order. Counsel for defendant files a memo stating that they have preferred writ petition so and so. It is submitted to the counsel for the defendant that the case will be listed tomorrow, hence the case may be adjourned. I have brought it to the notice of the court.
No, but court is not.
Well, I agree that the court is not bound because there's I have no order, my lords.
Because
But
unless and until there is an order, they can't.
yes, my lords. Yes, my lords. But,
Pendency of a writ petition is not a ground.
my lords, but may kindly see the order, my lords, at page number 24, my lords.
Yes.
It is filed. It is passed on 19th June 2026. On 27th June 2026, in 4 days I filed. There's a weekend after that I filed my writ petition once I obtained the certified copy, and I've notified the trial court also and moved my lords now.
Try for another Supreme Court judgment which says that matter when it's posted.
My lords, may I kindly just read that the 2011 judgment just once
I've
again?
seen it. I've seen it. Except that at one place saying reserved. After that, if you see what is the ratio, the court is dealing with the case which is posted for arguments.
My lords, however, they have commented on what happens when it is posted
What
on
happens
judgment.
is that cannot be considered as a ratio laid down by the
My
court.
lords, may I kindly see, my
What
lords.
was dealt by the court, some passing remarks in the judgment, they won't.
Well, this is not a passing remark, my lords.
Come to the order, what is the issue before the court?
Para 22, my lords. Para 21, in fact. Ideally, the recording of evidence should be continuous, followed by arguments without any gap.
Come to the facts at page 279.
My lords, there's a suit for money recovery.
Yes, leave granted, respondent filed a suit for specific performance, where the facts were dealt with.
Yes, my lords. Para 3, my lords.
Yes.
The suit was filed on 26/3/2007. The written statement was filed on 12/9/2007. Thereafter, issues were framed. Both the parties laid evidence. On 11/11/2008, when the arguments were in progress, the appellant filed 2 applications, numbers so and so. The first application was under 151 of the Code of CPC, with a prayer to reopen the evidence for the purpose of further cross-examination of PW1 and the attesting witness.
That is precisely is what?
My lords, I'm not disputing the facts, my
No,
lords.
not the facts. It has gone before the Supreme Court. The facts of that case are, when the matter is posted for argument, reopen and recall were filed. That was what is dealt with by the court. Then
Yes,
that's what the ratio laid down. Court never dealt with the reserved matter at all. If you see, except at that place, You will not see that reserved matter, when the matter is posted for judgment, you will not find anywhere. Because that is not the ratio in that.
May I just read para 21, my lords?
Yes.
Ideally, the recording of evidence should be continuous, followed by arguments without any gap. The court should constantly endeavor to follow such time schedule. The amended code expect them to do so. If this is done, applications for adjournment, reopening, recalling, interim measures could be avoided. The more the period of pendency, the more number of interlocutory applications, which in turn add to the period of pendency. Para 22 minutes. In this case, we are satisfied that in the interest of justice and to prevent the abuse of court process of court, the trial court ought to have considered whether it is necessary to reopen the evidence, and if so, in what manner and what extent further evidence should be permitted in exercise of its power under 150 on the code. The court ought to have considered as to whether it should straightaway recall PW1 and PW2 and permit the appellant to confront the said recorded evidence to the said witnesses, or whether it should first receive such evidence by requiring its proof for authenticity. With respect to this facts and circumstances, I file IA number 28 under Order 7 Rule 14A to produce additional documents.
Case has traveled further.
Yes, my lords, I just want to give this background. I file IA number 28 to get a forensic lab report on record. Now that has been rejected, and I am the order on IA number 28. Your lordships will find at page number 226, my lord. Sorry, 260.
I heard you.
My lords, my hands are tied, my lords. My lords,
All taken
for no
in the-
fault of mine, my lords.
Yes.
My lords may kindly see, I filed the writ petition within a week. It's not that I've been a diligent litigant, my lords.
I'll consider all that. Dismissed.
My lords, may I kindly request, my lords, two submissions. I'll just point out what is it that I want to send to the forensic lab, and then your lordships may kindly consider.
No, I'll record all your grounds in the order. That's why I'm not dictating the order now, because it will take time. I'll record all your grounds that you have taken, all the judgments you have recorded, you have placed on record. And still I'm not
My lord,
convinced.
virtually, my lords, then today, my lords, the trial court will bulldoze me and post it for judgment, my lords, and I'm left remediless.
Posted for judgment, you are saying?
My lords, my lords, it's not that I take time to argue.
For judgment, the court will only pronounce a judgment. Nothing will happen. No other steps in between.
My lords, then my defense, my lords, the reason why I want to rely upon the IA number 28, an order is passed, where I am not allowed to rely upon the forensic report because of the fact that it's by a private lab. I agree. Okay, I concede. That's the reason I file IA number 29. That is the impugned IA. And I seek for only indulgence for the specimen to be sent. Now, the IA number 28 comes to be rejected. And as well as IA number 29. Virtually, I am not allowed to put my best defense forward, my lords. There's a specific order, specific issue that has been framed to that effect. Only to discharge the burden on me, I have to lead this evidence, my lords. And I've brought it to the notice of the court.
Yes. Dismissed. Next.
My lords, may I request one indulgence, my lords? Let me have the liberty to challenge, take up any contention. In case a decree is passed against me, in any case, if a decree...
That I have said yesterday itself.
Sorry.
I said yesterday itself.
Let that be recorded.
Yes.
I'll be in the liberty to challenge.
Yes, next.
I seek leave to appear on VC, my lords. Senior is in another court.
Yes.
I appear for BS Karthikeyan, my lords.
Yes.
For this count.
I think you were not there yesterday.
Yes, my lords.
What are your instructions?
My lords, there is an MFA order dated 25/9/2025 that permits only works to be carried out for the Schedule A property, which is the building. But there is no, a status quo has been ordered against Schedule B property, which are the flats. The work order is against the entirety of the building, my lords. So we will abide by the MFA order, but in case the quashing happens, my lords, if the work order that they've sought for quashing gets quashed, it
what to do as an interim order, I'll record your submission that you will only be restricting it to Schedule A property, but not B, as per the order passed in MFA.
Please, ma'am.
Then counsel for the petition is before this court. I'll keep this writ petition pending.
Please, ma'am.
Then counsel for the petitioner submits that contrary to the orders passed in MFA number
52009 of 24.
5209 5209 of 2024 dated 11/7/2024. Where is that order?
Page number
Annexure
Page number 44, my lord, 47, my lord.
47.
Order wherein
25, 925.
Where do you get that order?
Page number 47, my lord. Annexure C, my lord. Page number
Wherein-
47.
Wherein an order was passed, an interim order is passed. That the interim order is only with regard to, that is the status quo, is with regard to the B schedule property, which consists of 5 flats. The grievance between the plaintiff and defendants is only with regard to the B schedule property. Therefore, the interim order earlier granted is modified to the extent that the appellant shall not cause any obstruction to defendant number 2 to 5 for getting electricity connection and other amenities on the A schedule property other than the B schedule property. And counsel for the petitioner submits that now the respondents have issued a work order by virtue of which they have given their work in respect of the entire, in respect of both A and B schedule property. Then counsel appearing on behalf of respondent number?
Only one respondent.
8 to 11.
Discount.
Respondents 8 to 11 submits that the work order is, he does not dispute the fact that the work order is issued both in respect of A and B schedule properties. It is submitted that in the light of the order passed with the division bench, now they'll be executed, the order will be strictly executed only in respect of A schedule property. And he will come up with his objections. Yes. Notice to other respondents.
Number 28. Jana CH for petitioner.
Worship, may I make one submission, my lord. Tender my apologies. In fact, though I've been aware of the matter, my lord, facts of the case, the senior counsel Srivatsa has been engaged. And in fact, he has been on his legs in, may I request the court to take the matter on for Monday, my lords. So however, the inquiry has been, the matter has been posted in the last, on the last date of this month. So there's no proceedings going to take part.
No, I have no objection if my learned friend wants to take time, but I'll just recapitulate what was my submission before. This is a matter where there was,
Argued that day.
yes, no, this was a matter where a compromise memo was entered into between the parties. The compromise simply records that they have to construct this building within 24 months. If they do not do so, title deeds have to be deposited back. Number, they did not do so, admittedly indisputable.
You filed execution.
Yeah, now they want an inquiry to be held. I am also for an inquiry. All that I'm saying is kindly not visualize what will be the nature of the inquiry, give a timeline and matter may be discussed.
I'm very well, from the day when they objected for the inquiry. In fact, lots,
I'm saying, I have told my learned friend, we should not object because in view of the electrolytes judgment, the inquiry is very limited. The question the court has to see is whether they constructed or not.
No.
And one second, sir. Allow me to complete.
Yes, yes.
I'm
so
making my
sorry.
submission.
I'm so sorry. I'm so sorry.
Honorable Supreme Court. The compromise memo says that if you do not do so, the memorandum of understanding stands dissolved. That is the scope of the inquiry. That is what Lordships may direct the trial court to look into it and fix a timeline. I have no objection. Ultimately, these matters should go to their logical conclusion. This is the 7th application they have filed, 3 suits, 2 MFAs, 2 SLPs. But we are subjected to about 14 litigations for simply not this. Therefore, my request is this.
May make one submission. As the senior counsel expressed, there's a compromise petition what has been entered. No doubt there is stipulated time has been fixed to comply or complete the project. There's one clause where it says there's a force majeure. If there's a force majeure clause, and if I'm not able to complete with it within the stipulated time due to the force majeure, this is a question of I was supposed to develop the land within 64 weeks. And I need to take a permission from the sanction from the government statutory authority within few months. See, where the government passed in a government order was there, GO was there, and a notification stating that, and due to this landslide, no sanctions for development or for any further progress of any lands shall be permitted until further orders from the government. Now I have been stuck. Subsequent to the compromise petition, immediately next month this order was passed by the government. So where I'm going to get the plan sanctioned? Now they say that you should have completed. Without plan sanction, how can I complete? Now the whole question is that I was not able to complete the project because of this landslide, as the government did not sanction or grant permission or sanction license for the plan sanction. Now without plan sanction, can I go on with the project? That's a simple question has to be looked into it. Now they filed an execution sought for their time, and again they come and say that we keep litigating every time. Where is the bar if I am being aggrieved by the orders? Where is it has been barred to question before this court? And there's one direction from the honorable this court itself. Justice Devdas in one of the applications where they have sought for the deposit of title deeds. It has been clearly said that inquiry, a detailed inquiry has to be conducted. Now, in view of that, this review, without looking into that order, the court has passed an order where we have sought for an inquiry. We are not going to see, however, in the execution petition, what has been awarded, what has been decreed, that cannot be questioned. Now, the only scope is that now the order or the decree is there. One has to comply the decree. If I fail to comply the decree, why I did not comply the decree has to be looked into it. That has to be looked into.
Now the Learned Senior Counsel says that the inquiry may go on.
Yes.
As per the settled law.
Yes.
What is the scope of inquiry
Yes.
is limited, that should be done.
Yes.
Yes.
In
Judgment.
Yes, in the teeth of this judgment, kindly.
May make one submission. That's the reason in the initial stage itself I said I tender my apologies, my lord. So
May I
because
request
I've
Lordships to
been
asked.
asked.
Page 96, not para 21.
Please look at the judgment.
I've given it. Page 96, para 21. This is the latest one, MMTC Limited. But they concur with the earlier judgments of the Honorable Supreme Court.
Para number?
Page number 96, para 21.
Mm.
In conclusion, this court on the said issue held that objection to execution of an award under section 47 was not dependent or contingent upon a petition under 34. Ultimately, insofar as electrosteel was concerned, the appeal of electrosteel was allowed in view of the provisions of IPC, particularly section 30 and 31. It was found that the Facilitation Council did not have jurisdiction to arbitrate the claim after the approval of the plan. Kindly see the next paragraph. Electrosteel held that any challenge under 47 would lie within a narrow compass. It has also been held that at the stage of execution, an objection as to the executability of the decree can be raised, limited to the ground of jurisdictional infirmity or voidness. It has been further held that errors of facts and law cannot be the subject matter of objection under 47. This is the declaration of the law. Next paragraph also gives an example of what could be the objection. In Vasudev Dhanjibai Modi versus Rajabai Abdul Rahman, it was held that the executing court cannot go behind the decree. It was also held that where a decree is a nullity, for example, in cases where it is passed without bringing the legal representatives on record or made by a court which inherently lacked jurisdiction, objections can be raised at the execution stage. Now, in all fairness to my learned friend, I'll just point out what my learned friend is pointing out. Kindly see page 315. What is the nature of the compromise? Which 315. Kindly see page 325, 326, clause 21.
Yes.
The parties agree and confirm. Lordships get it? Para 21. Page 326, Roman numeral 21.
320?
Roman numeral 21, page 326.
26. Yes.
Please. The parties agree and confirm that in case of failure of completion of the tasks as per Annexure C for a continuous period of 8 weeks, the timelines decided, as per the timelines decided, it shall be open to the claimant to notify that the compromise entered into between the parties to joint development agreement dated 28/6/2013 and memorandum of understanding dated 24/6/2013 and general power of attorney to be registered as per the compromise petitions are cancelled. Consequently, the project implementation would stand halted on account of cessation of relationship between the parties as the owner and developer in respect of the scheduled land. The respondent shall return the original documents and the claimant would refund the deposit of rupees 7,50,000. I'll also ally the fears expressed by my learned friend.
Now, what he says is this annexure C timelines. Obviously, let the trial court look into this. I have no objection. The trial court look into the question whether he has adhered to the timelines of annexure C within 8 weeks. If it has not done so, the consequences flow. Now, what they want is not ultimately, contrary to the judgment of the Honorable Supreme Court, they want to go behind and say what prevented them from doing so. That cannot be the scope of an execution petition, because the award itself does not contemplate that such a situation. It does not give them the leverage to explain the inability to perform.
In that case, where is the point of remanding this matter to the court?
No, not because.
If I say no,
That
as good as saying that, you just have to know court can't go beyond that as per this judgment. When if the court is saying that court cannot go beyond the point, no, whether the force majeure clause is
Yes,
there,
yes.
whether they could do it and all. If that is not part of the inquiry, what inquiry the court will conduct?
No, but now the reason brought.
In this case, what they are raising is only that ground.
I'm sorry, I couldn't hear.
What they are raising is,
Yes.
their ground is that because of some events, they could not conclude the contract.
Yes.
So it does not amount to, no. They have not violated any terms of the compromise, is their case.
True.
According to you, in the light of this judgment,
Yes,
they
ma'am.
cannot consider all that.
Yes, ma'am.
They
That's
have to only look at whether the jurisdiction aspects and other things.
true, ma'am.
This won't find under that. So
Yes, ma'am. It
what
does not-
inquiry the court would do is the question.
No, the reason is this, ma'am. Why
Are
I
we
mean,
demanding the matter for the sake of remanding? Or
no,
really
it's not.
the-
So it is not, certainly not. So I'm only, though in principle they have challenged the order directing an inquiry itself, but I, my lords, thought it is for us to concede that yes, it is true an inquiry must be held. But what is the scope of an inquiry is something that I have assisted your lordships based on the judgment of the Honorable Supreme Court. Only for that reason. But it would only relegate the parties to a fresh litigation.
Case, if this court gives a finding on that and fixing the contours of the inquiry, then
Lord, may I make this submission in the alternative? Lordships may direct the trial court, lords, to dispose of the inquiry, keeping in mind the judgment of the Honorable Supreme principles laid down. That I don't think, Lord,
the light of the settled law.
the red law as decided by MMTC judgment, but that should be.
Is what
I
you
don't
said.
think any.
No. May make one submission. In fact,
But this was more of a concession by me. In fact, they had wanted to challenge the whole law, but I said, no, let them inquire.
no, in fact, my lords, at page 20, whenever they read the compromise decree or award, they skip this clause 5, which is at page 20. I mean 320, my lords. And there is another clause where it says, if this contract closes, out of the 15 acres and 90 cents, 2.5 acres land has to be registered in
But
my
I have
favor.
no objection.
No. Let me complete.
I have no objection. I am
You have
considering-
already executed a sale in favor of third parties. The entire land they have sold it. How could they sell? They have sold it.
What I'll do is, I'll say in the light of the settled law,
Yes,
that the court conduct the inquiry.
Only as request is not a timeline. no?
Yes. So no prejudice to you.
No, I think, my lord, now.
They have questioned
they
it.
don't
No, they
want
say that they're okay going ahead with the inquiry. So I'll remand the matter.
With
Very
an
well,
Let
inquiry.
the court remand the matter in the sense I said that petition, I do not find any reason.
Disposed of, lordships may say, Lord,
Disposed of,
with the
that's what.
direction to them to conduct an inquiry in the limited period, but keeping in view the law
How much
later,
time?
3 months. But they have taken 7 years. 7
No,
years.
no,
Now,
the learned senior counsel.
I am not making any observation.
my
on the
plight,
order.
Lord, my plight. I'm only-
Yes, please. come.
See, they enjoyed everything benefit from me, my lords. In fact,
Presented petition is
Yes.
filed. Questioning the.
Supreme Court, Supreme.
but may make one submission into my lords. In fact, during the course of this, I've also filed an impleading application where the subsequent purchasers to whom they have sold the entire land, where they were supposed to give us 2.5 acres of land during the course of this execution. So those proceedings, whatever the inquiry might be, my lords, 3 months, we are fair enough. We'll take part in the inquiry in whatever manner the court grants time, my lords. But in the due course, they should not, taking advantage of this, they should not bar in proceeding with the legal course of actions what we initiate.
No, that is not the scope of this writ petition. The writ petition is filed. Questioning an order dated 30/4/2026, passed in I number 7 in execution petition number 1075 of 2020. 2020 by the third Asian City Civil and Session Judge Bangalore. By order impugned, the court,
Has recalled its earlier order for an inquiry.
the court had allowed this, allowed the application and reviewed the order dated 22/1/2026 as recalled the earlier order dated 22/1/2026 and also ordered to hold an inquiry as per observation of the observation of this court in WP number 20089 of 2024. Both the senior counsel representing the counsel for the petitioner, also then counsel appearing for the respondent, have argued extensively on the merits of the matter. Considering the fact that the court has only ordered for inquiry and looking at the facts and circumstances of the case, that this court is of view that is very much essential. Hence, this court is passing the following order. The writ petition is disposed of, directing the trial court to the executing court to complete the inquiry initiated in section 47 of the CPC within a period of 3 months from the date of receipt of the copy of the order. Both the parties shall cooperate with the same. It is made clear that the court has not expressed anything on the merits of the matter.
But that MMTC judgment, Lordship said, as per the settled law relating to execution. Lordship may just make the
First and foremost, my lord, I can't go behind the decree.
Yes, that is the position of law.
I can't go behind the decree. There will not be mentioned.
And in the light of the latest judgment of the, where do you get the cost rate?
Yes, MMTC.
May make one submission. My lord. The problem with my lord, even in fact, earlier when I tried to convince the court with the Justice Devdas judgment, my lord, they kept on saying that the inquiry was with a limited purpose of general power of attorney. Now, quoting this, the court will again, I don't know how many times.
Whatever is the law of the law like declared by the Supreme Court cannot be at the matter of dispute between us. But page 78.
For that reason, I've actually said, in the light of the settled law.
That's all.
Lordships may, all that, at least Lordships may record that I have cited this judgment.
No,
It will become page
this
7.
goes against me in the trial court.
Lordships may at least
I
record
cannot express
that
few
I have
things before
cited
how the trial court thinks about.
I'll record his submission.
Yes.
In his submission, counsel for the senior counsel submits that the court, the court has to conduct the inquiry as per the law laid down by the apex court in MMTC Limited versus Anglo-American Metallurgical Coal Private Limited, reported in 2026 3 SCC 99. Then when it comes to the operative portion, in the light of the settlement.
Please. Para 20 is the operative. Para 20 is the operative. Para 20, no, Lordship said operative.
Order of the operative portion of my order.
Very
grateful.
Yes.
And then for the respondent, my lordship.
Yes.
Have instructions? Mandamus, my lordship. Kindly give.
Similar matter, earlier direction has been given as per
What is
annexure.
this? What is the?
Mandamus to power connection, permanent power connection to the
When did you
petitioner's
make
house.
the application?
Application
To
3/7.
cut the application filed with
3/7.
the petitioner on 3/7/2026.
Mm.
How much time it takes to consider an application? Minimum, they require 4 weeks to look into everything. And even before that, you are here.
In this matter, they are not granting without our court's
No,
order.
you say that your representation itself is dated 3/7/2026.
But normally that is this.
You should have come on 4/7 itself. You have a little late.
In this matter, what happened? Annexure H, similar matter was granted.
Not about similar matter.
There is a litigation pending in this land. That's why the authorities are not considering the application unless there is a direction by the court.
You should give them some reasonable time. With the just go to their office and straight away come to the High Court. That's not right. What do you say?
Kindly give the direction, my lordship.
How much time?
2 weeks.
The present writ petition is filed. Seeing the following prayer. Then counsel for the petitioner submits that when an application is filed seeking the permanent power supply by representation dated 3/7/2026, the respondents are not considering the same. It is submitted that in respect of several similarly situated persons also, when the same was not considered, they have come before this court. And mandamus was issued to the respondents. Next paragraph. Then counsel appearing for the respondent submits that.
Subject to the result of the writ petition numbers 220501 to the 23, my lordship. Subject to the result of the.
Why it should be subject to the result?
My lordship.
It is a question of the disposal of representation subject to the result. What the court will
My lordship.
decide. Main relief itself is the consultation of the representation. There is no subject to result. It is submitted by the land council appearing for the respondent that they'll consider the representation within a period of 2 weeks, considering the same. The petition is disposed of, directing the so and so to consider the representation within a period of 2 weeks.
Then number 30. E.G. Prakash of petitioner N. Devaraj.
Petition on the matter.
Yes, where is the affidavit?
Yes, my lords. There was one
Take
small
that
error. The party I'm not able to get through. 2 lakh and odd was the cost which was imposed, my lords. Proceedings, what we are supposed to pay. That I could not place it. Otherwise, the other things are, my learned friend has accepted whatever my calculation.
They are seeking 6 months time, my lords.
Hmm?
They are seeking 6 months time in the affidavit.
Other day you said 3 months.
Yes, my lords. I had made a request to my learned friend if you can give us some waiver, which my learned friend spoke to his client and they were not able to term. That was the reason why he had to ask for 3 months more, my lords, because he has to sell this property and then he can realize the money.
But I'm making it clear, in cases of these undertakings, I will say, if the order of the court is not
The
complied
last
with,
line, my
then
learned,
another cost of another 25 lakhs for them.
my lords, the last line I've stated so much because I understood what's the mind of the court. I state that the understand that the violation of this undertaking will have the respective consequences I have stated.
MOU, my lords, I have paid the amount here 2019. Lords, award was passed, my lords, in the month of India 2024, March 24. Lord, let them pay half of the amount. Lords, after all this process, he did not participate. Lords, he enters appearance. He did not.
No, anyway,
Let him pay 50%.
You're seeking 6 months' time. In between, after 2 months, you make some payment.
Lords, the only source he has is this, my lords. Even 15 days, within 15 days, we are able to sell, we'll settle the entire amount. That's not the issue, my lords. The problem is now that this is subject matter of the first IA, which is pending before the court, where the spot sale is fixed. I have to go make an application by pursuance of my lord's order to indicate that we are ready to sell the property. And if there is no hindrance from my learned friend's client, we will put it for sale by ourselves and realize the money, my lords.
From 2019 till 2026, you are waiting for this, to realize the money.
Yes, ma'am.
If it is happening in 6 months, and also I'll incorporate a clause that if this order, for the sake of buying time, they can't file the affidavit.
Yes, ma'am.
I will say exemplary cost of 50 lakhs. If they don't comply with this order as on the date. We'll fix a date and I'll make this matter and then we will do.
My lords,
I'll
may
make
keep
it
it
a
pending,
part-heard.
lords.
I'll make it a part-heard and
Please,
keep it on that day. Whatever is the date for.
Day before yesterday, my lord, they sought 3 months time. Now, my lord, this is 6 months time. My lord, they are tomorrow, my lord.
It's for you. If you want again to litigate, then it's for you.
No, my lord.
That's what I'm saying. After 6 months, we'll keep a date and I'll keep it as a part-heard.
Yes, my lord.
And that day, then I'll also say that by the time they have to pay for the violation of any of the terms and conditions, 50 lakhs.
Yes, my
lord. And what about the 2 lakhs is saying something?
We wanted him to give some.
It has been incorporated, my lord.
We wanted him to give us some.
Record that. I'll record
If it is 6 months, my lord, then they have to add 6 months interest also, my lord, at 24% interest. Yes, my lord.
May I request one thing, my lords? I will come out with the fresh calculation with respect
No, my lord,
to.
let it be ordered, my lord.
No, today itself I'm saying, I'm not.
Let it be ordered.
I will not come in his way.
If it comes up with calculation, there will be some.
No, my lord, only cost 2 lakh, 1 lakh, 2 lakh 1,000 has to be inserted. That's it, my lord.
2 lakh?
2 lakh 1,000, my lord. For 470.
1,470.
Yes, my lord.
The present petition is filed, seeking the following prayer. It is submitted that by virtue of this order, now they are going to put the property to auction.
Yes, my lords.
Property to auction.
It's already ordered, my lords, but then there was no takers on the one day when it was put to
No,
auction.
they are going to put the property to auction. It is submitted that the petition is in fact ready to pay the entire amount and you will sell the property.
My learned friend should not object for us to put it to
No,
auction
no.
because the court sale did not happen. If that is incorporated in the order,
If they will sell the property and pay the entire amount. Then what should be recorded from your side?
No, there are no objections, my lord.
It is submitted that they want the money and right from 2019, they have been waiting to realize, they have been trying to realize the amount. And if the amount is paid, they have no objection. When the matter came up on the last occasion, the land council, the petitioner submitted that within 3 months, they'll pay the money and they'll come up with an undertaking. Today, an undertaking affidavit is filed, wherein it is mentioned as 6 months. Land council appearing for the respondent submits that. Now, earlier, the submission was 3 months and then now they have come, now they are seeking for 6 months' time. Further, it is submitted that an amount of rupees 2,01,470 towards the cost
Cost of the
was not included. Further, now when they're seeking for till 6 months' time, the interest on this amount that accrues at the end of 6 months also needs to be included along with that. In response to that, land council for the petitioner submits that by oversight, they could not include the amount, and they have no objection to pay the interest after 6 months. When after whatever accrues for the 6 months' time,
Till the date of payment.
till the date of pay. That is 6 months only.
In case if I am able to pay it earlier.
Till the time they pays, that is before 6 months.
Before 6 months.
Considering the fact that the petition is ready to pay the amount, and as submitted by the council, instead of 3 months, it is stated 6 months. But considering the litigation between the parties from the year 2019, this court deems it appropriate to pass the following order. The impugned order dated so and so is state as per the undertaking affidavit filed before this court. This is August. Today is 11th.
Feb, my lords, Feb.
It will be
My
February.
lords, keep it as Feb 10th, my lords.
Huh?
Feb 10th, February 10th, my lords.
By February 10th, the amount as per the undertaking placed by before the court plus costs of 2,01,470 plus the interest that accrues on this amount for 6 months shall be paid by 10th of February or else, 10th of February, or else the petitioner and the violation of this order will be viewed seriously, and also the petitioner is liable to pay costs of rupees 50 lakhs.
But that will be taken as part of my lords.
Please.
This is Madras Parter.
Great. One direction that we should be allowed to.
The petitioner, clause number 4.
Well, by my submission, I have no objections, my lord. First day itself I told. That will be recorded, my lords.
Shall be permitted to go ahead with the sale of the property.
Yes,
great.
Then number 31.
Your Lordship, mine is serial number 92. I have grave urgency, Your Lordship, if it may be taken at 2:30.
She's calling the list. She called 31.
At 4 or 2:30. On the last 3 dates of hearing, I've been.
Parter is still going on. She called item
My
number
writs will become
31.
infructuous. Apologies.
Yes.
Petitioner. Well, this is a dependent's petition. Both courts held against me, granted injunction order confirmed by the appellate court. I am before your lordships. May take your lordships to the reasons assigned to show that there is a prima facie case against me. May take your lordships to page 88, the trial court's order at para 13.
Or shall we go to the appellate court's order? Or the
Appellate
trial-
same, my lord, the findings, my lord, both the courts almost similar finding was given.
So we'll go to the appellate court's
Please,
order.
please.
Where is the relevant?
Relevant, your lordship will get it.
Is it para 21?
18 onwards, I think.
18 onwards. Yes.
Para
We'll read from para 18.
18.
180.
Please, it is apparent on the record that the plaintiff is claiming possession of the suitable property, land bearing 174, measuring 2 acres. It is further pertinent to note that defendant 3 claiming to be the purchaser of land bearing 174/2, measuring 5 acres 20 guntas, and land bearing 174/3, 2 acres 10 guntas. Both properties are altogether different. It is also further pertinent to note that it is admitted by both the parties that the land bearing 174 is a larger extent wherein they are claiming the ownership and possession over the portion of the property. It is therefore in a suit for bare injunction. Title is immaterial, and what is required to prove is the actual physical possession and over the suitable property, since the trespasser also can maintain the suit for injunction as held by the Honorable High Court, Karnataka, and so and so. Wherefore, the suit property is capable of having physical possession.
What is the nature of the property?
Agricultural land. But therefore, my submission to lordship is, if your lordship were to see 2 paragraphs of the trial court, it will give a clear picture of the entire case.
Yes.
Para 13, page 88. But only 2 points I will make a mention. They claims a grant of 1978. Up to 1983, there was RTC records in their name from
Grant of year?
1978. Whereas my title, I traces my title from 1967 by registered sale deeds. And 83, up to 83, the RTC stands in their name. And later it was discontinued up to 25, 26. And they filed an application before the Assistant Commissioner for change of their entries, I mean to enter the records of rights. He has granted it. That order came to be stayed by the Deputy Commissioner. And now the trial court holds that. And both courts, trial court specifically says that.
So what are the documents filed by the plaintiff to show?
That is grant certificate.
As on 2026 is in possession of the property.
No, that's what RTC only. Changed only on 25, 26. That was also stayed by the Deputy Commissioner.
That is the basis?
That is the basis. And between 23 to 20, 83 to 25, there is no RTC records. That also trial court says that it is a matter of inquiry, including the identity of the property. Trial court holds that.
We'll continue reading this.
Please, please.
Yes. No, we'll continue reading this order.
No, I'm sorry. I'm sorry. My apologies.
Para 19.
Please.
Para 19 we are reading. We'll continue to read that.
No, I requested my lordship
post-lunch,
for
We'll continue.
trial court.
Appellate court will complete it.
Please. Para 19. Therefore, if the suit property is capable of having physical possession, the person who claims to be in possession establishes physical possession over the property. If the property is not capable of having physical possession, the person who claims to be in possession of the suitable property must establish better title over the same, since the possession follows the title in case of vacant site. It is further pertinent to note that if the title or suit property under the cloud, then the next course is open to the person who claims to be in possession of the suit property to get declared his title over the suit property. In this regard, this court is relying upon a landmark judgment of the Apex Court in 2008, so on, so on, so wherein the Honorable Supreme Court. Should I read that judgment? The paragraphs.
Yes.
In a suit for permanent injunction, to restrain the defendant from interfering with the plaintiff's possession, the plaintiff will have to establish that as on the date of the suit, he was in lawful possession of the suit property and the defendant tried to interfere to disturb such lawful possession where the property is building or building the apparent land. There may not be much difficulty in established possession. The plaintiff may prove physical possession or lawful possession either of himself or by him.
So what are the documents that you have filed to show?
I have filed the sale deeds.
Not sale deeds.
Possession, the RTCs, the learned judge
of which year?
Of year 2025. The learned judge has referred to that one.
No, but one more reference in the order is that both the properties are not one and the same.
No, that's survey number is only 174. It comprises of 31 acres.
The court also, it is not the plaintiff's case or the defendant's case that the properties are one and the same.
He is claiming the moment he got the injunction order and gone and demolished my compound wall. He is claiming that. Now he has filed an application for the police protection under the guise of this injunction order.
You appear?
I appear, my lord. Kindly see, my lord. Admittedly, it is a Gomal land. I trace my title to a grant. They have not placed on record the grant. Kindly see the written statement scheduled property and the sale deed scheduled property. The written statement scheduled property, even according to them and the court, is 174/2 and 174/3. But in the written statement, now they cleverly say old survey number 174, new number 174/2. They have not produced the PODI of 174/2 or 174/3. They have not produced it. They say that it was deemed for conversion in 2014, conversion sketch, PODI sketch.
Plaintiff is denying your title to the property itself.
No, plaintiff, yes, except one stray sentence. There are three places where in the written statement the plaintiff makes some allegations. The first is in paragraph 16, where he says some plaintiffs and some third parties interfered in 2014. What were they doing from 2014? Nothing. The next is in para 20. In para 20, in the written statement, they say, on the basis of revenue entries, I make a claim. They don't dispute my title. Then the next government is in paragraph 21 and 22, unconnected to me. They say some third parties were laying eyes on their property. Nothing against me. So I have placed on record the following documents: the original grant, the official memorandum, the Sagoli cheat, the upset price receipt, issue register extract, mutation extract, RTC and sketch. All these documents are put. Both the courts have held the properties are different.
Both the courts have held it is different. And their own written statement and the sale deed, there is divergence insofar as.
What is your case when you file the suit seeking injunction?
I said he's a stranger. I said he's a stranger.
He's not your neighbor.
He's not my neighbor. He's a stranger. And my lord, this one more interesting point. Survey number 174 measures 31 acres. Where is this property? Where is my property? That is all a matter for trial. Both the courts have held. If there is a dispute as to identity, it is a matter for trial. Rightly so. When I have produced all my title deeds and when I produced their own RTC.
Your documents, revenue
Yes,
documents, from the year 1984 till 2025, there is nothing in between.
My lord, from the year 84 to 20,
No,
yes.
from what he
yes,
said,
exactly.
from 2025,
No,
what document you're placing? That is already stayed with the High Court, and that
No,
cannot be a basis.
not in my case, not my case. No, my case is not stayed anywhere.
Is there?
Not in my case.
I have the document. I have produced before the trial court. Annexure?
That is not.
I'll hear and pass
Ah.
on in the afternoon.
Not
Yes.
in my case.
We'll hear.
My lords, may I make?
I will hear everybody. I'll come in a line. If anybody wants anything in between, I will raise and go. Yes. Yes. Memo for any posting, give it to the court officer. I am looking at each and every document provided you give the reasons. And only matters to be taken up at 2:30 will be mentioned now. Give it to the court officer, and if the memo contains reasons, I myself am reading and I'm writing on the memo. Give it to the court officer. All memos to be given to the court officer except 2:30.
Withdrawn.
13th is when?
With list
Huh?
yes.
Thursday is a long wait. You don't have to give it now. On that day you move, I'll take it up at 2:30. I'll take it up at 2:30 on that day. Yes.
Present writ petition is not maintainable. Suit for partition in.
If anybody is not following what I'm saying, I'm not going to listen to the advocates. I said memo to be given to the court officer except 2:30. No other matters to be mentioned. Yes.
Lord, serial number, it will become infructuous. It's listed at serial number 92, and from past 3-4 dates, it's not reaching. It will become infructuous, Your Lordship.
You are the respondent or the petitioner?
I am the petitioner.
If it is infructuous, I'll dismiss it.
Lordship, it may be heard at 2:30.
Why? If it is infructuous, why should I hear it?
The question is very.
No. That kind of things can't be a reason. Yes.
Your Lordship, it's at 2:30.
Either.
Your Lordship, serial number 73.
You permit me to talk? If you say infructuous, I will dismiss it right now, infructuous. Or else
2:30, there is
I will
no
not hear.
urgency.
I'll not hear. Only two options you have. Either I say infructuous or else it will come in its usual course.
It will become infructuous if I am not heard, Your Lordship, because the trial court is proceeding with the proceeding to hear the matter and dispose of the suit.
92, if it doesn't reach today, it will reach tomorrow. Wait. Yes.
My lord, serial number 18.
Lordship, serial number 73.
Yes.
My lord, may I make one request?
My lord, I see needed an adjournment, my lords, in one matter. Serial number 40 may.
Senior counsel need not ask for adjournment. Advocate on record will come and do that. Yes.
Lord, similarly, my lord, 44, I had some difficulty in the afternoon, my lord.
That's what I
Serial
said.
40.
Senior counsel,
Yes.
senior counsel will
We'll
not make
request.
mention. Advocates on record
Yeah,
will do it.
very well,
Yes.
very
Leave it to them. Yes.
Please. Just for tomorrow, my lord, nothing else. Just in the afternoon, I have some inconvenience, my lord. That's all.
The next date is on, it's day after tomorrow. It's a suit for eviction against me, my lords. I've invested 15 crores. It's a short writ, my lords, on rejection of my IA of production of documents, my lords. It's listed day after tomorrow. If my lords may have it at 2:30, my lords.
That you can do it tomorrow, day after tomorrow. Why should you do it today? I will take it up definitely if the matter is coming. So don't have to take up today. Yes.
Lord, serial number 73.
I'm not hearing. Yes.
Serial number 32.
Only 2:30 I said. If any 2:30, other than that, I'm not going to hear.
Serial number 8.
Any other matter 2:30. Yours is.
Memo of withdrawal, my lord. Serial number 37.
Take it.
Serial number 37.
Serial number 18, my lord.
Motiyodu.
Serial number 18,
Serial number
my lord.
73.
37 list 1, mana. I seek withdrawal. I filed my memo of it. The matter does not survive for consideration.
Memo
Serial number
filed that
37.
The matter does not survive for consideration. Memo is taken on record and displayed.
32, my lord.
My lord.
Serial number 34, my lord. Today to infinite not feeling well. Earlier, the other side also informed.
My lord, serial number 18, my lord.
the other side come, anybody says, I'll take it up. Now, why you take up at 1:40? Why am I hearing adjournments?
My lord, serial number
I
80.
understand, ask somebody, I will, even if you're not there, I'll adjourn the matter.
My lord, I will make one submission, my lord. Serial number 18, my lord. This is a disposal matter, my lord.
Serial number 26, my lord.
My lord. Serial number 18, it may be.
You're only making things, all of you are making things complicated for you. I can't
My
help
lord,
it.
serial number 18, my lord. Please, my lord. My lord,
Serial number
my lord,
26.
my lord, serial number 18.
May I make a mention, my lord, court is not audible.
Meant no indifference. So sorry. It was.
No, it was
I
about to,
I totally
senior
understand.
counsel
There
was
some
about to
dam-
conclude. That is not the time you leave the court.
I thought he was continuing for another 2 minutes. There was some damage which was occurring in another court. I rushed out and came back. It was without your ladyship's leave. It meant no indifference or lack of reverence to the bench. My apologies only to this. I'm sorry. I'll wait for my turn whenever your ladyship's board is.
Yes.
Great.
Continue that.
Number 31.
Well, morning, your lordship asked me, where is the stay order of the mutation?
What is that? Stay order.
Stay order of
Where
the
is it?
mutation made in favor of the Annexure J, page 119.
It's not stated in the written statement, my lord.
My learned friend.
They must show from the written statement that the stay order was there as on the date of when the matter was heard. I do not know. Very
It
well.
was
then.
before the appellate court.
This document was part of it.
No, part of the appellate.
Yes.
119 page J.
This is dated.
This is dated, my lord, 9/7.
Huh?
9/7.
9/7.
10/7 it is shown. 9/7, my lord, the court has passed this order in Canada, staying that mutation order, which was passed by the assistant commissioner on 20th March 2026. But all this has been suppressed. And learned judge, trial court has given a clear finding. I will read only one paragraph, your lordship will appreciate that one.
Page
Page
number?
88, page 88,
88.
the trial court order in the midst of it, madam. Para 13.
Yes.
The RTC extract for the year 2026 pertaining to survey number 174 has also been carefully examined. It shows the total extent of survey number as 31 acres, out of which 13 acres, 28 guntas classified as Sarkari Bhuma. It further records the names of defendant number 4, my client, and other purchasers in respect of 5 acres, 20 guntas, and 2 acres, 10 guntas, respectively, under MR so and so, so and so. The same RTC also records plaintiff's name in respect of 2 acres, so and so, 611. This order has been
It was
set.
first recorded on 6/11/2020.
Yes, my lord. This has been now set up.
My question is, recorded for the first time on 6/11/2020.
6/11/2020.
Not before that.
Not before that. Up to 1983, it was there. 1983. Then thereafter, there was a gap. There is no explanation. May I take your lordships to next, my lord, para 14. 12 also very important with regard to the RTC. The principal contention of the defendant is that although name of Puttama appeared in RTC for 82, 83 to 84, 85, it was not continued in the subsequent revenue records. According to the defendant, there is no satisfactory explanation for the absence of her name for several decades, and therefore mutation effected in favor of the plaintiff in the year 25 cannot by itself confer any right over the property. They further contend that the identity and existence of the suit property are disputed. Plaintiff's claim is clouded by serious questions relating to title. Para 14. Thus, the revenue records presently disclose entries in favor of both parties in respect of different extents carved out of larger survey numbers. Whether the plaintiff's mother lost her revenue entries after 84, 85, whether such omission was justified, and whether subsequent mutation in favor of the plaintiff has been legally affected are all disputed question of fact. Likewise, the rival claims regarding the identity and title to the suit property involves matter which requires appreciation of oral and documentary evidence. Such issues cannot be conclusively decided at the interlocutory judgment. Having come to this conclusion, trial court, can it be said that there is a prima
And
facie?
about your case, where it is discussed?
Which one?
About your case.
My case, madam. I will just refer to. May take your lordships to page 83, summary of the written statement of defendants.
No, apart from summary, what is the analysis of the court on
The
your
court
case?
says, my lord, prima facie, they did not say anything about my case. They simply say that they have made out a prima facie case. The same has been concurred with by the appellate court. Not even no difference to the documents. But
So the appellate court gave any finding with regard to that, what you have filed at page number 88?
no, my lord, that was not taken into consideration.
Huh?
No, they have not even considered. But the sketch along with the 1978 grant, it says the boundaries as per the sketch. I will just show the sketch. There is no boundaries in it. The my lord friend is relying upon the sketch. It is part of the original trial court record. What is it?
Take that.
174. Kindly see, there is no mention of which are the boundaries. This is the sketch my learned friend is relying upon along with the grant certificate. No coding of work.
Grant also doesn't specify about the boundaries.
No, it only say that with regard to the schedule as per the sketch. But there is a dispute over the trial court itself has found. There is a dispute over the identity of the.
Survey number 173 consists of how many acres?
174 consists of 31 acres, out of which 13 or 14 acres belong to the government.
Your property is also in 174.
No, 174.
We'll ask.
Please.
Yes.
First and foremost, my lord, I'll file.
Let's come to your plaint. You are seeking injunction in respect of which property?
I am
Come to
seeking
that.
injunction in respect of 2 acres of land.
Where is the plaint? Plaint.
Plaint, my lord. Plaint could have signed. They have not filed the plaint. I'll furnish it.
It's there at page 49. Come to the
Yes,
suit property, suit scheduled property.
Yes,
It says, all the piece and parcel of the agricultural land situated at so and so. You don't, east by remaining property belong to Munisha Amappa. North by road, south by remaining property of same survey number 174. These boundaries are carved out from which document?
From the sketch.
Huh?
From the sketch.
How can the sketch will show? Just now they have passed on the sketch. Please come to the sketch.
Sketch is annexed F, my lord.
Yes. Page number?
Annexed F at page 21, which just now my friend also passed it on.
This is at page number 21.
21.
In respect of a vast extent of how many acres? 31 acres.
31 acres.
31.
This sketch is given to me at the time of the grant. It is part of the grant records. This is one aspect of the matter, my lord. My lord, insofar as the contention of the other side that there was a gap between, my lord.
No, forget about that.
Yes.
Please
Only
convince
on
the court
this
on this
aspect.
point.
My lord,
Now, there are no boundaries to your grant, and the sketch doesn't show any boundaries. The survey number, it only says survey number 174,
174. My lord, my friend's case is that he is the owner of property in survey number 174/2 and 174/3. His documents, what he has placed is in respect of survey number 174/2, 5 acres and 20 guntas, showing 174/2. The last document is of the year 2007-2008. Then 174/3 is 2009-2010. Then it jumps to along with me 2024, 24, 25.
His document contains boundaries.
His document contains boundaries as per the sale deed. No grant certificate is produced. Admittedly, the entire survey number is a Gomal land. So the genesis should and must be a grant. That grant certificate is not produced. All of a sudden, from 2007, 2008, it's silent.
No. It is because the plaintiff has to depend upon his case.
Yes, depending on my case.
So,
True, my lord.
according to you, you say that this is my land
Yes.
and there shall be an injunction.
Yes.
What is your land? What are the boundaries of your land? You say that it is as per the sketch.
As per the sketch.
Sketch doesn't contain any boundaries.
I-
So, how should the court grant you injunction for about an indefinite land? Unidentified land.
We are a poor agriculturist. This 2 acres of land was granted to my mother. The pani was standing in her name. After her demise, the RTC mutation was changed to my name on an IHC basis, which they say that they have challenged. Nowhere in the written statement do they say that this boundary is not correct. It is not their contention at all. Where have they said so in the written statement? They don't dispute it.
You know what I'm not able to understand.
I understand, my lord.
How will the court grant injunction?
I understand my lord's question. My lord, as per the, whatever is the shed.
No, let us forget that what he has disputed, what he has not disputed.
True.
Fact remains is, you are seeking, you say that this is my property, I want injunction to that. So if somewhere, my property is in this room, so I want my injunction in respect of that. Which is that?
As per the sketch, I have described it.
I can understand if the sketch
True.
shows the
I
boundary.
agree. I do appreciate my lord's question. I have to answer it. But unless the opponent denies it, they should deny it. It is not so.
No, it's not about the defendant denying. When the court is granting injunction, court has to grant
My lord,
injunction
my
basing
lord,
on
it is-
something.
My lord, it is a civil suit. It is a civil suit. There is an element of truth when the plaintiff says something. The preponderance is, my lord, all civil suits, there is an
Prima
element.
facie-
My lord,
prima facie case you have to move.
my lord, that is the first principle, is my humble submission, lord. Unless my friend disputes it, my friend should dispute it that
All these I will left it
All-
open.
my lord,
This matter has to, this orders needs to be set aside. I'll set aside and remand it to the court. Let the court decide it.
My lord,
Because the manner
my lord,
in which the matter
My-
proceeded.
One more, there's one more primary submission, my lord. The appeal is filed by in the written statement, the defendant number 3 claims to be the owner of this property. Defendant number 3 has not filed the appeal. Kindly see the order of the first appellate court.
Who filed the appeal?
Now the appeal is filed by the defendant number 4 and 5. Kindly see the first appellate court order, my lord.
Who is defendant number 4? He is a party to the proceedings.
He is a
party.
He is a party.
Injunction is granted against him.
He does not claim any right, title or interest. How can he be aggrieved?
It's a joint family property. Sale deed.
No, defendants are, let's look at
There
the
are-
plaintiff.
Kindly see
No.
the written
Let us
statement.
look at the plaint and
Kindly
please
see the
tell the
written
court
statement,
who are the
sir.
parties. What is the relationship?
Plain.
Come to 55. No,
Ma'am.
not 55. It is 40, 50, 49.
49.
Who are the parties?
Brothers and then.
My lord, kindly, my lord, I'll just read, my lord. From-
Dependent
one-
4 and
one-
5.
one-
One second.
one
Dependent
moment.
4 and 5 are the son and father.
Are?
Son and father.
And what is their relationship with 3, 2 and 1?
No, they are the cousins, my lord.
Huh?
They are cousins. They are cousins.
Sale deed will not.
Sale deed
cousin,
is in respect-
cousin is not bothered about the sale.
No,
His
sale deed
property
stands in the
of
name of-
other cousin.
Sale deed stands in the name of 4 and 4.
Why these people are made parties?
They made a parties.
My lord, kindly, I'll just for one moment read the first appellate court order at page 21, para 21, page 43. My lord, it is the specific case that the third defendant is the owner of the property as per them in the written statement.
No, I'm sorry, my learned friend may not be right. Annex D, page 83, the second paragraph itself, I say, plaintiff has made the defendant 1, 2, 3 as parties in the suit. They are not necessary and proper parties to the suit.
Yes, they are not necessary parties, exactly. You yourself,
What he says is you have not questioned that. Defendant number 4 and 5 have questioned this.
Yes, madam.
And
They have suffered the injunction order.
no, who is the owner of the property? Every
The
injunction
defendant-
order that
defendant
is
number 4
passed.
and 5.
No, every injunction order that is passed need not be questioned. Whoever is the owner of the property will
4.
question.
Yes.
Who is the owner of the property?
4 and 5, along with other joint holders. So, let me show the.
No,
file.
Sale deed is in whose
Sale deed
name?
is there.
In whose name?
I will show.
My lord, kindly see the written statement, my lord.
We have filed along with this.
My lord, I'll just
I will
read
just
para 21.
pass on this sale deed, madam.
Yes.
The contention of the appellants, para 21, page 43.
What is it?
The contention of the appellants, defendants 4 and 5, that the defendant number 3 has purchased the property bearing survey number so and so and land bearing sir. Therefore, the property purchased by defendant number 3 is altogether different from the suit schedule property. It is not the case of the appellant, the defendant 3 purchased with property and suit schedule property are one and the same. In order to establish his position of the suit schedule, the defendant plaintiff has produced so and so. Then, my lord, kindly come to page 45. It is also further pertinent to note.
Before we go to that, I have to be convinced on
My lord,
how the injunction granted is correct.
he has not challenged the order
right
at all.
or wrong, if he is not the owner of the property, why you wanted an injunction against them?
No, he does not challenge the appellate court order.
Who?
The third defendant, who in the written statement, they say that the third defendant is the owner of the property, survey number 174/2 and 174/3, and that I am allegedly making a claim over it. If that be so, he should be aggrieved. He does not file the appeal.
That is one aspect.
Yes.
So injunction is also there against these people is also a factor.
Yes.
Injunction against 4 and 5 is also there.
Yes, 4 and 5. They do not assert that they have any interest in the property. They should assert, my lord. They should say assert any right or interest.
Why the third defendant has not questioned it?
In
Third
fact,
defendant? I'm sorry.
Why the third defendant?
They have
is
filed
the
a memo.
Owner of the property.
They have filed a memo telling that they are not interested. 4 and 5.
No, I have taken a stand in my written statement. They are not necessary parties. It is only when at 4 and 5, it is also extracted in the trial court order, page 13. It is further record the names of defendant number 4 and other purchase in respect of 5 acres 20 guntas and 2 acres 10 guntas respectively. That's why I placed it on record the
What is
sale
that
deed.
page number?
Page number 88, para 13, which I have read already, madam.
Para 15.
Para 13.
Hmm.
RTC extra for 26 pertaining to survey 174 has also been carefully examined. It shows the total extent of survey number 31 acre, out of which 13 acres 28 guntas is a Sarkari Gomar. It further records the names of defendant number 4 and other purchases in respect of 5 acres 20 guntas and 2 acres 10 guntas respectively in MR so and so, and also the name of the plaintiff.
Yes.
Kindly see the RTC, my lord. Their own RTC 24-25. Their extent is also protected. My extent is also there. So admittedly, the finding of the trial court that there are two different properties is demonstrable. Once it is two different properties which are demonstrable by their own records, I am entitled to injunction in respect of my property. That is the legal position.
That is not the. That is how you are entitled for injunction. Please come. Agreed with her. Order passed.
There's one judgment of the Supreme Court.
Please pass on. Please
Says,
pass
my lord, my humble submission is under supervisory jurisdiction, my lord.
There is an error apparent on the face of the record. There is a blatant error committed by both the courts while granting injunction. That's why I'm interfering. I will not go into any of the meticulous points.
I'm well aware of it, my lord, but there is not all my title deeds.
I am not passing any order granting. I'm saying I'm remanding the matter. Let the court decide.
So I had the benefit of injunction, my lord, till
that
date.
will continue till such time.
I had
agreed with her.
That benefit should remain, my lord.
Let them not do precipitate, my lord.
Nobody.
One second.
What I'll say is, let status quo be maintained.
Till the dispo, your lordship can kindly fix the time frame, my lord, within 2 months or 8 months, whatever it is.
Some time
They are
frame
ready
may be
to
fixed,
assist.
let the injunction be protected.
Let them not do
Don't
anything.
do anything. When the matter is disposed, when I'm setting aside the order, a question of continuing with the injunction would not arise. I will only say, maintain status quo.
My lord, it's like this, my lord. Can I make one?
What are you doing?
My lord, it's an agricultural land, my lord. May I make this submission, my lord? My lord, the orders of status quo generally are granted, my lord, where there is a construction, where
I said
there is.
both the parties shall not do anything.
Please.
Don't do anything.
Please.
Let both of you maintain status.
Because it's an aspect of possession, my lord. Generally, my lord, in aspects of possession, my lord.
Whoever is in position, I'm not saying, but no, either whoever is in position, don't do anything. That nothing to be done along with regard to that property. Let the status quo in all respects to be maintained, and I'll ask the court to decide this within 15 days.
Please.
Please. Until that time,
until that time, status quo.
Because of this.
Agreed by the order passed in.
I'm sorry, my lord. One last sentence.
Yes.
One last sentence. Because of this reason, my lord, even on their own showing, my lord.
No, what will we do if I grant injunction? What are you going to do?
I will not do anything, my lord. I will not.
I'm also saying them not to do anything.
They own a huge extent of land of 7 acres and odd. I just want 2 acres of land. My lord, they will
do anything.
They will simply overpower me.
They will not overpower you. If they overpower, you are not remediless. They are not supposed to do it. They also keep quiet. You also keep quiet. That's what is the order. Please come. Agreed with orders passed in IA number 1 in OS number 289 of 2026. The and which is confirmed by the appellate court in MA number 106 of 2026, dated 1st August 2026, by the first edition senior civil judge, Bangalore, dated 1st August 2026. The defendant is before this court. The respondent herein has filed a suit for bare injunction. In that, he has filed IA number 1 under Order 39 Rule 1 and 2, seeking injunction, restraining them, ad interim injunction,
Not to interfere with.
restraining the defendants from interfering with his peaceful possession and enjoyment of the property. The trial court, by order dated 2nd July 2026, has granted injunction. While granting injunction, the court has observed that the RTC extracts for the year 2026 pertaining to survey number 174 has also been carefully examined. It shows that the total extent of the survey number as 31 acres, out of which 13 acres, 28 guntas, is classified as Sarkari Gomala. It further records the names of the defendant number 4 and other purchases in respect of 5 acres, 20 guntas and 2 acres, 10 guntas respectively. The same RTC also records the plaintiff's name in respect of 2 acres under MR number T9/2025-2026 dated 6/11/2025. The court observed that the revenue records presently disclose entries in favor of both the parties in respect of different extents carved out of the largest survey number, where the plaintiff's mother lost her revenue entries after 1984-85, whether such omission was justified, and whether the subsequent mutation in favor of the plaintiff has been legally effected, are all disputed questions of fact. Likewise, the rival claims regarding the identity and title to the suit property involve matters which require appreciation of oral and documentary evidence. Such issues cannot be conclusively decided at the interlocutory stage and necessarily require a full-fledged trial, and accordingly, the court has come to the conclusion that the plaintiff's name reflects in the revenue records. The existing revenue entries constitute prima facie material indicating the plaintiff's position over the suit property, and accordingly granted injunction. The petitioner herein have carried the matter in appeal by filing MA number 106 of 2026. That came to be dismissed by confirming the order passed on IA on 1st August 2026. The appellate court, while confirming the order of the trial court, that an injunction is an equitable relief. The person who seeks injunction must approach the court with clean hands and establish his right over the property. On perusal of the written statement of the defendant, it appears the defendant number 4 to have not asserted any right, title or interest in any manner over the suit scheduled property, nor did over the property alleged to have been purchased by the defendant number 3 as contended in the written statement. It is further pertinent to note that in the present appeal, the defendant number 3 added as respondent number 4, who ought to join with the appellant, since it is the defendant number 3 who claiming to be the purchaser of the property mentioned in the written statement. It is also further pertinent to note that the respondent defendant number 3 would have appeared and filed his cross objection, which has not been done. Since the appellant has got dismissed the appeal against respondent number 2 to 4. It is under these circumstances the appellant have no right over the suit scheduled property or over the property alleged to be purchased by the respondent number 4, the defendant number 3. Nevertheless, no documents have been produced by the applicant in order to show that the suit scheduled property and the property alleged to be purchased by the defendant number 3 are one and the same, much less to show the defendant number 3 has purchased the property mentioned in the written statement. And the trial court has rightly observed that the plaintiff is entitled for injunction and accordingly granted injunction. Senior counsel appearing for the respondent, representing the counsel for the petition, submits that when the matter is pending before the appellate court, they had the document basing on which the injunction was granted, the appellate authority or the higher court?
Deputy
The
Commissioner.
appellate authority has stayed the operation of the said order. It is submitted that the petitioner's grant says that the property is as per the sketch. Senior counsel has drawn the attention of the court to the sketch, and the sketch do not contain any boundaries. It is submitted that survey number 174 consists of 31 acres. Defendants, plaintiffs, according to the defendants, they have property, and the plaintiffs have purchased were granted, were given a grant. As the boundaries are not clear, and in those circumstances, as the plaintiff has not made out a prima facie case, the court ought not to have granted injunction. It is submitted that the appellate court, in spite of placing the document before the court, has failed to give any finding on the same, and mechanically had confirmed the order passed by the trial court. It is submitted that the order impugned before this court needs to be set aside, and the writ petition has to be allowed. Next parallel, and counsel appearing for the respondent submits that both the courts have concurrently found that the property of the petitioner and the property of the defendant is not one and the same. And in that case, as far as the property of the petitioner, the plaintiff is concerned, he has placed the grant before the court to show his position of the property. Court having been convinced of the same, and as he could make out a prima facie case, and the other two ingredients are also satisfied, court has rightly granted injunction. It is submitted that as for the written statement, the defendant number 3 is the owner of the property. Now the appellant before this, the appeal and this petition is also filed by defendant number 4 and 5. When the defendant 4 and 5 have no interest in the property, and they cannot come before this court by filing the present writ petition, it is also submitted that when on a concurrent facts recorded by both the courts, this court exercising the jurisdiction under Article 227 cannot go into those factual aspects, and there may not be interference with the well-considered order passed by the court. Anything else? Passed by the well-considered order passed by the court. Next paragraph. Having heard the counsels on the senior counsel for the petition, the learned counsel for the respondent, peruse the material on record. The plaintiff respondent herein had filed a suit seeking injunction in respect of all the piece and parcel of the agricultural land bearing survey number 174, measuring 2 acres, situated at Karnamangala village, Bidarahalli, Hogli, Bangalore East, and the boundaries are mentioned as east by remaining property of the same survey number 174, west by property belong to Munishamappa, north by road, south by remaining property of same survey number 174. It is also an admitted fact that the grant was there in favor of the plaintiff's predecessor way back in the year 1967, and the grant as per the grant, the boundaries of the properties are as per the sketch. This court has perused the sketch. In the sketch, basing on the sketch, the court cannot come to any conclusion what are the boundaries of the property. As it is also an admitted fact, the entire survey number of 174 consists of 31 acres or 34.
31 acres.
It consists of 31 acres of land. In those circumstances, whether the property claimed by the petitioner, what is the property, what are the boundaries of the property claimed by the petitioner, what are the boundaries of the property claimed by the defendants, the court, unless and until comes to a prima facie conclusion, and basing on the RTC extracts, the court cannot say that there is a prima facie case. And further, before the appellate court, they have produced a document to show that the entries in favor of the revenue entries in favor of the plaintiff, which were done in the year 2025, are stayed by the appellate authority. In those circumstances, in the considered opinion of the court, the trial court and the appellate court had failed to consider the case on the merits of the matter. Hence, this court deems it appropriate to set aside the order passed in I number so and so, which is affirmed in so and remand the matter for fresh consideration. Accordingly, this court is passing the following order. The order dated so and so set aside, and the writ petition is allowed. The matter is remanded. When is the matter coming up before the trial?
22nd, I am told, madam. 22nd.
The trial court shall consider the IA number 1 within a period of 15 days from 22nd August. From 22nd August. Number 3, both the parties shall maintain status quo in all respects. In all respects concerning the property.
Great. Nobody shall change the nature. Nobody
That's
shall
what I
change.
said. In all.
I heard, my lord. I just wanted a further clarity. Shall not change or alter the nature of the land in any manner.
Either of the parties shall not change or alter the nature of the property, and the status quo shall be maintained in all aspects.
Please.
Till number 32.
Petitioner's counsel is not well, my lord. It pays for a week's time.
Yes,
It's connected matter.
Second matter, connected
Interim
matter,
order is there.
interim order is to
Interim order
be
is there.
continued.
Huh?
In the connected matter, interim order is to be continued. It may be taken up by
This
next week.
interim order next week, my lord, because the matter was
Yes. This is matter on 19th of August. Interim order earlier granted is extended, and it is made clear that no further adjournments will be granted. This is matter in the first list.
and also in the connected matter, my lord, they took dispensation on me, though I filed an objection. My name may be shown, my lord, for respondent 8. Let's say A. Sampath, my lords.
32.1.
32.1
32.1, print the name of A. Sampath.
for respond number 8.
Respondent number 8.
That interim order is to be continued. In that interim order is to be.
Yes, next.
Grateful.
Till number 33. V. Vishwanath Shetty for petitioner. Ramsinga Reddy.
Petitioner. Petitioner.
Have you served the
challenge
papers on the caveator?
Annexer E.
No, have you served the papers on the caveator? I'm saying.
Yes, served. Sir, I have served and I have got acknowledgement.
Yes.
May I submit?
Where is the impugned order?
Well, the impugned order is at page number, commences at page number 90, and that particular portion in 92. Where I filed regarding IA number 8 concerned, my lords, please. Lords, the suit of the deceased petitioner, my lord, for the relief of declaration to declare that.
Suit is of the year 2008.
My lords, please. Our impugned order is dated, my lords, please, on
No.
7/1.
Suit is of the year 2008. You wanted it to be now reopened and.
And that is a reopened, my lords. So far it concerned to reopen, there is no gross, my lord. IA number 8, I filed an application under section 65 BSA, my lords, please, seeking permission to produce the certified copy of the will issued from the office of the sub-registrar, as original will is misplaced and I could not be able to trace out the same. My lord, the respondent number 224 have contended that on the basis of the certified copy of the will, since they are disputing the same, the signature of the testator as well as the witnesses could not be able to prove, my lords. So that contention taken by the respondent 224 is accepted by the trial court. My lord, my humble submission is that, my lord, in absence of the original documents, when a document is registered in the office of the sub-registrar, my lords, please, the LTM of the parties, the signatures of the properties, everything will be scanned now, my lord, in presence of the recent. This will is of 2012, my lord, after digital.
Do you say that Xerox copies of it?
No, I have not certified copy I produced. certified copy issued by the sub-register office, is a registered will, my lords. So I can call for the records from the sub-register office to prove the signatures.
Come to the order.
Please, my lord. May kindly peruse page 92, my lord, please, regarding my IA. Para 3, my lords, please. Para 3. In support of IA filed number 8 of 2025, filed under section 65 BSA 2023, so and so, so and so. The applicant has stated that now the original will is misplaced.
BSA 2023. And the same is rejected by the court without even considering the fact that it is a registered will. And once the certified copy is marked, then they can call for the original will from the registrar's office.
I start for stay of further
Call for
proceedings.
the proceedings, notice and summons. Yes. Though the caveat is filed for respondent number 5. Land council submits that he has given the papers, but there is no representation, whatever, except 5 other respondents and summons. Yes.
Then number 34. 34. Interpreters copy.
Said they want time, my lord, could be adjourned.
For petitioners.
They inform they want time, my lord, saying there is
Kindly
no
have
interim
weeks time.
order.
On record advocate is not keeping them.
Yes, 2 weeks.
Please.
Yes, 35.
Then number 35. Onendra Raju P. Petitioner. Shetty Vignesh.
Yes.
Amendment application is rejected, my lord.
What is the suit for?
Suit for specific performance. My lord, the defendant is a widowed lady. She had some minor children. She borrows a sum of rupees 10 lakhs. That is loan agreement is converted into a sale agreement. These aspects were not brought to the notice of a counsel who appeared for her the first time. Then at the time of evidence, this was indicated to the new counsel. Accordingly, this amendment is sought for, detailing as to how this, what is this 10
Let's see
lakhs?
your affidavit. Where is that? Filed in support of the IA.
Affidavit, my lord.
Page number 79.
Page number 79 onwards, my lord. Para 3 onwards, my lord. I submit that the plaintiff, in the guise of getting the loan agreement registered from me for the sum of rupees 10 lakhs lent to me, has malafidly got the sale agreement registered in respect of the suit scheduled property, which is valued at more than rupees 1.5 crore at that point of time. I submit that even after the legal notice was issued by the plaintiff, I had approached him and his associate Manjunath, and they informed me that it's only for the purpose of income tax authorities, that she need not worry, and I trusted them. Plaintiff is an advocate, and I thought he will not cheat me. I submit that after filing the suit, I had given all the information it transpired between us to my advocate, and he had prepared, and it was he had prepared the written statement, and it was filed, and he was not properly responding to my queries. I changed and I got appointed my present advocate. I submit that only during cross-examination of plaintiff by the present advocate, we have realized all the information given by me to my earlier advocate was not incorporated in the written statement. I submit that under the said circumstance, in spite of due diligence, the said pleadings could not be incorporated in the written statement. I submit that it is just and necessary that all the incidents that has transpired between me and the plaintiff has to be incorporated in the written statement for enabling the court to adjudicate the true incidents that has taken place.
No, in the original written statement, what was your case? Are you alleging all these kind of things on the, what is that alleged in the written statement? Now you're making so many allegations by way of this in 14C and all. You say that on blank checks he has taken and all. This is something which changes the nature of the suit. Come to your original written statement.
Yes, yes, madam.
Page number?
Page number 47 onwards.
Let's see that. What is your line of
Para 14, the defendant number 1 submits.
After denial, what did you say?
Yeah, this is what I say, madam. Para 7 also I have said this, madam. The statement made in para 8 of the plaintiff to the effect that plaintiff obtained a purchase loan and further against false, since the defendant number have not executed the sale agreement. The statement made in the plaint to the, to that the plaintiff approached the first defendant are all false since the defendant number one has not executed the agreement.
Original written statement in only 14 paragraphs. Now the amendment is going in, come to the order. What did the court say?
The court says that I've virtually set up a new theory is what the court says, but that is not so, my lord. If you read, holistically read it, my lord, I've expanded the whole thing.
Let's go back to that amendment. What is that? That 14C you're telling about, same, the demand promissory note, blank checks.
Yes, my lord. From 14C onwards, in fact, for this 14 also says, my lord, that there was a security, blank checks, etc. The same thing I have elaborated in 14C onwards, my lord. If my lord compares the original para 14 and 14C, I've elaboratedly said so, my lord. The only thing that I've added is that the value of the property was 1.5 CR is what one aspect which I have added.
Come to the order. What do you say?
Please, my lord. My lord, it's a case of the my lord petition. My lord, I'll just, my lord, 3 dates, my lord, I'll just negate. I filed suit, my lord, on my lord 18th July 2019. The written statement filed on my lord 3/10/2020. The present application is filed, my lord, after a period of my lord 7 to 8 years. My lord, kindly see the affidavit along with the application. My lord, kindly come to my lord page number 79. The only allegation against the my lord in respect of application, I'll just read the my lord paragraph from 4 and 5.
No, you see, when agreement of sale is entered or whatever it is, at that point of time, the property is mortgaged to a bank.
Today also, my lord,
No, that's what. All those facts are need to be brought on record.
No, my lord, that in respect of my lord, defendant number 2 is concerned, my lord, he is a party. He is already argued the written argument filed. From the day one of our case is whatever his claim, my lord, I am ready to pay. It is not in dispute, my lord, in respect of my lord, registered sale agreement executed in my favor. Apart from that, I'll just point out, my lord, the 2 paragraph which is stated. He is stating, my lord, the present advocate also, my lord, entered in appearance in the present proceedings in the year of 2022, 4 years before. My lord, I'll just point out, my lord, 1 paragraph, my lord, in the affidavit which they stated. Paragraph from 4, my lord, page number 79. I submit that even after the legal notice was issued by the plaintiff, I had approached him and his associate Shri Manjunath and they had informed me that it is only for the purpose of income tax authorities and she need to worry, and I trusted them, the plaintiff and his advocate, and I had through he will the shit next paragraph. I submitted after filing the suit. I had given all information that I had transferred between us to my advocate and had prepared to file written statement, and it was filed, and he was not properly responding to my queries. I had changed. I got appointed my present advocate. In fact, the present advocate appointed in the year of 2022. Cross-examination is done. The matter, my lord, reached. In fact, our argument is over. Then, my lord, again they filed an application for my lord recall, my lord, adducing their evidence. Now, 6th adjournment, my lord, after my lord 2020, my lord, I completed my evidence on in the year my lord 2024. I'll just my lord 23/10/2024, my lord, I completed my.
Even assuming that earlier advocate has not properly advised, the present advocate is on record from 22, and you have now to fill up your latches or lacunae in the
Present advocate
that
is
cannot be. 22 new advocate.
24, I think so. Present
22.
advocate from
22.
4, I think so.
Some
24.
My lord, all my lord, after my
some
lord
time
posted
frame,
the
my
matter,
lord.
my lord, evidence is complete 2024.
Time frame I'll complete it, my lord.
Time frame.
Some small time frame I'll complete it, my lord. I assure
So
the
the
court.
entire evidence is completed.
Well,
Not to all to fill up your the latches in the evidence. Now, if you want all these, no, you are saying no. By virtue of this, what you want to say? You want to elaborate that this property is mortgaged to so and so. All this are already on record, but because the bank is before the court. Bank has already stated all that.
They in fact concluded their argument. They filed the written argument in the court. That stage they filed an application for recall, my lord, in respect of evidence. That is also court allowed. But thereafter, my lord, 6 adjournments sought.
Some, even whatever cross-examination that the council would have made, without pleadings, it will be of no consequence.
That your client would have understood in 2022 itself.
But
Now, what happens is,
valuable-
it is, no,
valuable-
that is true, but 20, after the evidence is, and the entire evidence
No,
is
no.
let in, just like that, what was the, you just want to put the clock back to 2019 without any reason.
It's to 2019, it's hardly 7 years suit for specific performance. Some indulgence is what I crave, my lord. Some indulgence, my lord.
No, if these, whatever you are pleading, in this, if it is not allowed, what is the prejudice? Let me understand.
My lord,
In those pleadings,
I will-
already
my
you have
lord, I
stated
will-
about that, those,
my lord, I will
checks
not
and-
be, my lord, the signatures on the suit document is an admitted fact. I will not be able to demonstrate the circumstances under which this document got executed.
that you have said so already.
No, in
Only
fact-
I thought, I didn't know that the cooperative bank is a party. If when the bank is party, then there are no other things. I've read your additional written statement. Please come to that. I mean, the amended pleadings.
Yes, ma'am.
You already said about the money lender, advocate by profession, so and so, security, all that you have narrated. What is that you want to narrate now?
Even we said in, my lord, our plaint itself in respect of the, my lord, bank loan.
These aspects in paragraph 14C onwards.
Please let us see that. How you have made out a case that no, from this, unless and until this is not heard, it will cause injustice hardship to you.
Because in the first instance.
No, these are on record. The sub-register office loan agreement has to be registered for security. Taking signatures, this is all already you have said so. Mortgage with the Tumkur Gramina Bank, valued more than 1.5 crores during 2017. Loan was sanctioned by Taluka, so and so. What was the consideration?
My lord, 50 lakh, my lord. In fact, 50 lakh is a consideration.
Kindly see the vast difference between the amount, my lord. What is paid is the value of the
Will
property.
anybody keep quiet? Will anybody go through the evidence? I know it is like introducing a different case altogether, which is not at all permissible by way of pleadings. That too after entire trial is concluded.
It's only at the stage of the defendant's evidence, my lord.
Evidence is concluded.
Our evidence is complete, my lord.
Their evidence
Then, my
is
lord,
completed.
court given an opportunity. They are not.
Their
Then, my lord,
evidence
matter posted for, my lord, argument.
Defendant's evidence is not yet over, my lord.
Then, my lord, they filed an application for recall. Thereafter, my lord, some dates has been given. In this juncture, they filed this presented petition. Thereafter, my lord, in fact, my lord, when the matter posted for different evidence,
My
they
evidence
took
is
an
not yet over. my lord.
No. There should be one simple reason for doing it. The court will not do anything for the sake of asking it. When you're saying that you want an amendment, one thing, why you have not pleaded this at an earliest? Yes, there is a reason. What is the reason? Nothing is forthcoming. Advocate came on record in 2022.
I have said that she's a widow with small children. She is not aware of it. That is the reason. my lord.
Plaintiff, she was the plaintiff. She was the defendant. She
Yes,
was the plaintiff.
Pardon? Defendant. I am the defendant.
That's what she was the defendant or the LR of the defendant.
No, she was the defendant. She is the defendant. She borrowed this money for her children's education, at which point of time this transaction happened. That is the circumstance.
But you can't, you know, who will answer to the judicial time you have consumed unnecessarily? And you can't make everybody to go around.
Kind indulgence, my lord, some costs I'll pay, and my lord, I'll undertake to finish it within a short span of time.
I'll only say, my lord, it's abusing the process of law. In fact, my lord, the court immediate below, my lord, considered and my lord recalled. In fact, the matter posted for my lord argument. In fact, argument my lord, we did it after completing my lord evidence. 2024, my lord, we completed our evidence. In fact, defendant number 2 is already completed his evidence, written argument on record.
Valuable immovable properties involved.
What are you
Permissible
doing?
with this structure.
Your valuable immovable property,
In
you are,
ordinary,
you should be
in
conscious of it,
ordinary,
not the High
in
Court.
ordinary injunction suits, this happens to a couple of times.
That is not the ground, that we can't.
I only crave
we
indulgence.
We can't.
My lord, I only crave indulgence
Generally,
having.
we will not. No. I can only exercise the judicial discretion, not
True, my lord.
otherwise. What is how I should exercise the discretion? You have to
Well,
tell me.
The fact situation is that she is a widowed lady, and this is what has happened, my lord.
Why the widowed lady is prosecuting the matter?
My lord, 2019 to 2021, 2.5 years went in the COVID, my lord. Hardly 5 years old. Suit in that context, at least, my lord, may kindly view this matter, my lord. On some costs, some indulgence may be shown.
Time is valuable.
I do.
You will ask your client if she is ready with 1 lakh. I'll do that. You can't take your sweet time and come to the court, exercise jurisdiction under 227. No, it comes with some cost. Cost is 1 lakh. If it is ready, let her come. I'll pass orders tomorrow.
If that cost also, my lord, then my lord, in the time bound manner, they can't, my lord, drag the matter for next 2-3 years, my lord. Within 3 months, my lord, suit has to be completed, day-to-day basis. My lord, that's some
reasonable cost my lord may impose some reasonable cost.
What is the reasonable cost?
I leave it to my lord's discretion.
No. When I said so, you say that what is reasonable, I'll record.
20,000 rupees maybe.
50. Give that.
20,000 max.
And let them undertake before this honorable court within 3 months, my lord, they will conclude in that.
No undertaking. I'll ask a trial court to proceed with it.
Deeply.
Agreed with the order. Order passed on I number 16. Filed under order 6 rule 17. Invoice number 5255/2019 dated 4th June 2026. The defendant is before this court. The respondent has filed a suit for specific performance. When the matter is coming up at what stage?
Defendant's evidence.
Coming up for defendant's evidence at that point, at that time. An application is filed under order 6 rule 17, seeking amendment of the plaintiff that came to be dismissed by the court by order impugned. While dismissing the application, the court has observed that the written statement was filed on 3/10/2020. Issues were framed on 8/4/2023. The plaintiff has entered the witness box, adduced evidence and is fully cross-examined by the defendants. The matter is now posted for evidence to the defendant number 1. The court observed that now by way of this amendment, now the amendment is filed stating that the mere change of advocate or omission on the part of the previous advocate cannot by itself constitute due diligence within the meaning of order 6 rule 17 CPC. If such a ground is accepted, the proviso would become redundant and parties would be permitted to amend precinct at any stage of the proceedings. And further, a perusal of the proposed amendment discloses that defendant number 1 seeks to introduce detailed allegations regarding fraud, misrepresentation, loan transaction, repayment of loan and other facts which were not pleaded in the original written statement. Such an amendment substantially changes nature and scope of the defense already taken and seeks to introduce a new case after completion of the plaintiff's evidence. The plaintiff has already adduced his evidence has been fully cross-examined. Allowing the proposed amendment at this stage would necessarily require reopening of the plaintiff's evidence and would cause serious hardship to the plaintiff, besides delaying the disposal of the suit. And accordingly, the court has dismissed the same. When counsel appearing for the petitioner defendant submits that the trial court has failed to consider a fact that if the amendment is not allowed, it would cause a lot of hardship to the defendant. It is submitted that the defendant is a widow and has to take care of the children. And in that process, there was no proper legal advice, though she has already stated about the fraud and other things, but she could not elaborate it in the written statement. After she engaged a new advocate, at his advice, they came to know that all these aspects need to be stated. Hence, they have come up with this petition. It is submitted that there is no intention on the part of the defendant to delay the proceedings. Next parallel counsel appearing for defendant.
Defendant number 1, my lord.
The defendant number 1, plaintiff. Submits that The defendant number one plaintiff submits that the after the entire evidence of the plaintiff is completed, the defendant has come up with such a plea. Earlier reopen is also ordered.
Please, ma'am.
Earlier application to reopen the evidence is allowed. And after that, the present application is filed. It is submitted that it is only to drag on the proceedings and basing on the reasons as stated in the plaint, as stated in the application, that cannot be a ground for amendment of the written statement. It is submitted that the it would cause if the amendment is allowed, it would cause a lot of prejudice to the plaintiff, and the court has rightly considered all these aspects and rightly dismissed the petition, and there are no grounds to interfere. Next paragraph. Having heard so and so, the suit is for specific performance. The written statement is filed in the suit. This court has perused the written statement. In the written statement, already a factual basis is there with regard to the fraud and other fraud and other allegations made by the in the written statement. However, now by way of this amendment, the plaintiff wants to elaborate those allegations. This court finds force in the argument of the learned counsel for the respondent and also the reasoning given by the trial court. The change of the advocate cannot be a ground. According to the learned counsel for the respondent, the advocate was changed in the year 2022. They have waited till 2026 to come up with the application. There are clear latches on the part of the defendant in filing an application seeking amendment of the pleadings. However, concerning the kind of allegations that are made in the written statement, original written statement, and to prove the same, as this elaboration of facts is required in the interest of justice and balancing the interests of both the parties, this court is passing the following order. The order dated so and so passed and so is set aside on the condition that the petitioner shall pay an amount of rupees 50,000 towards costs to the respondents. Number two, immediately the petitioner, accordingly this IA is set aside and consequently IA number 16 is allowed. Immediately the petitioner, the amended written statement shall be filed, and the petitioner shall not seek for unnecessary adjournments. If the petitioner is not proceeding with the matter, it is for the trial court to proceed with the matter and pass appropriate orders.
Let some time limit, my lord, to complete the proceedings, my lord. In fact, for 3 months.
2019 suit I will not pass. Yes.
My lord, immediate cases on 22nd. Can I pay it on 22nd? Because my lord has said immediately. On the hearing date, I'll pay it.
No, I didn't say immediately. What is that immediately?
I thought my lord said pay the cost immediately.
No, I didn't say so.
Some observation in respect of, my lord, they can, my lord, they need not to take any further adjournment or, my lord,
I
filing
said
some.
so. They should cooperate. They should not take, court should not give anything else. And they should tell you before taking adjournment.
Lords, filed 2 writ petitions, my lords. Lords, one is to restore the written statement and defense of the petitioner, and the other one is to set aside the IA number 9 and 10, my lords.
What is IA number 9?
My lords, IA number 9 and 10 is to recall and they have filed an application to recall and
First,
reopen.
which writ petition to be taken?
My lords, it's 21162, my lords.
Which one?
21162 of 2026.
Give that. File is not there. They'll call the file by. Yes, next 37.
37 discourse, serial number 38. Serial number 38.
Petition, defendant's writ petition, lordship. Lordship, the petitioner here in lordship purchased the suit property, lordship.
What is the suit for?
Lordship,
Suit for.
suit for partition and separate position.
This IA.
IA filed by the defendant number 2 to file a written statement, my lordship.
What is the delay?
Delay, my lordship, written statement closed on 8/7/2024, my lordship.
When did you
The
file?
written statement, 12/8/2025, the petitioner filed a written statement.
Why?
Lordship, on that point of time, she is not well and she went USA for treatment, my lordship. Therefore, my lordship, there is a delay. Further, my lordship, there is a 2 more suits are pending in respect of the suit property, my lordship.
About all that, why did you not file the written statement in this suit is the only question that will be decided by this court.
Lordship.
Why you have not filed the written statement in this suit is the only thing the court will consider in this case. So
Please.
why you have not filed? What are the reasons for that?
I have, in the IA, my lordship, I have narrated.
Where is it?
IA at page number 49.
Yes.
At page number 50, my lord, paragraph 3, my lordship, I submit that subsequently of service of the summons, I appeared before this honorable court through my counsel and taken time for written statement, filing of written statement. Subsequent to my appearance and several litigations are pending in respect of the suit property, there was a need of documents and appear to details written statement.
What is the present stage now?
Present status is further evidence of PW1 on the last date of vacation for posted for cross of PW1.
Cross-examination of PW1. The 2 occasion was posted. Moreover, he has watched and avoid the proceedings. So in support of their affidavit, they have not been placed in any material. They have not disclosed the other pending
Who
litigations.
is he? Is a family member?
No, he
I am
is
a
a purchaser.
purchaser.
He is a purchaser. His case is somebody is a family member sold the property. He has, in fact, he has watched the proceedings. When the matter was posted for evidence and adjourned for cross-examination, then only come up with this application. So the honorable trial court take into consideration of this honorable court reported judgment. Very the casual manner and casual approach is not to be considerable. That reason was
In all these condonation of delay matters, there won't be any law on that. It all on facts.
But very vague allegations,
My lordship,
the
suit
very,
property already converted in the
casual
2008 itself. Lordship. 2008 itself it is converted. Now they are claiming as a agriculture land.
Who stopped you from filing the written statement?
Lordship, sorry, I have narrated in the written statement, my lordship, there is a two more partitions suits are pending in respect of same property in the additional senior.
Those suits also you're a party.
I am that suits also I am a party, my lordship. I am trying.
There also you didn't file your.
There we have filed, my lordship. We have.
Then why not this?
But we are all this petitioner are trying to settle the entire litigation, my lordship.
Yes, Mr. The other suits are also there on cost will allow this.
No, my lord, there are other.
No, this property, he is also a party in the other proceedings pertaining to the same scheduled property. There he is contesting.
Yes,
So what is the benefit that you will get in the suit if he is
My
not
submission
contesting?
is, what is the impediment to come up with the papers? Their affidavit is, you have collected the.
Even the
summas
court
case.
is accepting that there are no reasons.
Yes, ma'am.
After accepting that, that is the next question I am putting forth. Please come.
The heavy cost may be put through and.
How heavy it is?
1 lakh may be put, because in this honorable court in one occasion was put the.
Here is a
1
delay
lakh-
of 1 year.
1 lakh
What is the property?
What is now property is converted. It is agriculture. They are claiming 4 acre 29 out of 1 acre 17 guntas they claim.
What is the market value of the property?
We don't know. We don't.
Then you must be knowing.
We don't. I have no objection to impose any nominal cost.
I say.
He's saying 1 lakh.
Because,
It is elaborate cost.
because in every
It is
date
very
he has
elaborate.
appeared and watching the proceedings,
Where
that is a grievance. ma'am.
Where is the order?
Order in page number 21 is a observation made by.
Agreed.
Page number 20, even in the instant case was already shown.
Agreed with the order passed in. Agreed with the order dated 7/4/2026. whereby the trial court has refused to take the written statement on record. That's IN number, uh, an application filed by defendant number 12 under order 8, rule 1 CPC is rejected and the court has failed to take the written statement on record. Then counsel for the petition submits that there are another two suits are pending in respect to the same scheduled property and he has filed the written statement and contesting the same. In the present suit, due to various reasons that he is out of country, nor is not feeling well, and the compromise talks were going on, he could not file the written statement within time. It is submitted that it is a case that in substantial interest, the written statement should have been taken on record. This court next, the trial court by order impugned had rejected the application. While rejecting the application, it is observed that
Page number 20, ma'am.
the delay in filing the written statements are not supported by any documents and they were not valid and cogent reasons. And the court is of the view that it is not proper to consider the contention of defendant number 12 at this stage. The delay of nearly 3 years, 1 month is not explained properly by filing necessary application. Therefore, the court is of the view that there is no merit in the application and accordingly dismiss the application. The learned counsel for the petitioner has reiterated the same submissions as were stated before the trial court and in the application filed in support of the same. Learned counsel for the respondent submits that as the application is not, the IA that's filed in support of the application does not contain any reasons why he was not prosecuting the matter, why the delay of 3 years has occurred. The court has rightly dismissed the petition and there are no reasons to interfere. It is submitted that it is settled law that these kind of delays without any valid grounds cannot be condoned for the mere asking for the same. Next, having heard the counsels on either side, there is a material on record. As rightly submitted with the learned counsel for the respondent on the face of it, there are no reasons stated for not filing though the reasons are stated, those are not the reasons on which the court will consider the delay. This court is more driven by the fact that there are about, along with this, there are about 3 partition suits. In other 2 partition suits, both these parties, both the petitioner and the respondent are the parties. And in that the petitioner has already filed his written statement. In those circumstances.
They have not been disclosed the other connected cases.
No, I have narrated in my written statement at page number 42, my lord.
And he has already filed his written statement. In those circumstances, this court is of the view that the delay in filing the same needs to be considered, and he should be given an opportunity to file the written statement, however, on cause. Hence, this court is passing the following order. The order impugned dated so and so, passed in so and so, is set aside, and consequently, the IA filed with the petitioner under order 8, rule 1 is allowed on the condition that he shall pay an amount of rupees 50,000 to the plaintiff.
Lordship, 50,000, 20,000. 50,000 is really allowed. 20,000.
If you don't pay,
20,000. 50,000 is.
This is not a case to be entertained at all. If you want, I can just dismiss it.
At least 25,000.
Yes, to the petition, to the plaintiff.
Number 36. 36, serial number 36.
Yes.
Lords, it's 21162 of 26, my lords, the first petition. My lords, in this I have prayed for restoration of written statement and defense, my lords. My lords, it's a suit for eviction suit, my lords. My lords,
That's a suit filed.
my lords, suit filed in 2023, my lords. Suit filed in 2023, my lords. My lords, and
When did you file this IA?
my lords, the plaintiff has filed application on 21/8/2024, and it was allowed and ordered to deposit 21,000 from the filing of the suit to the, till the disposal, my lords. My lords, and later, my lords, on 4/9/2025, my lords.
What is the impugned IA?
My lords, the trial court has struck off the defense of the defendant, my lords.
Because
Struck off the, my lords,
you have
because,
not paid the amount.
my lords, we have paid amount for, my lords, I have paid 1,42,000, my lords. And in the last occasion on, my lords, on 8/7/2000, on,
I have passed an order that whenever an order is passed by the court, you do not comply with it. The court has to. If you are a respondent, court has to strike
my
off the
lords, my lords,
defense. If you are a plaintiff, the court should not proceed with the matter.
my lords, I have paid amount, my lords, and my lords, all,
Paid the amount. It
My
is
lords.
about, have you complied with the order in toto?
my lords, my lords, not in full, my lords, but I have requested the court to give some time to, that I have applied a loan, my lords. My lords, and also I have showed bona fide by paying 1,42,000, and again
What
in
is
the last
outstanding?
occasion. My lords,
But
it's,
after taking into consideration all this thing, 5,30,000 rupees.
That is bona fide. Out of outstanding 5 lakhs, paying 1 lakh.
my lords, I have requested 3 weeks of time, my lords, to pay full amount. I have applied for a loan and I will pay it, my lords.
Pay the amount, then come to the court. I will
Unless and
will
all-
set aside this order.
My lords, and the other one is, my lords, I have filed an application to recall and reopen the cross
All
examination.
that will happen, first of all, this is restored. Your defense and all,
Right, my lords.
once that order is restored, so you pay that 4.5 lakhs or whatever, 5.5 lakhs, whatever is outstanding. I'll keep this matter pending. And then we will set aside this order. The other order also will set aside. We will allow your writ petition.
My lords, I request your lordships to extend that time, my lords, like,
Nothing, no time. If you want any interference from this court, you have to pay the money. Yes, when do you want?
my lords, next month, my lords.
This is matter on September 15.
My lords, the second week, my lords. Please, my lords.
List on September 9th.
My lords, till then, the matter may be still. my lords.
What do you think that just like that court will stay the proceedings?
My lords, because my lords, the trial
What is
court.
happening now?
My lords, now it's listed for arguments, my lords. My lords, if that is, if the case is proceeded in,
No, you are getting what you couldn't get from the trial court, you will get it from this court.
my lords, if that is the thing, my lords, I lose my opportunity to cross-examine the plaintiff, my lords.
When was the order passed to deposit the money? How long
Plus-
back it was?
Plus 21/8,
21/8/2024 is when the order passed. 21/8/2024 is when the order was passed, stating that from the date of suit, 21,000 admitted rent, you pay the amount. My lord, that, my lord, is not paid. Hence, my lord, in 2025, we filed application to strike off the defense. That order is passed on 18/6/2026.
My lords, in the meantime, they have filed one more contempt petition which is pending before High Court, my lords. Rather than
Any
filing
stay.
execution,
You
my
want-
lords.
You want any stay, pay some amount on that, I'll grant stay. Either of it, Nana, all I'll not, for the entire payment, I will not wait till then.
This matter may be listed on second week of September, my lords. I'll seek.
I will not grant any stay. I'll post it on that day. If you want stay, pay some amount, I'll grant stay.
Lords,
Is the matter same like earlier date? Next, both the matters.
date.
Yes.
Number 39. Bharat K. for petitioner.
Petitioner, kindly have day after tomorrow, my lord. We engage senior counsel services. It may be taken up day after tomorrow or Monday, my lord, they need.
Next week, Wednesday.
That's
Yes.
Serial number 40.
My lords, I appear in this matter for the respondent on caveat, my lords. My lords, just want to make a submission. This is connected to the matter that my lords, in fact, my ladyship heard last week. If the court recollects and that matter was dismissed but the judge order is still not out yet. It's the same parties. Whether execution issue where 50% the court had directed, if your ladyship recollects.
Yes, sir.
This was dismissed. Now, in the Order 9, Rule 13, also similar order is passed by the trial court because it's the same judge, and again that has been challenged.
Lord, this application has nothing to do with the
What to do,
execution petition. Lord.
No, any one order I have passed, as the senior counsel says, I'll ask it to be like, I think it is not.
Lord, will kindly refer the.
Not ready
please
yet.
read that order, Lord. The impugned order is important, Lord.
Read.
In one case, says 50% I have to deposit. In other case, it says 40%. I'm alleging about the fraud, my lord. They have suppressed the material documents. And because of that suppression, the entire, the amount will be reduced,
We'll have it
drastically
after
reduced to the
tomorrow.
nil, my lord.
Can it be next Tuesday, my lords? Can it be next Tuesday, 18th? 18th or
Lord, there is
19th?
execution is there, my lord.
No
They have
execution.
the
Execution came
thing.
on
They have to
20th.
give me an undertaking that until disposal of this case,
No,
nothing they'll
no.
take
No
action.
execution order is
Till
passed. It's
next
on
date of
20th.
hearing, whatever, my lord.
This is
Nah,
matter
my
on
lords, we are not
Tuesday.
giving it.
When a senior counsel representing the counsel for the respondent submits that, no, they are not, no, they have not initiated execution proceedings.
No,
Is it
no
correct?
order is passed on any attachment. Nothing is passed as of now. Because it is.
List is matter on Tuesday in the first list.
Yes, great.
And the respondent shall not precipitate the
My lords,
execution.
let there not be any direction because the date of execution itself is on 20th. It's
Then you
identical.
have- When is the execution date?
20th. Next date is 20th or 21st it is.
Then it's coming up before that. What will they will do?
Lord, the 22nd is the application is there on 22nd, but I don't have any order because in execution also I have to deposit 50%.
22nd is also a long way. Tuesday is
Yes, my
before
lord,
that.
there both the matters are coming on the same date. One is execution case,
When is it coming?
same 20th.
Tuesday is, what is the date?
18th. my lord.
18th.
18th is fine, my lord.
That's
Yes,
the date.
that's all. 18th I'm seeing. Great.
But earlier, page 86 for his lordship's order, earlier order, it said that I had filed a claim for about 3 crore 60 lakhs. I had filed an application that the property was auctioned by a different bank. And about 5 crores was remaining. I filed an application that the 5 crores should not be released because my suit was there for 3 crore 60. The lordships directed the trial court not to look to D4 filed the application. Earlier, bank had filed the application, asking the court what should be done. Then, Lord, your lordships directed that I may be permitted to file because I had filed a 38 Rule 5 application. It was not decided. Lordships directed both applications to be decided once for all.
Now the order is passed.
Yes, now, Lord, 38 Rule 5 application, Lord, we have filed a WP CPC listed at 91 today, 95. That, Lord, I understand it should go under order 43 because 38 Rule 5 should go. We'll file a conversion memo, Lord, for seal number 95. Now, Lord, this is an application where the bank asked the court, what should I do? Whether I should keep that amount. That is a bank which had auctioned the property. Asked the court whether I should keep the amount or whether I should realize it. Now, Lord, since the main application will be 38 Rule 5, now they are also trying it. The bank will also release the DD.
Then if after conversion, let him convert it, I'll pass order.
Yes.
It will go along with that MFA.
This could go along with that, but not till that
But
MFA.
MFA is not filed.
MFA, no, I'll
That
convert.
to be filed. So what we
Yes.
do is we keep this pending.
Yes.
That 95, where is that, where is 95?
Seal number 95, Lord. I'll file the conversion memo now itself. And your lordships may direct the office to
Yes.
permit me to convert.
Yes.
But in the meantime, Lord,
Meantime,
till
no.
the 38 Rule 5 is decided, if they release the DD, Lord, what the
Because
court holds, Lord.
Either you argue it on the merits of it or you go with this relief. Both I can't consider.
Lord, what
at
has
a time.
happened is this, the trial court, I had an agreement with them. This was with regard to vehicle loan. I had a single agreement with them, with the main
No,
body.
I'll hear it. I have absolutely no difficulty in deciding this matter.
Yes.
But when you say this has to go along with
No,
that.
Lord, no, I'm not saying that.
No,
This
not-
I would want your lordships to say,
Then
hear
I
this
will
and
hear
decide.
it, I will hear
Yes,
it.
then, Lord, I'll just, yes.
Yes. What is order?
Annexure A, page 31. Lord, for a moment, kindly see that agreement between them and me, Lord. Annexure B.
The I number 2 filed by the plaintiff under order 38 is dismissed. I number 1 filed by defendant number 4 is the bank,
Yes,
is disposed of.
Is
What did the
disposed
court say? Let's look at the order first.
yes. Lord,
Para
kindly
14?
see. According, 31, page 31. I'll read from para 13, Lord.
Para 13.
13. It is also noted point that as per seeking of order 38 Rule 5 of CPC at the stage of suit, if this court has satisfied or otherwise the defendant with intent to abstract or delay in execution of any decree that time, the court may pass an order of attachment before judgment of the suit property. However, in the present case, suit property was mortgaged with the defendant number 1 to 3 with defendant number 4, wherein defendant number 1 to 3 were failed to pay the entire amount. Accordingly, the scheduled property was sold in public auction. However, after deducting the loan of rupees 1 crore 39 lakh, defendant number 4 has to return the surplus amount of 5 crore 68 lakh. The plaintiff has not pleaded that the surplus amount of rupees 5 crore 68 lakhs is in custody of defendant number 4 in the plaint, because Lord, by then I was not aware of the exact amount. However, after conducting the auction sale and the loan of the defendant number 1 to 4 was secured, the loan and defendant number 4 is intended to return the said amount by way of DD, either defendant number 1 to 4 or the court. Therefore, in this background, there is no any point that defendant number 1 to 4 was caused delay in executing the order. There is no any decree against defendant number 1 to 4 till disposal of the suit, or he is avoiding to appear before this court. Now, this is important, para 14. It is also noted point that as per averments of defendant number 1 to 4, the plaintiff has sanctioned loan in favor of borrowers of 457 persons. However, 457 persons were not party in the proceedings. In support of the contention of the plaintiff, he has relied on 9 documents. When the plaintiff has submitting binding agreement, and accordingly they have mentioned about scheduled property. So the scheduled property was mortgaged to the defendant number 4. It is also submitted as a loan structuring agreement, wherein also some kind of a period of 8 months for restructuring the loan repayment balance. Accordingly, the loan agreed by the plaintiff for rupees 10 lakh. However, the schedule has been mentioned. Therefore, considering the documents relied by the plaintiff, there is no any other document pertains to show that loan was paid by the plaintiff to the borrowers, and the list of borrowers was not submitted. Though the document in page 32 was submitted by the details of loan amount was mentioned, and payment of EMI was not mentioned in the document. Therefore, at this stage, it has come to conclusion defendant number 1 to 3 were not avoided for execution of any decree. Hence, I am of the considered view that the payment of surplus amount by defendant number 1 to 4, defendant number 1 to 3 is his choice. Therefore, the plaintiff has not made out any grounds to attach the amount. Now, Lord, they say 457 persons, I should have added the agreement. Now kindly see para 15 minutes. It is also pointed loan obtained by defendant number 1 to 3 from defendant number 4 and defendant number 4 was auctioned the property for some amount is beyond the scope of the suit. That is how the court treats it.
You are the plaintiff in the suit.
Yes.
What is the suit for?
Suit is for the kindly see, Lord, page number 50, 51. Now, Lord, before taking loan from me, he had said
The defendants
to pay 3 crore 60 lakhs, directing the 4 defendant to create a lion on the scheduled property, which is this property which was sold. They are directing the 4 defendant to pay the outstanding amount of the defendants hearing to the plaintiff out of sale consideration. Now, Lord, before taking this, taking the loan, Lord, kindly see page number 34. Before taking the loan, he said, I have a loan with defendant number 4. I will clear that loan and I will execute a mortgage for you, to me. Page 37.
Yes.
About two paras from the bottom. Whereas the first party has requested the second party to take over the existing loan with HDB services, which is defendant number 4, and shall continue to mortgage said property to second party after the discharge of the said loan with HDB financial services. That scheduled property was the same property. 16/1. Kindly see 38 second paragraph. Additionally, first party shall transfer all deposited original title deeds to second party collected from HDB financial services accompanied by a loan clearance certificate without any further obligations. First party shall authorize second party to collect the original title deeds from HDB financial services on clearing the loan proceeds with HDB financial services. Before availing or utilizing additional loan based on sanctioned order, first party will execute an equitable mortgage by depositing title deeds. Additionally, first party agrees to execute a supplemental deed of mortgage for the additional loan if required beyond the sanctioned order. So, Lord, he was supposed to use this 360 to clear loan with HDB services and then execute the, and if he wanted further additional loan, he had to execute this mortgage deed.
Now, what the bank did, bank sold the property.
Bank sold, in the meantime, bank sold the property. It asked the court, what should I do with the additional money? Court should have.
No, you're filing this as far as your 151 CPC is concerned.
Yes, Lord.
What is that application under 151?
151, it was filed by defendant number 4, bank, asking the court whether it could release or
No,
it could
this
deposit.
petition is only as far as that is concerned.
Yes.
Who appears for this plaintiff?
My lord,
I mean, the defendant.
defendant number 4.
Bank.
Yes. No, I am not appearing for defendant number bank. I
Then
am
who?
appearing for defendant number 3.
Who is the owner of the property?
My lord, yes, owner of the property. My lord, here the facts are little different, my lord. My lord, here 457 borrowers are there. I am a facilitator of the loan. My work, my lord, is that I am a company which sells two-wheelers. I am not the borrower of the loan. I am a company which sells two-wheelers, battery make two-wheelers, which was sold to 457 persons. In the meantime, these 457 persons were availed loan from the plaintiff. I am not the principal borrower. I am only a facilitator.
Just now, yes.
Page 35 binding agreement.
That binding agreement, my lord, is not in respect of these 457 loans extended to 457 persons.
What is this?
This binding agreement is for the purpose of taking over the loan from the fourth defendant who had extended a loan to the company, first defendant company, and this is only in respect of taking, and
Who are the parties to this agreement?
this agreement, my lord,
Between you and the plaintiff.
company is a party.
That's what, between you and the plaintiff.
Yes, that is true.
He
But
has-
my lord, this agreement,
He has sought for enforcement of this agreement.
yes. No. He has not sought for the enforcement. This agreement, this binding agreement has never came into force. This was not fulfilled. If your lordship kindly look at the contents, kindly see page 36, my lord. Whereas Dial
No.
Legal India Private Limited,
Earlier when I heard this matter.
Please.
And an order is passed, I think this is not the.
this
line-
order was passed by your lordship
This
when
defense
there was
was
no
not-
opportunity was given.
Represented.
Please.
Ravishankar.
Ravishankar.
Dear Ravishankar,
Yes,
I
yes.
remember.
Correct.
Yes.
He has appeared.
Argued on
Argued on
securitization.
your behalf. And he was also argued on the surface rules.
Yes.
And all,
Correct.
when I'm remanding the matter, he said, what is the scope and all, your lordship may not dictate it because it is, your lordships are it amounts to prejudging the.
My lord,
demands.
in that order, your lordship may also find that the plaintiff in this case did not argue the case at that point of time. Order was passed without hearing their arguments by the commercial court, by the trial court.
No,
Then
no.
your lordship directed.
No, I heard the council, somehow did this now, what are the you are submitting?
Yes.
Appears to be like different
It's a
facts
new.
from what it was, I heard.
These
from the
are
last
all
debate.
the facts, my lord. I am not the principal borrower. These principal borrowers have not been made as a party. The suit itself is not maintainable, in fact.
That you will take that plea before the trial court.
Trial court,
Please,
it's a trial
but my
issue.
lord, at the same time,
No, before going into all that, for this 151 application, what are your objections? Show me that. Where are
That
they?
is at page. Where is it? Objection. Objection. But we have,
At page number 70 is there,
yes. That is my objection, Lord.
your objection. Then what about their objections?
They didn't file objections to that, I think.
Yes? You have not filed?
They have not filed, Lord. Because it was
Defendant
not
number 123, it's there at page number 80, what is that?
page 80. Objection, what is it? Defendant 123 on IU4. This is mortgage.
No, this is my application. My application. of
80,
Objection.
page 80,
80. Objection.
80.
Objection to my application, sir.
No,
38 rule 5 application.
this is objections to 38 rule 5 application. My 38 rule 5 application. You sure?
Yeah. Can see the date. 38 rule 5. Attachment, claim attachment before the judgment.
Para 10, it says plaintiff without proving bona fide claim attachment before the judgment
Yes.
cannot be granted.
my lord, these two, both the IAs were, my lord, with a single order, it is.
So then we will hear it, we'll
My
look
lord,
at the
my
objection.
submission is that the trial court has passed the order in conformity with order 38 rule 5 only.
We
My
are
lord,
not
there is no
hearing that.
obstruction. I have not caused any
We are
obstructions.
not
It's
hearing
been.
38.5.
Yes.
38.5 MFA they will file. It's an independent writ petition at 95 or 96. We are only under 151. What are your objections for that? If you have filed a common objection, that also will read. Please tell the court what all the objections you are submitting now.
file objections to only 38 to 5 and not 40, 151 objections as per different because it was a nearing to their benefit. The release was to be made in that year. So they didn't file any objections.
Rule 5, application. Yes. Illustrate.
DD is not been used. DD is not been.
Page.
You have stated at page 82. No, I'll be assisting you.
Sorry, madam.
82.
Please, madam.
Now what the court has done with this, what the bank is going to do?
No, my lord, bank wants to give the DD directly to them so that they can draw it.
Told that it's outside the scope.
Wait, because it's, court says it is outside the scope of the suit.
Earlier, it was directed to file indemnity. No way of they have directed, no interference.
Who appeals to the bank? Bank is not
Nobody
served.
will take it.
No, nobody is.
Nobody will take it.
Come up with all the documents. I'll hear you. We'll post the matter next week.
Please.
And in the meantime, let them not hand over the check to DD to you. Let it be with the bank.
My lord, bank has not come. Actually, they have.
Pass an order.
Yes.
You're here. Leonard agreed with the order passed under 151 CPC. The present writ petition is filed. When the bank has asked has the permission of the court, what is to be done with the surplus amount after deducting their the loan? The bank has not given any direction, and in fact, it is observed that is outside the scope of the suit. Then senior counsel representing the land counsel for the petitioner submits that if the bank had in fact that is one of the prayer made by the plaintiff in the suit.
Yes.
One of the prayer made by the plaintiff, one of the prayers sought by the plaintiff in the suit, and if the amount is the DD is given to the handed over to the defendant number 1 to 3,
yes,
it would cause a lot of hardship to the plaintiff. It is submitted that the court has failed to consider the same, and in fact, the court has every authority and jurisdiction to decide the same. When counsel appearing for the respondent, defendant number 1 to 3 submits that in fact, the loans were obtained by 451.
457. They are the principal borrowers.
Principal borrowers, and they were not made parties to the suit, and the binding agreement has nothing to do with the said transaction, and he submits that he'll come up with his detailed objection considering the same. This court is passing the following order. Which respondent is the bank?
Fourth respondent.
The fourth respondent shall not hand over the DD to the respondents 1 to 3 till the next date of hearing.
Please.
List this matter on when do you want?
Next week, my lord.
List this matter on 18th of August.
Next week I'm not there. 24th, next week I'm not.
24th of August in the first list. And that matter, one matter will be out of my list. I'll be happy. Where is that 92?
95, my lord. I'll file a memo seeking conversion.
95. A memo is filed seeking to convert this writ petition into a MFA. MFA. Accordingly, the memo is taken on record and the petition is permitted to convert this writ petition into MFA. within 1 week from the date of
Please.
receipt of the copy of the order.
Please,
Yes.
oblige.
For 42,
No.
42, memo is put.
Might I beg leave minutes to appear along with the counsel.
What is that?
Might I beg leave to along minutes along with the counsel for the petition?
Yes.
Please.
Yes.
Defendant before this court. Amendment rejected.
Huh?
The defendant is before this court, minutes.
Is it on? The mic is on?
It's on. Minutes.
Yes.
Defendant is before this court. Amendment application is rejected. Stricto sensu, the plaintiff did not have any objection to the amendment. The lordships could see the impugned order for a moment. It starts not at page 15.
Page number?
15.
Yes.
Para 8, my lords. Page 20.
This is a suit of 2025.
Yes, my lords. And it's a
What is the impugned order?
amendment application.
What is the amendment you are seeking?
My lords, it's a section 6 suit, my lords. Now, my lords, there is a plea which has been raised to the effect that the plaintiff who has
So the suit filed 2025.
2025.
1/8/2025.
August 2025. Now, my lords, there is a
Then how many days?
6
6
months.
months it has to be decided.
6 months it has to
Maybe
be.
that's the reason why the court has decided.
Correct.
In fact, my lords, the court says this. The reason why the court says I am not going to get into this is 24. My pardon, my lords, 23. Para 11. So there was an endorsement, but not, there's an inquiry which has been.
Shall I allow this writ petition?
My lords, I have a few objections, my lords. Why?
But unfortunately, you have no objection.
My lords,
before
I
the
have,
trial
my
court.
lords, but I need to justify, my lords, because the trial court has taken great pains. And my lords, this, as your lordship said, suit, my lords, was filed on 1st of August. 382 acres, my lords, have been dispossessed. Suit, my lords, is for damages as well and possession. My lords, in the written statement, my lords, they admit that I am the owner. Now, my lords, they want to retract this admission by way of an amendment.
Then why did you say that you have no
That's,
objection?
it has happened, my lords, but as your lordships pointed out, and even the trial court, my lords, as observed, my lords, whether I say no objection or not, the court, my lords, needs to see whether, my lords, the amendment would be relevant.
What
And-
was the earlier written statement? What is the?
Correct, my lords.
What is
In
that?
the earlier written statement, as your lordship sees, my lords, page 48. In page 49, my lords, they in fact say, plaintiff is the absolute owner of the suit schedule properties measuring 382 acres of coffee land situated so and so. Now, my lords, this is the admission, my lords, in the written statement that the plaintiff is the owner. Kindly, my lords, kindly see page 57, the amendment application.
Oh, they say you are not the owner.
Correct. Otherwise, there's an admission in the written statement that I am the owner.
But very unfortunately, you have no problem with that.
My lords, what happens, my lords, is the situation is like this. 382 acres, my lords, have been dispossessed. My lords, every 6 months or say 8 months, they are plucking the coffee. Pepper, my lords, is being taken with them. Almost 5 crores, my lords, is a loss every month. My lords, I have a request, my lords. My lords, may I allow this writ petition? My lords, now 6 months, my lords, now is already 12 months over. Let's let them be put on terms. Kindly see, my lords, they're not cross-examining PW1. Evidence has commenced. And my lords, at the time of further cross-examination.
No, why you are accepting for that such inconsistent plea, which goes to the root of the matter?
My lords, because it doesn't. Because, my lords, I'm confident that the order that they are saying, my lords, that it is not an inarm land. My lords, it is an inarm land. I have been granted the land. Therefore, my lords, I can substantiate. But, my lords, I'm not able to avoid them taking adjournments, my lords. That's my biggest problem.
Yes,
And
what do you say on that?
Lordship may put me on terms.
How much time?
My
3
lords,
months?
plaintiff evidence is yes, my lords.
3 months?
Please, my lords.
Please. The agreed with the orders passed on I number 14 in OS number 44 of 2025 dated 6th August 2026. The respondent defendants are before this court. The suit is filed under section 6 of the specific relief act. In the said suit, the IA is filed seeking amendment to the written statement that came to be rejected by the court. The court also observes that the plaintiff has no objection for amendment of the pleadings. However, considering the fact that it's a suit under Section 6 of the Specific Relief Act, the court has considered about the delay and how the application, even if the plaintiff has no objection, and how the case has to be considered. This court has perused the order. There is no infirmity with the order passed by the court. However, without unnecessarily delaying the matters and dragging on the proceedings, this court deems it appropriate to pass the following order. The writ petition is disposed of. The order impugned dated so and so is set aside, and the writ petition is allowed. Consequently, I number so and so is allowed. The trial court is directed to complete the entire proceedings within a period of 3 months from the date of receipt of the copy of the order. Number 3, the petitioner shall not take unnecessary adjournment and shall not delay the proceedings.
I have one intent. Your Lordships have granted me everything. Can it be made 1 month more because we have the vacations in between? That not.
What is that?
We have vacations in between. So
Vacation?
there are vacations in
My lords,
between.
my trial court statistics, my lords, I am aware, my lords. I've been
Possibly
going for
one
this
more month,
matter.
I'm not-
The
I
court
don't
is
want
free,
too
my
much of
lords,
time.
to take up this matters.
Can it be made by the end of January? My lords, we'll be able to finish the entire term. That is my undertaking. We will not drag beyond that.
We are in August,
We are
September,
in August.
October, November.
We have two sets of holidays, one in October and one in December. So
But still, it will be done. That's a court's problem. It will
can
take
we just have it, so at least by the end of Jan 15?
3 months.
Obliged.
Item number
Very
43 for admission matter, Prakash Timanda
Deep
and for petitioner.
Yes.
Lord, my application seeking rejection of the plaint, Lord, came to be dismissed. Lord, the first respondent plaintiff, Lord, filed a suit for mandatory injunction, Lord, a peculiar suit, Lord. I have produced the copy of the plaint, which is at ink page 27.
Suit for injunction.
Suit for mandatory injunction.
Mandatory
Directing
injunction.
the executors to execute.
What is the application filed?
Pardon?
On what grounds this application is filed?
No cause of action and barred by law of limitation. But the facts are these, Milord. Milord, the maternal grandmother of the first petitioner here in Milord executed a will bequeathing the sole property in favor of her son as well as the daughter. After the execution of the will, Milord, the suit property came to be acquired by the central government through the income tax department. Lord, the testatrix, Lord, they received the total compensation amount and distributed the same among the children and the relatives. Lord, this fact, Lord, is aware. But the plaintiff was aware of the fact because
was this stated in the plaint?
What he has done is the acquisition, my lord, he has challenged before the competent court, and his plaint came to be rejected by way of rejection of the plaint. My lord, that he suppresses, and he simply says after 30 years of the death of the grandmother, he comes out with the case of directing the executors of the will to give the books of accounts. Lord, that is the property itself was acquired during the lifetime of the testatrix.
That is what I asked you, precise question.
Yes, ma'am.
Whether all these things are stated in the plaint.
He says regarding the execution of the will, and he says that the property in question was the subject matter of the will, but he specifically conceals the fact that she has disposed of the property was not in existence during her lifetime.
At this stage, how can the court consider all these aspects?
Lord, for the purpose of rejection of the plaint, Lord, if the plaintiff, Supreme Court says, I have got the case law, Supreme Court, Lord, says that if the plaintiff by clever drafting, if he conceals the material facts, my lord is aware under order 6 rule 2 say order 6 rule 2, the plaintiff is bound to
No,
disclose.
concealment of fact has to be revealed by somebody. That will be revealed by you. That is a defendant.
No, my lord,
Does the Supreme Court say that that concealment of fact which is revealed by the defendant in the written statement can be looked into under
Yes,
order
my lord.
7 to
Yes,
11?
yes, yes,
Please give that.
yes.
Sir, take that. Yes.
My lord, may kindly peruse
This is
paragraph
Karnataka
6.
judgment. There are judgments of the, so many judgments of the Supreme Court.
Allah, Supreme Court is referred, my lord, I have got that copy also. I
Yes.
got that copy also.
Yes.
Paragraph 6, my lord.
Hmm.
If the plaintiff is subjected to scrutiny, it appears that the plaintiffs have founded the reliefs mainly containing that the GPA dated so-and-so was the only document executed by them and their father in favor of the defendants 1 and 2. They say that they had to join in execution of the GPA with their father on the insistence by the defendants 1 and 2. The argument of the petitioner's counsel is that the plaintiffs have deliberately suppressed two important transactions, namely execution of the agreement of sale and the affidavit, which were contemporaneous transactions. The next sentence is important. The petitioner's counsel has produced the documents which he has concealed. The defendant has produced it. In the background of the well-established principle that the only plaint must be seen for deciding an application under order 7 to 11 of the CPC, a question whether these two transactions can be considered would be obviously arise. This is what the question arose before this honorable court. Application under order CPC, a question whether these two transactions can be considered would obviously arise, as has been pleaded by the plaintiffs. If GPA was the only document that came into existence as 23/1/2002, definitely the plaintiff's case that they are entitled to 1/3 share in the suit scheduled property becomes an issue to be decided after recording evidence. If not, they must fail at the very threshold. And now, if para 10 of the plaintiff, that I do not want to trouble, my lord. The next case law is also, my lord, is of important, but since this has been already recorded, and he wants to write on the defendant by suppressing those two material.
Here, what I couldn't understand from this order is, where did the order says that we have to look at the written statement filed by the defendant or the defense of the defendant?
No, not looking at the written statement, my lord. But unfortunately,
The
my lord, the learned
main aspect is, according to you, the property is no more in existence. It has been acquired by so and so. Compensation is dispersed. Who will tell the court all this?
Pardon,
how will the court know about all these facts?
my lord, that is, I have produced the written statement filed by the plaintiff in the collateral proceedings in the another
Correct,
suit,
correct.
wherein he has admitted.
Can the court look into that?
Lord, that is what
I'm not able to understand that that is the ratio laid down. Where is that?
Yes, my lord.
Show that particular paragraph.
Yes. I will read paragraph 6, my lord.
Yes, please.
This says like this, my lord. If the plaintiff is subjected to scrutiny, it appears that the plaintiffs have founded the reliefs mainly contending that the GPA dated so-and-so was the only document executed by them and their father in favor of the defendants number 1 and 2. But in this matter, what happened is, if a plaintiff says only one document was executed and not any.
The court has looked at the petitioner counsel, that is a defendant counsel.
A defendant counsel. That is a defendant counsel.
But under which Where is the judgment I'm asking? Because the judge, another coordinate bench has looked at the document produced by the defendant counsel, that won't become a precedent.
No, my lord,
So-
I have got the certified copy of the admission.
Please show me one judgment which says that while deciding under order 7 rule 11, court will look at the documents produced by the defendant. If you say,
I will point out, my lord. I will point
not
out.
from this judgment, this is not a law. Judge has just looked at it. That doesn't mean that that's a law. There are judgments of the Supreme Court. If you can show me one judgment, then we will go ahead with that, not with this.
My lord, may kindly have it tomorrow. I will produce. Because this
Tomorrow
is
we'll
of,
have it next week.
Lord, this is of importance. Therefore, I just.
No. If it is like, I will definitely understand the law and go further, but we have to follow law, what is already
Exactly.
settled.
I will produce the authoritative judgment.
This is matter next week in the first list. Yes,
Lord,
give some
a
date.
specific date may be fixed.
That's what. They give the next week some date.
Number 44,
Great.
44. Manasa MB.
My lord, I'm being led by senior counsel in this matter. It's a rejection of plaint application on the challenge. May I please request for tomorrow, my lord?
Tomorrow it's not possible.
On Thursday, my lord.
Next week Tuesday.
Monday, my lord. Monday.
Tuesday. Yes.
Then number 45, Sidramaya VP.
Very good petition. The respondent number 1 has filed a suit for recovery of money, alleging that father of the
All
petitioner,
the 230 matters. Yes.
the contention of the respondent number 1 is,
And 1 minute. And after this, 230 matters, and then any other matters. 230. Then we'll. But all that orders maintainability matters are there that we will call so that the list will be reduced. Yes.
whether page number 29, father of the petitioner,
What is impugned order?
whether respondent number 1 has filed a suit for recovery of money. His contention is father of the petitioner, when she was a minor, has borrowed a loan from the respondent number 1, and he has issued a check for discharge of the loan amount. Subsequently, he died. He has filed a suit for recovery of money. My lord, we have filed an IF for rejection of the plaint under the provisions of amended section 6 class 4. Daughter is not having the pious obligation, daughter or son or grandson not having pious obligation after commencement of the Hindu Section Amendment Act 2005. So for a moment, my lord, section.
Let's look at the order, how the court had dealt with it. Then we'll look at the provision.
Yes, order is at page number 17, madam. Regarding the provision at page number 19, the trial court has passed an order. This is the contention we have taken, para number 9. After appearance, defendant number 1 to 4, the defendant 1 and 2 filed their written statement. During pendency of the suit, defendant number 1 and 2 are died. Their LRs already on record. Based on the pleadings, the issues are framed. The plaintiff adduced his evidence, also witness, and closed this side. The matter posted for evidence of the defendants. The defendant number 3 examined as DW1. The matter posted for argument. Defendant number 4 attained majority at that time. Majority under guardianship is discharged. The matter posted additional written statement of defendant number 4. At that stage, counsel for defendant number 3 and filed the above application seeking to reject the plaint on the ground that in view of subsection 4 of section 6 of Hindu Succession Amendment Act 2005, there is no cause of action to file the suit. On the other hand, the counsel of plaintiff in his obligation to the application taken contention for designing the application under order 7 rule 11 A and D, the averments of the plaint alone must be taken. The defense of the defendants cannot be considered. As per section 289 of principles of Hindu law, pious obligation of son, grandson, and great grandson pay ancestors debts.
Yes. That all depends upon proportionally to what you inherit from the estate of the deceased.
My lord, we have not received any estate of the deceased.
And that the court will decide that.
My lord, there is no pious obligation on the daughter.
When you inherited the property.
No, we have not inherited any property.
That is a question to be
He never
decided.
pleaded. What is the property we have inherited? So he is having only one property. Sorry, he is not having any property. Say there is not inherited any property, it's a pious
Not,
application. Is not
only to the extent of your inheritance from his properties, you are liable to pay under the recovery of money
My lord,
suit.
I will read for a moment of section clause 4, my lord. After commencement of this act, there is no pious obligation at all. So this is simply year 2022.
No, I'm
And
telling
also,
you
my
this,
lord, it is not
you
his
have
personal-
inherited the properties of the deceased.
Yes.
Are you not supposed to pay that?
No, yeah, as per section 6 clause 4, there is no such obligation. Say, for a moment, 6 clause 4 may kindly be read, my lord.
Yes, we'll see. Notice to the respondent.
My lord, to 14th it is posted for argument, my lord, it will be infructuous.
What are you doing till now?
My
What
lord,
is the purpose of filing this application?
immediately after she attained the age of majority, she has
I
discharged
know you
and
have come
she
before
filed
the
it
court
as-
now. We will not stay the proceedings next
Well,
week.
otherwise it will be infructuous.
Next week. Hand summons, the memos are filed.
My lord, notice to R2 may kindly be dispensed.
Yes, a memo is filed seeking dispensation of notice to R2.
R2.
Dispense with.
My lord, otherwise, my lord, a petition will be, petition will be.
You have waited enough time.
No, we
For
have not
filing an
waited.
application
Immediately
under Order
after
7
discharge,
to
I have filed application.
Order 7 to 11, when after the arguments you file a Order 7 to 11 and
My lord,
come to the
it's
court.
it's a minor's right, my lord. Minor immediately.
Why
after
you have not decided, why you have not understood suit of which year?
My lord, minor has no subsisting right at that time. She cannot take defense at that time. Immediately after she attained majority.
When she attained majority.
My lord, she is 20 years right now. I am immediately after completion of 18 years of age, we have filed return statement. I have filed application for rejection of plaint.
No, rejection of plaint as far as the defendant is concerned, it has to be rejected.
Yes. Yes, as far as my right is concerned, it has to be rejected. My father has died, grandfathers have died, and I have no
So
brother.
partly the plaint has to be rejected.
Mother?
Partly.
Partly it has to be rejected.
It can be rejected.
Yes, it can be rejected. So as far as on me is concerned, I have to be rejected. I was a minor at that time. I do not know any business transaction of my father, and also it is.
Next week. Orders, call the orders matters.
Matters for orders, cell number 69, Arjun Santosh.
Plaintiff, my lord. Lord, present the requisition is filed.
What non-complaints? I'm not hearing the matters. What is this
my lord,
non-complaints of officer?
Non-compliance, the objections regarding a single order.
For those two IAs.
Yes, my lord. But my lord, on similar matters, connected matters, my lord, I already allowed those office objections. In petitions 7964 of 20.
It is submitted that in similar matters, office objections are overruled. List along with.
May I be permitted to take a service through hand summons also?
Yes, notice, hand summons. Yes, next 70.
Cell number 70, VV Prakash.
Yeah, it has to be heard. Let it be in the list. 71.
71, Sagar BB.
Yes, 71. Give that.
Maintainability, Sagar BB.
Give it to respondent.
No, with regard to me. What are the two IAs?
Well, two IAs, one for recall reopen and the other one is for.
Office objection with regard to the maintainability is overruled.
In fact, besides the matter, it's got to do with.
No, it will be there. It won't be there in the orders. It will come in the other.
Filing of written statement beyond 120 days in a commercial OS, my lord, squarely covered.
Yes. Yes. Overruled. Yes, next 72.
72, cell number 72, Lingaraju KR.
Yesterday's matter, my lord. I'm pressing for interim order.
Yes, tomorrow. Next.
Cell number 73, cell number 73, Pushma HR.
Yes, tomorrow.
Cell number 74,
Yes.
Altogether
Yes, 75.
75,
Tomorrow.
Abraham Joseph. Cell number
75, I pay for the petitioners, my lords. On maintainable.
75.
Yes, my lords.
Huh.
On
Maintainability.
Please, my lords. Ex parte IA was rejected, my lords. That's why I filed a writ petition, my lords. It's covered by a judgment of the coordinate bench, my lords. I have.
Is that? There is another judgment, I think.
But it is a complicated question, my lords. There are 2018, my lords, a coordinate bench has held that a writ petition is maintainable, my lords. Earlier this year, another coordinate bench has held that a appeal is maintainable, my lords. Then once again, my lords, in June, the coordinate bench holds that an appeal is not maintainable. So I will leave it to my lords. But in my opinion, my lords, I think a writ.
Ultimately, what should happen? There should be some consistency in the orders.
So
If continuously one single judge and the other taking different views, what will happen?
my lords, I bow down to that, my lords.
Then we'll say that we'll refer this to the larger bench.
The only difficult, I'm seeking interim.
Because it can't go on like
Well,
this. There should be some definite.
What I understand, my lords, is that there is a detailed hearing taking place on this coordinate bench, my lords. The appeal bench, I'm told, is hearing it. A colleague of mine, I'm told, is arguing the matter. There may be some finality, but I would only request that it not be deferred till then, my lords, because it's a suit for partition, my lords. That's why I'm pressing, my lords. I understand it may be difficult today, my lords, but we had on Thursday, if possible, my lords. I'm also seeking that a connected writ petition also be tagged along with this, my lords, arising out of the same order.
Along with so and so, right?
Please,
on the paper.
sir.
Yes.
We had on Thursday, if possible, my lords.
Yes.
Cell number 76.
Sir, number could be tagged, madam.
76. Yeah, Madhusudan Rao.
Yes, 77.
77.
Appearing for the petitioner, Your Lordship. Your Lordship, we had served upon the petitioners on the address that they had furnished in the trial court, and we had furnished to the trial court counsel also, Your Lordship. As directed by this honorable court, it is prayed
Where
that
is
that
the memo? Where
Your
is the
Lordship.
memo? Memo.
A memo dated, we have filed it, Your Lordship, before the court on 17th September 2025, Your Lordship.
The registry is directed to put up the memo. List is matter next week. Yes, next. Can look at it, interim order is there extent or else, is 70?
78.
79.
Sir, YD. 77. 78.
Memo is filed seeking conversion of this to a located writ petition. Seeking conversion accordingly. The memo is taken on record and permitted to come for statistical purposes. CRP is disposed of. Yes, 79.
Cell number 79. Cell number 79.
Yes, this also. This is matter in the month of on 25th of August. Interim order is there, extended.
Cell number 80.
Yes, what is this letter? Letter of extension. The coordinate bench of this court by order dated 9/9/2024. Disposed of the matter. Come here. The MFA order is that extension is placed before me. But it says MFA. In MFA number so and so. WP number 39119. But generally it is not coming before the same judge. The WP number, we're seeking extension of time. As this court on 9 September 2024 has passed an order to dispose of the suit as expeditiously as possible, but not later than 1 year. Now, a letter is addressed saying that, stating that why this stay is granted in WP number, which is filed for a speedy disposal. This matter, WP number 39119 of 2025 tomorrow. In a mandamus matter, stay is granted. Tomorrow. Yes.
Cell number 81.
Memo is filed seeking dispensation of notice to R1 68, 70, 77, 79, 102. Same memo is taken on record and notice is dispensed with.
Cell number 82.
My lord, I appear for the petitioner herein, my lord. In serial
Yes.
number 82.1, a memo is filed seeking dispensation of notice to respondent.
I think
my
it's
lord.
filed in 82. It is filed in 82.
82.1, my lord. 82.1. Both are connected.
MMO is for seeking dispensation of notice to respondent.
Respondent, single sole respondent, my lord. And
Respondent, memo
therefore
is
it was
taken
listed for orders. My lord may kindly take it up for admission, my lord, on because
Yes,
28th, my
yes.
lord, this matter is relating to the court fee issue, my lord, refund of court fee issue.
Immediately
Any
it will
date,
come.
my lord, any date.
Immediately once this is, once objections or next stage it will come. Yes, 83.
Please.
83 Kartik B.
Yes, tomorrow. It's 84.
84. Then number 84, SK Mittal.
We have paid the amount as per directive.
Let's, money is received. The memo for calculation I produced, Millets. I filed it on the last occasion. The amount has to be finalized. What I could see from there,
This is matter day after tomorrow as a first matter.
please, Millets.
Yes, next.
Then number 85. Then number 85.
We have the petitioners in this matter, my lords. My lords, the office objections with regard to the personal interest, my lords, which I have clarified in para number 21 of the petition.
What is personal interest? What is the petition about?
Lords, this, my lords, is regard to bike taxi, my lords, operation of bike taxi. My lords, wherein, my lord, me please to recall, last 1 week, my lords, there were few vehicles which were seized by the RTOs, my lords. My lords, wherein they had not followed the order which was passed by the division bench of this court, my lords. Wherein few motor vehicles were should be operated with the yellow board, my lords, is the rules which is.
Who are you?
My lords, I am the petition, my lords, wherein I am the representative of certain society, my lords, union societies.
Then that is a public interest.
No. No, what happens in this matter, my lords, is that I'm affected by that order.
How?
Kind of, that is. It may be taken up tomorrow, my lords, seniors and all. Other matter.
It's tomorrow. Yes,
But in the first one, my lords, at specific time may be mentioned.
No,
Seniors
no,
are engaged.
no special reason for this. Yes, 86.
Well, 86, my lord, you lost my have to day after tomorrow, my lord, because only one objection is the my lord, day after tomorrow.
No. What is this objection?
Well, objection is my lord, certified copy. That is not needed, my lord. The order challenge is my lord, 18/3/2026 passed in the application for my lord, IO for stay. That is certified copy.
Is,
Day after tomorrow.
accepted. Yes, day after tomorrow. S87.
Please, my lord.
Memo is for seeking dispensation of notice to R3 to 11. Same is dispensed with. The petition shall furnish the and summons not taken. Let it be in the list. Why and summons is not taken? Let this matter be in the list.
Then number 88.
But serial number 88, I appeal for respondent number 1. The notice has been awaited.
Respondent number 7, my lord, before the trial court is placed expert, my lord, I kindly dispense the notice to respondent number. I failed, my lord.
Memo and summons served on R1 to R6. You appear for R1 to R6?
No, my lord, I appeal for only respondent number 1 only, is Gaurama.
No, it says Satisha D.
Please,
For
R1 only.
to R6. It says R1 to R6.
Please.
R8, the bank, it's already served. Now who has to be served? R7?
R7, my lord. Before the trial court, my
It
lord.
can be dispensed with?
Dispense, my lord.
Give the memo. Memo
Please,
is for seeking dispensation of notice to R7. Dispense with 89.
Interim order, my
Blood,
lord.
In all
blood
the
in this
matters-
matter, blood time has, blood is there interim order has been granted, blood time may be given. I am ready for addressing the argument. Blood, small matter.
Yes, next, 89.
Then number 89.
Yes, let it be in the list. 90.
Then number 90. Then number 91.
What is that report?
Plus 91, I appeal for the petitioner. The report is, this is a writ petition filed for expeditious disposal. Your lordships have heard the matter. Thereafter, your lordships directed let a report come stating what are the year-wise pendency. This is a suit for partition from the year 2016.
Wait.
I am a senior citizen. Your lordship said, yes. I'm sorry. The report is
Which year is
presumably
the
to see the year-wise pendency.
Which year is the suit?
2016, my lord. 2016, and I'm a senior citizen, my lords. In fact, adjournments are granted 4 months, my lords, each date. This year, the matter has only come in February and July. Only twice the matter has come in the entire year.
Petition is filed seeking a mandamus. It is submitted that both the petitioner and the defendants are senior citizens, and the suit is of the year 2016. Considering the submission of the land counsel of the petition, this court is passed the following order. That petition is disposed of, directing the trial court to dispose of the matter as expeditiously as possible, but not later than 1 year.
My lords,
Yes.
including judgment, my lord.
I said so. I said 1 year.
Yes.
Yes.
Obliged. Yes, yes. Grateful.
What is this memo of complaints? Anyway, let it be in the list. Yes, next.
As per orders of this honorable court, and summons has been served on the trial court advocate.
Land counsel for the petitioner submits that already they have served the notices on the counsel appearing for the respondent before the trial court and filed a memo to that effect. Notice to respondent self-sufficient. Interim order earlier granted is extended.
Interim order it is not granted, my lord. Kindly grant interim order because matter it is posted for cross-examination.
Will come.
Please.
I have to hear it. Let it come. Yes.
My lord, kindly fix any date, my lord.
Let it come next week. Yes, for
Fix
94.
any date, my lord.
I said next week, which I will give the date. 94.
Please. Much obliged.
Aditya Chatterjee.
Appear for the petitioners, my lord. Lords, in this matter, on the last day prior to the interim order being granted, the caveator had been served and they were present and they were heard as well. They undertook to file objections. That's the reason
First respondent, he filed the caveat.
has filed caveat.
If it is filed the caveat, it would have been reflected in this.
It's not been put up. They were served, they were heard. The order will reflect that, my lords.
It is submitted that the caveator is already, has already appeared for the respondent. Registry is asked to put up the note. Case interim order earlier granted is extended. List this matter in the month of September.
I may be permitted to comply with office objection.
Yes, 95.
95 disposed. Cell number 96.
Yes.
Take case.
Let it be in the list.
Cell number 97.
97, I appear for the petitioner.
Notice.
Notice maybe.
Yes.
For respondent,
98, let it be in the list.
petitioner has been instructed to file a affidavit, my lords, in the case.
We'll see. Now I'm not hearing, calling it for any hearing. I want to get rid of some matters from the list. So some that can be removed, I'm removing. Other matters will come in the list.
My lordship, serial number 99.
I have not. Yes, 99.
My lordship, there's an urgency. It may be taken up tomorrow or on Thursday.
It will be there in the list.
My lordship, on the top of the list. Lordship.
Yes, next.
Cell number 100.
100 is my lord, the Supreme Court direction matter, my lord. The 6 months direction has elapsed also, my lord.
Seeing the court, I can't.
I understand.
I can't take up these matters. If I take up these kind of matters, once the entire day will go.
No, my lord, it's actually a short matter. For example, my lord, there are 3 connected petitions. One of them, my lord, is an amendment application. I asked to amend and reduce my suit claim. They file objections and the judge dismisses my application, my lord. I'm reducing my suit claim.
This week list this matter on 19th.
Top of the list, my lord.
Top of the list, then the whole day has gone at 2:30.
It's a short matter, my lord.
2:30.
2:30 also is.
Yes,
request
next.
for 2:30, my lord.
I said so.
Please.
Yes.
101.
What is this 101? You heard along with main matter. What is this? Huh? 101, who appears?
I am for responding.
Yes, let's just matter in the month
Tomorrow.
of September. If
Tomorrow,
give some, give
Very
some.
urgent.
No urgency.
Respondent is very word age person, my lordship. He is suffering from kidney.
What is the order in this?
Actually, my senior has gone to home, my lordship. That's it. Tomorrow, my
Let
lordship.
it be in the list.
Tomorrow, my lordship.
Yes, remaining matters, let it be in
My
the
lord,
list.
in this case, I represent the petitioner. I am seeking striking of the defense on the ground that
No, I'm not hearing any matters. It will be there in the list. Yes.
my lord,
Letter.
tomorrow, let it be at 2:30, my lord.
No urgency for 2:30. Yes, call. Any signatures?
My lord, serial number 46, my lord, one submission, my lord.
All matters will be in the list.
My lord, 46 may be taken up on Monday, my lord.
My lord's kind permission.
My kind permission, serial number 104 is my lord. Day after tomorrow is the trial court matter was.
To a matter. tomorrow as the first matter. Interim order earlier granted extended till tomorrow in the first matter as tomorrow.
Serial number 104 minutes. Plenary hearing.
List number clear ಮಾಡಿದ್ರಿ ಈಗ. Madam. Madam.
Madam, first matter tomorrow or what?
ಇಷ್ಟು ಏನ್ ಮಾಡ್ತಾರೆ?